Ladies and gentlemen, good morning and welcome on the conference Impact COVID-19 on the Justice System. The conference is organized as a part of the project conducted by the University of Silesia, financed by NAWA with the same title. The conference is organized more than 2 years after the start of the COVID-19 pandemic, and therefore it will be an excellent opportunity to analyze how regulations in European countries regarding the functioning of the justice system have changed in the time of COVID-19's pandemic. It is a great pleasure to open this conference. I would like to thank everybody for attending today. Especially, I warmly welcome our partners from program, Professor Wigita Webraite, Professor Irina Izerowa, and our experts, Professor Anna Nylund, Professor Renko van Ree, and also Professor Fernando Gascon-Inhausti, who will join us remotely today. I warmly welcome our partners, International Association of Judges, especially with my friend José Igreja Matos. Thank you so much for joining us today. And also I warmly welcome Duro Sessa, who is a president of European Association of Judges, the branch of International Association of Judges. I also warmly welcome Office for Democratic Institutions and Human Rights, represented by Gennadine Barba. It's nice to have you today. Thank you so much. And last but not least, I would like to also thank you, our Dean, Professor Czesław Martysz. From the bottom of my heart, I thank you, my colleagues, Jakub Płaziuk and Basia Cis. I wouldn't be able to organize this event without your help. Thank you so much. I realize that you don't have an abundance of time, but I would like to thank everybody for attending today in person and online. I hand over to my dear friend, Professor Krystian Markiewicz, head of the University of Silesia Interdisciplinary Center for Judicial Studies, and the president of Association of Polish Judges Justitia, without whose help it wouldn't be possible to organize this event. Thank you so much, Krystian, and the floor is yours.
Dzień dobry. Kasia już
Good morning. Kasia has already said so much that I have almost nothing to add, but I would like to welcome everybody in Katowice. As an inhabitant of Katowice, I hope that you will spend here a pleasant and creative time at the same time. One of the goals of the conference is to ensure the proper functioning of the justice system during extremely difficult times, such as pandemic times. It's important that what is related to the state of emergency and what limits the right to a court does not stay with us one day longer than it's necessary. These are, among others, the tasks of the Interdisciplinary Research Center on the Administration of Justice at the University of Silesia, which I have the honor to be the director of, and which today initiates its international conference activities. I would like to thank you, above all the judges for their participation in the conference, some of whom, as the president of the Justia Polish Judge Association, I have the honor to work with. I warmly welcome once again José Duro Sessa, the president of the EAG, the president of the Supreme Court of Croatia, judges from all over Europe of the Supreme Court, such as Michael Sieberg, the judges from Poland, Professor Weitz, Judge Gudowski, and other judges. I would like to welcome judges from Justia, especially Jula Żółtak, who will be the speaker today. And I'm really happy that for some time only one of the spokesmen, the first spokesman of the Tribunal of Justice, came here. We have Marcin Szpunar today. And I would like to welcome the representatives of Advocacy and the attorneys at law, the President, Mr. Ryszard Ostrowski. I would like to welcome Mr. Bartłomiej Piotrowski. I would like to welcome the Dean of the Advocacy in Częstochowa, Mr. Piotr Figa. Dear ladies and gentlemen, here I would like to thank to Professor Katarzyna Gajda-Roszczynialska for the initiative and coordination of the project. And my sincere thanks for invaluable help to Barbara Cis and Jakub Płaziuk. And finally, I would like to say thank you to Vice Rector of the University of Silesia, Professor Tomasz Pietrzykowski, for the support from the very beginning of this initiative. Thank you very much. I would like to give the floor to Professor. Thank you very much.
Good morning.
Dzień dobry.
This is really a great pleasure for me to welcome you to the University of Silesia on behalf of first of all, the rector of the university, Professor Dr. habilitowany Ryszard Koziołek. He is very sorry that he cannot be with us personally today, but asked me to extend his warmest regards to all participants of this conference, but also on behalf of the whole our academic community and myself. It is not only pleasure, and I'm not only glad, but above all, really impressed how many so distinguished guests have accepted our invitation and attend this conference. I take it as an additional proof, making it proven beyond reasonable doubt, that the research center headed by Professor Markiewicz and Professor Gajda-Roszczynialska is very well prepared to foster serious interdisciplinary international studies on courts, judges, institutions of the justice system and all procedural aspects of the legal system. I hope that when only Professor Markiewicz will finally defend judicial independence and rule of law in Poland as the leader of the Association of Judges Justitia, then as the head of the research center, he will turn this enormous experience and expertise gathered during this time of unheard of crisis, or should I rather say several overlapping crises that happened to the legal systems and judicature in particular, and turn it into the exceptional material for scientific research and inquiries. Knowing the energy of Professor Markiewicz and Professor Gajda-Roszczynialska, I have very little doubt that it will be actually the case, and I regard this event as a step just in that direction. At the moment, please let me also thank all people from our university and other institutions involved in the organizing of this conference for making it possible. To thank all of you for coming to us, attending this conference and visiting our university, and wish you interesting and productive discussions throughout two coming days. Thank you very much.
And I would like to open the first panel. I kindly invite our speakers and moderator also. Okay, the speakers are José Igreja Matos, Durosesa, Gennady Barba, profesor Maciej Szpuner, serdecznie zapraszam, i pani sędzia, pani doktor Urszula Żółta, którą również serdecznie zapraszam do panelu. Czy mamy Ula? Czy my się mieścimy? Czekajcie. Tak, bo nie ma Michała. Dobrze. Okay.
It work? Oh yes, I'm sorry. It didn't work just a moment ago. Okay, so ladies and gentlemen, first of all, good morning to everyone. I was asked for two things by the organizers. First of all, to speak English. Okay, that's relatively easy. The second thing is to keep the time schedule. We are already 15 minutes behind, so I should resign right now and leave, but let's try to make it without further delay. I will be introducing speakers one by one. The panel will be held both in English and in Polish. We start with the English speakers, and I immediately give the floor to José Igreja Matos, as you have already heard, a judge from Portugal and president of the International Association of Judges. José, the floor is yours.
Thank you, thank you. Good morning to you all. Thank you, Greg. Let me take you some seconds only to thank the invitation to both of you, University of Silesia as our host. It's really an honor to be here, and to Professor Markiewicz, my dear friend, and an hero for many of us in Europe as European judges with his commitment to rule of law along with Justitia. I see many familiar faces. I salute you all. As you know, I'm the president of the International Association of Judges, and we think this kind of cooperation with the academic world and with European judiciaries, this crossover in these difficult times that we are living, are essential to our common future, to our values, to the commitment that we all have about rule of law, and particularly, since it's my lecture will be about that, particularly the independence of judicial systems. So I only have 10 to 15 minutes, so I will try to keep to the schedule. Greg will say something if I don't do that. And he's a very tall man, so. So I will begin with my short speech. In the present conference, I will try to deal briefly with the deterioration of judicial independence triggered by the restrictions imposed by the governments in the context of the COVID-19 pandemic. We all know how coronavirus completely affected our lives as individuals and as members of our communities. The best way to describe this disruptive event will be perhaps the parable of the philosopher Byung-Chul Han, on the behavior of the human being with nature analogous to that of a viral expansion. On a trip, Sinbad and his companions came to a small island that looks like a paradise garden. They light a fire and celebrate. And suddenly the island wobbles, the trees fall. The island was the back of a giant fish that had been motionless for so long that sand had accumulated on top of it and trees had grown on it. The heat from the fire on its back is what brings the giant fish out of its sleep. It dives into the depths, and Sinbad, the sailor, like the others, were thrown into the sea. This parable teaches that humanity is fragile, always uncertain, and we all should approach with humility this absolute uncertainty. The fragility was also shown, yet again, regarding the affirmation of judicial independence, a basic requirement for rule of law. Judicial independence is not a vague concept open to whatsoever interpretation. The rulings of the European Court of Justice, the firm jurisprudence of the European Court of Human Rights have densified this crucial concept. Mostly because of Poland, the European Court of Justice is behind an undisputable enrichment of European commitment towards rule of law, a long-established value and basic principle of EU law stated on Article 2 of the treaty. The recent pandemic crisis and the resulting measures dictated by political authorities warn us, once again, to the rising of totalitarian policies based on high levels of control over public and private life, control imposed with reduced, if not inexistent, supervision by the courts. In a large number of countries, regardless of the region involved, the legislative and executive powers act too often as twin brothers. In fact, it could be even stated that frequently the legislative power is like a younger brother, passively obedient to the rules imposed by the dominant big brother. This fact should have imposed an even more demanding responsibility for courts to exercise its functions concurring with the national laws and constitutions. However, only seldom this counterbalance occurred. The concrete examples are abundant. The most impressive ones in the European Union are, for sure, familiar. The so-called illiberal state implemented in Hungary caused long-lasting costs on the national judiciary. The assault on the judicial system in Poland was materialized through the euphemistically labeled judicial reforms. The purpose was quite evident: to annihilate the independence of judges. In a background of overall anxiety vis-à-vis the safeguard of common basic principles enshrined by constitutions and European treaties, the pandemic COVID-19 has intensified these well-founded fears. The temptation, a dystopian one, was too obvious, and the legitimate concerns with public health were used not always as a fitting reason for the imposing of restrictions, particularly in matters like freedom of expression or freedom of movement. Trailing this tendency, several states took advantage of the COVID-19 crisis to undermine the principles and institutions safeguarding the rule of law. One can mention, for example, 3 cases derived from special laws presented by countries of the old continent. Hungary, where the emergency bill granted the government sweeping powers to rule indefinitely by decree, with no effective checks from the other state powers. The amnesty bill passed by the Turkish authorities in order to reduce the overcrowded prison population was planned to exclude from this benefit all the so-called political prisoners, including many judges, prosecutors, and lawyers. Thousands of judges continue to be unfairly persecuted, discriminated, and treated as pariah by Turkish government. The use of lengthy sunset clauses to emergency bills, diminishing for long periods of time the proper control, namely by the judiciary, of any undue constraint on fundamental rights. The initial proposal from the British government indicating a period of 2 years for the coronavirus bill, later amended to introduce a 6-month review by the Parliament, demonstrates how unaware are political authorities, even in consolidated democracies, about the importance of sunset clauses shaped to circumscribe in short periods of time all measures that constrain fundamental rights. According to a Freedom House special report, since the coronavirus outbreak began, the situation on protection of human rights has grown worse in more than 80 countries. Thus constitutes a likely violation of well-established standards proposals like the ones to introduce a widespread mobile phone tracking by the state, Slovakia, to utilize armored vehicles with machine guns to patrol the streets, Albania, to publish online lists of names and addresses of quarantined citizens, Montenegro, to forgive men and women to go out of the house together, rather separately or in alternative days, Panama, or a ban on a dog walking hour, meaning pets could not go outside at all, Serbia. Still today, China is maintaining draconian measures of absolute control, in particular obstructing freedom of movement, and Russia is yet another case of an oppressive regime restricting freedom of expression. As constantly remembered, an emergency bill or other legal measure aiming to contain the spread of coronavirus is obliged in all cases to comply with the principles of rule of law, such as those: necessity, proportionality, democratic scrutiny, legal certainty, reviewability, equal protection of the law, and transparency of information. Those imposed law restrictions must also be time-limited, applied only when the reason for its approval still exists. The pandemic also imposed a large use of the so-called digital justice. Despite many positive aspects, the potential of new technologies to weaken the independence of the judiciary and the essential role of the judges is nevertheless a matter of concern. In this particular, the excessive focus in the definition of quantitative objectives for the assessment of the jurisdictional response to the detriment of the weighting of qualitative criteria must be highlighted. In fact, the effectiveness of justice, the quality of justice, of its exercise depend on a judicial administration that succeeds in reconciling the principles of independence and impartiality with the requirement of efficient management of the courts. For its global dimension, the COVID-19 pandemic challenges decisive values of life in society. And if, in one hand, it has allowed the judiciary to strengthen its technological environment in a way that may become virtuous, on the other, it has posed serious risks to our freedom. For to be free is not merely to cast off one's chains, but to live in a way that respects and enhances the freedom of others. In fact, those who decide, those who are in power, those who are the leaders, can only assume themselves as free if and when they respect and promote the freedom of others, protected by an independent and impartial judiciary. Thank you. Thank you very much.
Thank you very much, Joseph, for keeping the time limits. Thank you for showing us the international dimension of judicial independence, taking us from the oriental climate of Sinbad stories to the sad reality of Central Europe. Now I will give the floor to another friend of Polish judiciary, to Juro Sesa, who is a former president of the Supreme Court of Croatia, former president of Consultative Council of European Judges, and now president of European Association of Judges. Juro, the floor is yours.
Thank you. Good morning, everybody, and really, I'm really flattered to be the part of this conference. I was always a practitioner. I was always working as a judge. I'm not a lecturer, I'm not scientific, but I have a great belief in science, in law science, because it helps judges to understand, to apply, and to properly the laws and the principles which we all have to obey. My topic is speaking about the rule of law and in pandemic times, and I think that the role of judges in this crisis of pandemic and a similar crisis is very important, because we have always to protect the principles of Article 6 of the Convention, and on the other hand to control the acts of other two powers when they are applying extraordinary measures. So when we speak about rule of law, it is not only a vague principle which everybody knows what it is. It has several aspects which are, I think, very important. The first is that everybody should obey the rules which are there by the legislator in way how to act, and that applies not only for the judiciary, it applies to all other parts of the state power. So the lawmaker and the executive, they have a power to take an action, they have a power to change the rules, but they always have to protect, to follow the procedure, and because by following the procedure they are actually protecting the system which they create, and the judges are there to have a power and position to control those acts. So we need independent judges, we need independent judiciary to assess in an objective manner whether the limits of lawful authority have been exceeded. And that is something which we have always to have in mind, and integrity of judges in that respect is of the enormous importance. Without that integrity, I think this task cannot be fulfilled. And speaking of rule of law, there are some other aspects. For example, it has to be protected the lawful expectations of the addressees. The laws should not have the retroactive effect, or only in a very limited circumstances. And it should always act in a benefit of citizens, and the judges should always have that in mind, that they are not there to speak about themselves, which they have to, but only for the interest of the citizens which they serve. Even I hate this expression which has been developed and now is in common use, especially in Council of Europe bodies, and that is the court users. And that makes it that the judges are service, but in some way they are, but not in this consumer point of view, as somebody could understand it. There are many international, of course, documents which are speaking about the rule of law, and if you put them together, especially the wording of European Court of Human Rights, there are principles which are many times repeated, and that is democratic society subscribing the rule of law, democratic society based on the rule of law, and rule of law in a democratic society. So democracy and the rule of law are binded together, and we cannot understand one without another. So there are three principles which the modern Europe is based on. It is respect of human rights, it is pluralistic democracy, and the rule of law. So rule of law is everywhere, let's say. So we have always to have in mind that. And if I can just finish this part with what said Judge Guido Raimondi, the former president of European Court of Human Rights. He said in 2017, opening the judicial year, he said the rule of law is what sets Europe apart. It is one of the achievements of our civilization, a rampart against the tyranny. This is what Europe represents, a part of the world where the rules of the democratic game have been laid down and where compliance with these rules is guaranteed by the constitutional and supreme courts. It is not everywhere so, but this is something which I think we should always think about that, and as judges try to achieve this goal by all means. Speaking and connecting the rule of law and the pandemics, we must admit that it had a big impact on the work of courts and on the protection of human rights and the rule of law. So what is the basic is that in these circumstances the court must continue to provide legal protection, and they must adopt new circumstances and control the acts of the authorities. So what has always to be saved, even whatever procedures are used, whatever new technologies are used, whatever new approaches to the work of courts are introduced in good faith, I believe, we have to have in mind three main principles: that the right to the fair trial before the independent and impartial tribunal should always be there, the right of judicial review on deprivation of liberty, and the right to effective remedy. These are three principles which always have to be protected, and by no circumstances they should not be diminished if we want to keep the principle of rule of law. So there are different examples how the countries in Europe answered these requirements in a pandemic way, in pandemic crisis, which is, I hope, fortunately behind us, but there will be some other crises. So the principles and the procedures we set up now would be for sure used in some other circumstances. So always the balance has to be made among the principles of the fair trial and Article 6 on one side, but also we should never reject or diminish the safety of judges, the safety of parties, safety of the court staff, because we are not, because these, and sometimes it's not easy to find the proper way, and the countries in the pandemic answered to this challenge or the problem in different ways. And there are representatives here from different countries. Perhaps I'm not quite accurate, so I'm not going to explain these examples for the moment. And just to conclude, I think it is much to do, and we have to think about many things, and this conference and others which have been created and held up on this topic show that we are facing something which judiciary was never faced before, and somehow it shows that judiciary was vital and that they somehow managed to answer to these problems, because when you look to the country's reports, the main role of the judges was not so badly behind in these last 2 years. Thank you very much.
Thank you very much, Jura, for showing different aspects of rule of law. I also don't like the expression court users, but I think it shows that the judiciary is not only the third power, but we, the judges, are servants to democratic society. Keeping to the topic of the rule of law, I will now give the floor to Gennady Barba, with whom I had pleasure to work for many years, who is Chief of Rule of Law Unit at ODIHR OSCE, working in Warsaw. Gennady, the floor is yours.
Thank you very much, Greg. Dear colleagues, dear participants, I would like to thank the organizers and personally Ms. Gaida Różinelska for the invitation to participate in the conference and to contribute to the organization of this conference. It's a privilege for me to talk to you. As was said, I'm the Chief of Rule of Law Unit in ODIHR. We are based in Warsaw, in Poland, and we are an autonomous institution of OSCE mandated to assist 57 participating states in the field of election observation, human rights, and the rule of law. Before I go any further, allow me to recognize the very difficult situation in the OSCE region today. I would like to quote the director of ODIHR, Matteo Mecacci, who said, "The military attack by the Russian Federation on Ukraine is arguably the most serious security and humanitarian crisis that the OSCE region has faced in decades. It makes painfully evident the horrors brought by military conflict, the widespread suffering of innocent people, and the denial of human rights guarantees for millions of people. The eruption of this war is also a direct example of how disrespect for human rights, democracy, and rule of law can lead to one of the most serious security crises in the OSCE region. Similarly to the war in Ukraine, the COVID-19 pandemic is another crisis, and it generated multiple challenges for the administration of justice. Now I would like to share with you the main findings and recommendations identified by ODIHR in respect of the functioning of courts during and in the aftermath of the acute phase of the pandemic. These findings come from three main sources. ODIHR report on the situation of COVID pandemic, primer on the functioning of courts, and policy brief on fair trial rights during public health emergencies. These publications we developed in 10 consultation meetings during the last 2 years with around 200 participants and 50 independent experts, including some esteemed colleagues present here today. First set of findings, when it comes to the role of courts in exercising oversight of emergency measures, it was already mentioned by other speakers, and I would like also to emphasize that our states have committed to control the decisions to impose a state of emergency and to ensure that legal guarantees necessary to uphold the rule of law will remain in force during a state of public emergency. International and regional good practice requires parliamentary control and judicial review of the existence and duration of the emergency situation. ODIHR identified that the oversight of emergency-related measures was not adequate at the beginning of the pandemic, given that many parliaments and courts stopped working. In particular, ODIHR identified that core democratic principles and rule of law principles of separation of power and effective remedy were affected during the pandemic, resulting in excessive accumulation of power by the executive. Higher or administrative courts could not review the emergency measures due to lack of competence or deficiencies in the legislation, and this affected the exercise of freedom of assembly or freedom of movement. Another set of findings concerns functioning of courts and access to justice during the pandemic. It was already mentioned international standards and principles which govern the functioning of courts and limitation, but I would like to stop at two United Nations Human Rights Committee General Comments number 29 and 32, which provide guarantees on how restriction of fair trial rights can be undertaken during a state of emergency. Fair trial guarantees have to be respected in full when the courts examine cases related to non-derogable rights. Moreover, the same sources underline that the right to an effective remedy, the fundamental guarantees of a fair trial, such as the competence, independence, and impartiality of the judiciary, and presumption of innocence, should be respected at all times, including during the pandemic. ODIHR assessment found that the pandemic resulted in partial closure of courts and suspension of procedures except in urgent cases. Consequently, individuals faced considerable challenges in access to civil, criminal, and administrative procedures. Access to court in urgent legal matters was problematic, in particular in cases of domestic violence, trafficking in human beings, detention, and torture-related situations. Courts lacked sufficient and clear guidance on how to organize the trials, what cases to prioritize, and how to ensure the safety of trial participants, judges, and court staff. Judicial self-governing bodies and general assemblies of courts also face challenges in decision-making as a result of quarantine. The lesson learned from this finding is that emergency measures relating to courts and judicial procedures need to preserve judicial independence, including in relation to appointment, promotion, and disciplinary procedures of judges. The last set of findings concerns the observance of the right to a fair trial, and here what we found is that courts severely limited the right to public hearing. On many occasions, the information technologies have been used to conduct trials, but the rules on using these technologies were approved in a haphazard manner, sometimes without proper consideration of safeguards, and were not fully supported by the legislation. Even today, in many states, these rules are not compliant with fair trial guarantees. Often the courts failed to provide effective access of the public to remote hearings, and another major challenge was unrestricted and confidential access of lawyers, both physically and using ICT technologies. In conclusion, it is important that the courts continue to operate public health emergency, both in order to ensure effective democratic oversight of the executive and in order to offer access to justice in most urgent cases. States need to develop robust legislation which should clarify how to ensure judicial independence during health emergency and how to ensure safety protocols in courts. Remote and hybrid hearings have become a normality in operation of courts, but more efforts are needed to ensure that the legislation regulating such hearings is compliant with fair trial standards. We in ODIHR, we remain ready and stand by to provide the necessary guidance on all these issues through our publications and through targeted legal advice and revised legislation. Thank you for your attention.
Thank you very much, Gennady, for showing the ODIHR standards and the role of courts. I think, as you mentioned, war in Ukraine, we all have to remember that it was preceded by the total erosion of the judiciary in Russia. So this clearly shows the role of courts. Now, our next speaker is Professor Maciej Szpunar, who keeps a perfect balance of being international speaker and national speaker, as first advocate of the Court of Justice in Luxembourg, and at the same time professor here at the University of Silesia. Maćku, the floor is yours.
Thank you very much, Grzegorz. I'm really honored that you welcomed me today here in my alma mater. Before I proceed to my speech, first of all, I would like to congratulate both to Professor Gajda and to Professor Markiewicz for creation of this center. I remember the initiative which was filed a few months ago. And what you undertake is always successful, and this conference is the best proof of it. So also that you managed to welcome and to invite here such excellent speakers from abroad and also from Poland. Excellent experts. This is the best proof of it. My speech, because as I noticed that the other speakers had about 10 minutes, and here next to my name there is 20 minutes.
O kilku kwestiach. Znaczy, COVID a Trybunał Sprawiedliwości to jest zagadnienie niezwykle szerokie, ale myślę, że po pierwsze Wspomnę o tym, jak na funkcjonowanie Trybunału Sprawiedliwości wpłynął COVID.
Court of Justice, what happened after COVID, how these experiences were used in our activity, in our presence, in the proper reality. And at the end, I would like to tell you about the cases that are being heard in connection with COVID, and these are pending cases. So, of course, I will not tell you my legal viewpoints on it, but I would like to mention to you what do they regard, and maybe for some of you these matters will be interesting. COVID impacted the Court of Justice, and I remember when all started at the beginning of March, we had a meeting of the presidents, and then the possibility of taking some steps was taken into consideration. But in contrary to national courts, which have only local challenges, for the Court of Justice, it was we have participants from 20 both as members and the workers, and our cases are organized for 27 member states who have to come from Cyprus, Malta, Portugal, Finland or Estonia. And I remember that on that day, I think it was the 6th or 7th of March, on Tuesday, the President, the Secretary of the Court of Justice said that we will close the Court of Justice earlier or sooner, but it will be tested if we can function remotely, if our devices, computer devices, can work, and we will check if the mechanisms which we will introduce during closing of this Court of Justice, we will be able to use them later in the future. The first issue was the technical issue. If there was a possibility of remote work when it comes to interpreters, and we have 50% of interpreters. This is a huge number of employees, and this is not a big problem. But the big challenge are the cases, court cases, and hearings, internal meetings, so general meeting, and some judges' meetings. And the closing of the Court of Justice made us cancel all the hearings, and the natural reaction, so that the parties cannot come to Luxembourg, was the mechanism of changing the case hearing in writing. There were the questions in writing made, and they were directed to the parties, and this regarded to all cases at the beginning of the pandemic. And we did it at the beginning. The judge reporters were asked to write questions to the parties, and these questions were sent to the parties, but luckily a curious system of exchange of the pleadings was functioning, so there was no need to rely on the post office. But after some time we noticed that this change of hearings to the questions made in writing, first of all, it prolongs the proceedings, because then we scheduled the hearing 3 or 4 meetings after the general meeting. So after these 3 or 4 meetings, then we could have further works. But sending questions in writing turned out taking much longer time, because first of all you have to formulate the questions. This is one day. Then you have to translate them, depending for whom they are directed. You have to schedule the deadline, at least 2 weeks, depending on how many questions there were. And then the answers also had to be translated into the working language. So then altogether the whole process took 6 weeks. So during the pandemic, we reached the conclusion that when the case is important, it's better to reschedule it for a later date rather than to replace it with questions in writing. Then there was the tendency, very present among the members of the Court of Justice, to limit the number of cases, saying that we are just the court of law and we are not examining the factual matters, and on the basis of the viewpoint of the parties we know everything, so we can proceed on this basis to issue the opinion. And I will come back to this idea about limiting the number of court hearings. Thirdly, we had to allow the parties to participate in remote hearings. That was a big challenge, I know, for all courts of member states, but for us it was so complicated because it's not just a matter of a teleconference about the transfer, about the connection in all member states, but also this is the issue of ensuring proper interpretation. We have 24 official languages. The majority of the court hearings are in the languages, because each member state can have the court case in their own language and has the right for simultaneous interpretation into its own language. And it turned out that the technical possibilities of the members allowed for simultaneous interpretation in only 2 additional languages, later in 3. So there were situations. So if there were more member states or members from other countries, then we gave our consent to the remote participation, but we said that then the party will have to agree that there will be no interpretation to its own native language. So the party will have only 3 languages just to choose, and then she will have to present the arguments only in these 3 languages. And then the representatives of the member states agreed very often to such an option. And now, when the COVID pandemic stopped, or when it started slowly to finish, we had a special meeting of all members of the Court of Justice and or the spokespersons, what we should be doing now. Which experiences should we keep and which should we abandon? When it comes to the remote participation in the hearings, the majority of our members was against it. We reached the conclusion that only in exceptional cases we will agree that the party could participate in the hearing remotely. In exceptional cases, when the flight was cancelled or in some disasters. But then we required a physical presence in Luxembourg, because if the representatives of the member states can go to the sittings of the parliament sittings, then there is no reason that we should treat their presence in Luxembourg in any more liberal way. And finally, we also gave up making the questions in writing to the parties. We reached the conclusion that this mechanism is only possible in situations when the questions are only technical and when they don't require any debates. For each of the states, for the judges, there is a problem that if we formulate a question for the party or for the witness, there is always the necessity to make the questions more precise, and making them in writing makes it almost impossible. Once I wrote a project that if in the first question the party says yes, then I ask such an additional question, and if the party answers in this way, but I was suggesting by this some possible answers. But what if the party doesn't answer in any way that I anticipated? What then? So we came back to these exceptional situations when there was personal participation of the parties. But when it comes to simultaneous interpretation, is it okay now? Yeah, it's okay now. So now I am being heard for the interpreters. There is no longer, the wire is so short, yeah. Now everything is okay. But the only thing that is from this COVID experiences, we noticed that during closing the Court of Justice, this is the last disadvantages for the people who want to sightsee the tribunal, who want to visit and meet the judges. And we decided that then the citizens are privileged from Luxembourg and from the neighboring countries. So, the result of the pandemic is that maybe part of you noticed it, that now we have online transmissions. Sometimes we have the meetings of the Grand Chamber, and we reached the conclusion that we should allow the possibility to see how does the proceedings before a court of justice looks like for the citizens of all member states, and also for introducing special virtual visits when somebody from any place can take part during a virtual tour over the Court of Justice and can in real time talk with the judge or with the person who is showing around. And these are the things when it comes to the very Court of Justice. Maybe one thing at the end. With the view of our regulation of the opinions and the rulings have to be read in public. So even during the highest time of pandemic, the President and I, we had to go every day to the Court of Justice, and we had to pronounce the judgments in person, the judgments and the opinions. And now every Thursday at 9:30, the President reads the judgments of the Court of Justice. The first spokesman reads also. Earlier they were read before the court hearings, but this we decided this prolongs this proceedings unnecessarily. But this reading has a legitimate purpose, because in Strasbourg there is just the ruling on the website, but here it's different. It needs to be read out. And finally, at the end of my presentation, because this is just the second part, because I'm not finishing, I would like to mention to you COVID cases which were filed to the Court of Justice. So the first case is very important. This case regards C1821, and this regards the regulation of the European Payment Order. And in a member state, for the time of the pandemic, there was suspended the deadline for filing appeal measures. And as we know, this regulation for the order of payment, it specifies automatically its deadlines for filing an appeal against this European payment order. And then the party who filed an appeal, then it relied on this national regulation, thinking that this suspension also refers to the European instruments, but this is not so obvious. Many regulations of the European Union referring to the widely scoped cooperation in civil cases autonomically determines the deadlines for it. And we have the opinion of Collins, the expert witness, according to whom the Court of Justice should give the answer that this suspension also has an impact on the deadline that is included in this European regulation for the order of payment. Then we have many proceedings which refer to COVID and the consumer protection. So as you know, in many cases, people there were some parties cancelled, some events, some flights. They were cancelled or postponed, and this is all falls into the regulation of the European Union. As you all know, the regulation on 261/2004 about the delays of flights when we can claim damages when there is a late that exceeds specific time. But there are also some other obligations. For example, if the flight is cancelled even 2 weeks earlier, even if there is no obligation, then the flight company has to offer an alternative flight. And in case C26 involving Ryanair, there was a question if this suspension, if this proposed obligation of offering an alternative flight connection can also refer to not plane connection. Because Ryanair, when the flight was cancelled, it could offer also such connections which were present. Another case, this is a case regarding to tourism services. This is C396 to 9011, and this is a case referring to the cancellation of some trips, and also the fact not just cancelling the trips, but if the travel agency can be liable for lowering the standard of provided services, if it turns out that over there in hotel, 90% of the attractions normally available due to COVID are unavailable. We know that the former judgments was very strict in this reference. So, for example, when it comes to the standard of the provided services, so if the fact of COVID can be a justification for limitation of the liability, if the essential element of the provided services is not available. A similar case is a case, French case. This is a case that also refers to the cancelling of the services. And this case is interesting insofar that the questions of the National Court, of course, they refer to the possible limitation or exclusion of liability. But in the questions, the referring court presented what was the state of affairs of the tourism sector, and it was that they lost 80% of the income, and this is a sector which employs 3,000 people in a given place. So it shows Court of Justice, be careful when you give the answer to this question, because this is a very potential, and it will involve many consequences, and we really appreciate these questions. When the national courts ask us not only about the legal grounds, but they also show us the context, the wider context, when we would give a specific answer. And the final question, the final case, now the case which is pending, because I am the expert in this case, and this is about vaccination. So this is a case 765/21. This is an Italian case, and this is an obligation of vaccination for the workers of medical services. And this is not the case of the very obligation, but about the wording of the regulation 507, which allows to issue a temporary agreement to introduce a medical agent. And now we will have to deal how quickly such a project of authorization of these medical products was justified in this case, and if it was consistent with specific European regulations. This is all on my behalf. Thank you very much, Grzegorz. And now I'm waiting for the discussion.
Dziękuję bardzo. Thank you very much. I think it's really interesting to hear the practical aspects of functioning of the Court of Justice related to COVID-19 pandemia. You've mentioned it's the end. I just wonder whether it's the beginning of the end or just the end of the beginning of pandemia, but this is something that time will show. So we've heard about Court of Justice, and now we will hear about the functioning of the European Court of Human Rights. Unfortunately, the speaker couldn't be with us, Professor Michał Balcerzak, who is a well-known specialist in human rights field from Toruń University. I hope he is here with us online. Let us see. We can see you, but we cannot hear you yet. Yeah, for the last 2 years, everyone opens the speech, "Can you hear me?" it seems there's a dilemma. Either it's the audience or the interpreters. A będzie?
Tłumacze mnie słyszą, tak?
Teraz słychać. Now we can hear the speaker, yes. Jest jakieś spięcie, jakieś sprzężenie, natomiast słychać szanownego mówcę.
Dzień dobry Państwu.
Hello everyone, hello ladies and gentlemen.
Akurat teraz wszyscy słyszą coś w tłumaczu, także
Everybody here is through the interpreter actually.
Tak, dzień dobry.
Hello everyone. Can you
Proszę o
hear
sygnał, czy mogę
me?
zacząć?
Give me a signal when I can start.
to jeszcze nie jest ten sygnał.
It's not the right signal yet. Unfortunately, soon we'll have it.
Czyli teraz już powinno być dobrze. So, the floor is yours. Chyba nas nie słyszy. Czy nas słychać?
Hear us.
Ja słyszę Panią tłumaczkę.
To może zamienimy speakerów i teraz pani sędzia zrobi prezentację, a w międzyczasie się uporamy z problemem technicznym. Tylko, że Ula ma prezentację w PowerPoincie, więc to też wymaga. No właśnie. A skąd? A. Okay, so okay, so what we do now is we switch the speakers. So now I will give the floor to Judge Dr. Urszula Żółtak, representing Justitia Judicial Association, and we will hear about the functioning of courts in Poland during the pandemic. Whenever you're ready. I knew that keeping the time limits is mission impossible, but now it's
Prezentacji.
To jeśli Państwo tłumacze mogą przekazać Panu Profesorowi, bo mnie nie słychać, a Państwa słychać, że zmieniamy kolejność mówców i spróbujemy się uporać z problemami technicznymi w międzyczasie.
W PDF-ie nie zapisuje. A możemy zobaczyć. Tylko w PowerPoincie. To jest...
Okay, so I guess now we can start with our next speaker. The technical issues seem to be solved already. Well, the floor is yours.
Thank you, Gray. First of all, I would like to thank the organizers for invitation, particularly Professor Krystian Markiewicz and Professor Katarzyna Gajanda-Roszczynialska. Bardzo dziękuję, panie profesorze, bardzo dziękuję, pani profesor. It's a pleasure for me and honor to be here with such excellent participants. In the first part of my speech, I will briefly describe the law adopted during the pandemic.
Recording stopped. Recording in progress.
What does it mean?
It's the Russians.
Okay. And in the second part of my speech, I will briefly discuss its practical application and effectiveness from the from the practical point. So the COVID-19 pandemic brought chaos to the courts and demonstrated their anachronistic functioning and lack of investments for many years. The problem became the funding, the balance between right to courts and the demands of the pandemic. In this time, number of changes were introduced to adapt operation of the courts to the new reality. Judges were successively amendment to the law, initially restricted in their ability to adjudicate at hearings and then directed to adjudicate at hearing remotely. The special anti-COVID law enacted a special solution related to the prevention, counter-reaction and eradication of COVID-19, other infection diseases and crisis situation caused by them, so-called the Anti-Crisis Shield Zero, was enacted on March the 2nd, 2020. It contained a package of solutions to protect society against the crisis caused by the coronavirus pandemic. This law did not contain any specific regulations regarding the functioning of courts. During this time...
Wie pan co, możemy później, bo muszę wyjść teraz do prezesa, dobra?
During this time, court's president and also individual judges issued eternal orders and postponed cases or taking the cases off the dockets. due to the lack of condition for conducting a hearing in safety. On the 31st March 2020, the Polish Parliament introduced amendment to this law that applied the rules concerning the functioning of the courts, so-called Anti-Crisis Shield 1.0. According to the new law, specified procedure in the case of complete cessation of court operation was introduced, and catalogue of urgent cases was defined. The president of the courts could order any case to be heard as urgent if its non-determination could result in a danger of human or animal life or health, serious harm on public interest, or because of a threat of imperative or material harm. The new regulation suspended the deadlines in civil proceeding. At that time, apart from urgent cases, the courts did not conduct any ones. On the 16th of May 2020, Parliament amendment provision on functioning the court during pandemic. It was Anti-Crisis Shield 3.0. By this amendment, repealed the provision concerning the suspension deadline in proceeding. The deadlines begin to run or continue to run. The most amendments of the aforementioned Act introduced significant deviation in the previous course of civil proceeding, remote hearings, and conduct the proceeding behind closed door instead of the public hearings to a great extent than before. By amendment effective from the 3rd July 2021 was introduced further changes in the civil procedure. Remote hearing and non-public hearing became the main form of civil court proceeding. Remote hearing was mandatory. Such a solution was introduced for a duration of the state of epidemic emergency and within 1 year after it's revoked. During the pandemic, the Minister of Justice issued a number of guidelines, a recommendation regarding the principles of maintaining safety in the courts, mainly during the hearing. Some of them were intention, but they didn't work. The main new developments implemented during the pandemic were remote hearing and non-public hearing. Remote hearing that means hearing held remotely at a distance with direct transmission of images and sound. Before this amendment came to force, remote hearings could be organized only by a way to a legal aid when the questioned person was in the building of another court. While thanks to this change, the person questioned could be anywhere. Such a solution concerning remote hearing were limited to civil cases only. Non-public hearing. This solution provided the possibility of issuing judgment on our decision ending the proceeding in a closed-door session to a great extent than ever before. Until this amendment came into force, a civil court could only end the case with a judgment rendered to a public hearing, except for a default judgment issued in case of the defendant's inactivity. Remote working. It was recommended but not implemented due to lack of special tools. I mean, electronic files didn't exist in Polish courts. There was no digitalization at all. Other solution, the most innovative at the same time and the most objectionable, was the remote trial. Conducting a remote hearing requires several conditions to be met from the perspective of judge's duty or ability of a courtroom. It's not obvious. There are several courts, mainly district courts in Poland, that not fulfill basic conditions for public buildings. Courtroom that could be used for remote hearing was limited. For example, in my court, which is one of the largest court in Poland, initially there was only one room for the department allowing remote hearing. It also needed access to remote hearing application. Courts were used numbers of publicly available social contact application not suitable for many numbers of participants. And obtaining contact details of participant, email address and phone numbers. The provision of phone numbers and email address by professional attorneys is obligatory and take place in the first pleading. By other parties as witnesses is not mandatory. The court may request that they were provided, but there are no sanctions to failure to do so. Requirements of a remote trial from the perspective of a witness duty are internet access and computer equipment and providing court with the contact details. The new solution introduced at a later stage was the possibility of questioning a party or witness who does not have internet access in a separate room at the court building. It meant that such a person was obliged to come to the court, but was questioned not in a courtroom, but stay in a separate room and was contacted with the court remotely. This solution was introduced on July 2021, so after 1.5 years after pandemic starts. There are some technical problems of remote hearing. Working in a court is based on outdated and rarely updated information systems. Too long time of a remote hearing in comparison with a standard hearing because of technical problem happens. Many information systems used in courts are not adapted to the large number of participants. Some participants in the proceeding do not have a computer or internet access or have a low quality computers equipment or slow speed internet access. Very often judge must teach participants to use the application during the hearing, and very often hearings were delayed or postponed by technical reasons. There are of course also legal problems. Limited access for public. It's rare happen when the person who is not a party of the trial wishes to participate in it as an audience, but it's the right and it's the main condition of the fair trial. But the participation of the public in a remote hearing has been difficult for the technical reasons. On the other hand, public participation in normal hearing during pandemic has often been impossible due to the size of the courtroom and the obligation to keep social distance. The most recommendations of the Ministry of Justice were impossible to implement in practice. Social distancing in court or courtrooms were simply impossible. And the other problem was protection of personal data of person questioned. The court is required to verify the identity of the person giving testimony. During the verification of the identity from ID, the data might not be disclosed to an unauthorized person. The other problem was correctness of verification of the identity of a person questioned and verification of the condition for giving testimony. There are, of course, some practical problem on the other, on this new developments. The remote working, the modern remote working of judges was impossible due to the lack of remote access to the court files. We have no electronic files at all. The legal problem and other developments were doubts of with the compliance of the new regulation with the standards of the right to a court. Consider the issue of nature of trial. The public trial is a fair trial. The right to a court means that right to be heard by judge. The pandemic slightly reduced social activity, including interest in litigation. During the pandemic period, nearly 200,000 fewer cases were filed in civil courts in 2020 than in 2019. The inflow of cases to civil courts was controlled, as many cases were handled as were received in the year's data, but almost 180,000 fewer cases were handled than in 2019. This information has been overused by our Ministry of Justice to show that reforms are working. In the previous years, there was dramatic increase of civil cases in the courts. This resulted in a significant workload for judges and later lengthened proceeding. Between the 2017 and 2020, the length of proceeding increased dramatically. During the period 2015-2020, the duration of civil court proceeding increased by about 44%. So, pandemic demonstrated that law imposed obligation without the possibility of implementing them. Revealed the organizational problem of the introduced remote working and remote hearing solution. There were technical problems with remote hearing, which often made them ineffective. There was a problem also with compatibility with the right to a court of the proposed solution. The pandemic also covered up many of the court's organizational problems. It provided a convenient excuse to hide the long-standing unresolved problems of the judiciary. And also, the pandemic demonstrated lack of investment in courts for many years. A bitter reflection in closing that when the Law and Justice Party reigned the power, it was spent about 1 million Polish zloty for billboard campaign against judges. And now Poland is obliged to pay 1 million euro per day because failing to comply with the CGEU interim measure relating to disciplinary procedure against judges. Today, the fine imposed on Poland is 204 million zlotych. If Minister of Justice invested such a money in Polish courts, probably we would have the most modern courts in the world. And at the end, I would like to recommend reports prepared by Polish Judges Association Justitia. The first one is based on the survey of judges. It contains a number of recommendations also concerning technical aspects of court functioning. The other one is on efficiency of court proceeding. It fills an information a gap on important statistical indicators for district courts. Thank you very much for your attention.
Thank you very much for covering the functioning of courts. Okay, so I have a signal from the organizers that Professor Balcerzak's speech will be postponed after the technical problems will be solved. We are very sorry for the technical problems, but this is like the, let's say, sins of the youth, since this is the first conference organized by the Interdisciplinary Center for Judicial Studies. So I am very happy to announce that we are right on time to start a coffee break. And as a coffee addict, I know that postponing coffee break is degrading and inhuman treatment. I would like to thank all the speakers for their brilliant speeches. Thank you very, very much.
Please sit. Ladies and gentlemen, dear colleagues, welcome to the second panel of our conference. My name is Robert Kulski, and I'm honored to moderate this panel dedicated to impact of the COVID-19 pandemic on the civil proceedings, systematic changes. This panel consists of two parts. The first one deals with changes in the system of civil procedural law introduced by COVID-19 pandemic. The second one focuses on digitalization of civil proceedings. In the first part, two presentations will be held. As the first speaker, I would like to invite Professor Anna Nylund from Faculty of Law from University of Bergen from Norway. Dear Professor, the floor is yours.
Thank you. I'm very honored to be here today and to have been invited here to speak with these wonderful Polish colleagues and also international colleagues from across Europe. And actually, this is my first trip outside the Nordics after the pandemic. And today I will talk about systemic changes to the civil procedure system, very much based on a book that I authored during the first year of the pandemic, together with my colleague, Professor Bart Kranz from the University of Leiden. And next slide, please. I will talk about four topics. So first, what I mean by systemic changes, and then we'll look at three types of systemic changes. That's preparedness, so how we are prepared for a crisis, and then look at the format and structure of civil proceedings, and then I say a few words about openness, well knowing that there will be a special panel on that afterwards. Let's say, there. So, as mentioned then, systemic changes are shifts in the fundamental concepts and ideas that the system, the civil justice system, is based on. And it includes organizational changes, transformation of how work is organized. And a systemic change brings us into a new era. And change can be very deceptive because digitization feels often like a systemic change, but actually what we witnessed so far during hearings to doing the very same thing remotely. But of course these are only on the short term, because like the first cars, they look very much like horse carriages. And now a horse carriage and a car look very different. And these changes take a long time. And we know, for instance, that Zoom fatigue, which is a really real phenomenon confirmed by neurological and psychological research, shows that we might want to change our hearings because online hearings are fatiguing. And this could probably then lead to a change in the functions and timing of court hearings, in their content and dramaturgy. But we are not there yet. And crises tend to spur changes, to alter the course of history. And therefore we should not waste a good crisis. And now we have the second crisis going on consecutively, back to back in Europe. But of course, changes do not happen during the crisis often, because everybody is so busy coping with what they need to do. And rather they happen in the aftermath of the crisis. And this is the period that we have entered into. I think we're in a sort of, hopefully, I think, in a post-COVID era. So probably the digital revolution is still ahead of us. And these changes, they can be like a landslide, a sudden change, or like slow erosion that slowly changes the system, or a series of consecutive smaller landslides. And in my opinion, we now stand at a crossroads where we could actively and critically reassess our civil procedure, and in light of the experiences that we have had, or then, of course, we could resist the changes, or then we could somehow uncritically embrace the changes. And I think in this regard, countries that have made a larger digital leap have an advantage because they're more advanced in this process. And then for preparedness, I think most civil justice systems were definitely unprepared. And one exception is Japan, a country that's used to earthquakes and had the SARS pandemic, because they had these business continuance plans. And I think the war in Ukraine shows that you really have to be prepared, because this corona crisis, it was sheltering at home and going online, whereas the war in Ukraine is fleeing your home and going perhaps partly back to pen and paper. And countries like Norway, we have closed roads every winter due to heavy snowfall. Germany, for instance, had flooding last year. So we know these crises are coming, and therefore recently, only this spring, did we have new provisions in the Norwegian Civil Procedure Act that actually makes it more flexible regarding remote proceedings. So even in a normal situation. And at the start of a crisis, these business continuance plans helps courts to function because they have ideas of how to retain the minimum functions. And in parallel, courts should then start preparing for how to function in this prolonged emergency situation and how to maintain and resume their functions. So we need a dual focus then on maintaining and then resuming functions. And knowing which cases to prioritize is very important. Otherwise, you might start haphazardly treating cases or very big differences among courts. And these could be identified in these business continuance plans. And the other thing is that during the pandemic, we have seen innovations, but the problem has been that innovations as such do not suffice unless we have a way of proliferating these innovations, of judges sharing experiences. So we should prepare for how judges can continue to share experiences in a crisis. And also, I think the coronavirus has shown that we also perhaps need to rethink how work is divided among judges, because there might be judges who have health situation considerations or care obligations that need to be taken care of. So we need to be prepared. And then to the format of the proceedings. And when we did this study, what was really interesting, because I think we can see that, of course, there are huge differences in Europe regarding the balance between oral and written proceedings before the pandemic. But now we have even seen a greater divide, that countries that had more written elements have now even more written elements, and countries, jurisdictions that have more oral elements have retained much of those oral elements in their proceedings. What explains this gap? I mean, intuitively, it seems to me somehow contra-intuitive, because one would think that there would be more leeway to go to written proceedings in oral countries, and then that those countries with written proceedings would have to retain the orality to be able to, for instance, then comply with fair trial requirements. And one thing is evidence, for instance, that explains this. And how much evidence is needed and what kind, how is this evidence given. So in Norway, parties usually present excessive amounts of oral evidence, and there would be a need to cut down on the time spent hearing this evidence. Yet in this kind of context, it's unthinkable to have purely written proceedings. And for change to happen, it would have to be gradual, and 2 years of a pandemic is definitely too short to change the mindset of judges. So in a way, we could say more pandemic would be good to produce real change. And then, of course, if you are used to having written witness statements, then or witness statements that are recorded, and then the court decides the evidence based on written statements, then going to fully written proceedings seems to be a thinkable and actually an option that's very close to what you have done previously. And we could also look at how the structure of proceedings influences how countries can adapt. And one thing is, if you have a main hearing model of civil proceedings, then the main hearing is the apex of civil proceedings, where you present your evidence and your legal and factual arguments and your and so forth, and then replacing the main hearing entirely becomes almost again unthinkable. Whereas if you have a more piecemeal style, more written style, it's easier, perhaps in a mindset, to actually then limit orality or remove it altogether. So this probably could explain why we see this greater divide. Then talking about main hearing model countries, there we have case management or preparatory hearings, and these are short and of a limited scope, and thus more susceptible to being conducted remotely, because only a few persons are present and the duration is shorter. And these hearings will probably never go back to an in-person format, at least in many countries. And this then brings us to the question, will this have implications in the long run for how we conceive hearings, that they will become of a more limited scope and duration in many countries? And will we go, in particular small cases, only to remote hearings, or maybe some mixture, so we would have hybrid hearings, just to cut cost and expedite proceedings? And I think this has brought me to think that what do we actually mean by a hearing, and how do we conceptualize hearings, their functions, their contents, their dramaturgy in different European legal cultures. And perhaps we see much more differences than at least I had expected. And maybe we will go to the style of proceedings that we see in the European Court of Justice, that you have more question and answer rather than presenting your full arguments in those countries where you have this main hearing model. And then we should also ask whether the type of hearings should depend on whether parties are self-represented or not. And some have advocated that in small case proceedings where we have self-represented parties, we should perhaps leave the idea of a concentrated hearing and go to a piecemeal structure that would allow the judge to iterate and reiterate instructions. And we could also ask whether ADR hearings can replace some court hearings, and what their function in the system is. Is it sufficient to see and talk to your judge during, or a mediator during an ADR hearing, and that would then, at least to some extent, abolish the hearing of the need of a regular hearing. And also the written communication, we still communicate with the court as if we were using typewriters. So we could ask, why can't the parties be required to work in a single joint document, or at least update documents rather than filing separate documents, so you cannot easily know how arguments and claims have been amended? And we could also ask, we have all these Teams and Word and SharePoint, but why don't courts actually mimic their functions? And I think this is a crossroad where we could really think what are the uses and how could and abuses of digital proceedings, and how can we fit our proceedings to a world with lots of small claims, an increasingly complex legal system, yet diminishing legal aid, and actually create a system for the 21st century that's accessible, yet delivers quality justice, that combines oral and written, synchronous and asynchronous elements and new technologies. And they should be based on the recent insights on cognitive, emotional, and social processes in courtrooms and beyond, so that we could create a system that actually delivers justice to citizens. And then a few words, nearing the end, on openness, and I think we have also to rethink openness. Why do we have it? Is it to instill trust? Is it to measure accountability and transparency and quality of the judicial system? And how do we actually measure quality? What is quality? And do the data we use now, are they just weak proxies, or do they actually measure quality? And how can we optimize cost and efficiency and quality? And openness is also being transparent to the parties, to be able to present your arguments. How can we do this in a complex world with many self-represented parties? But also to able to be rebut any claims and arguments supporting those claims, and how can you get well-reasoned rulings that can be scrutinized. And also to think how openness can be counterproductive if it's the wrong kind of openness. Courts in Norway have now, they started streaming early on, but the seats are limited, so you have to sign up. And particularly for lower courts, that makes sense, because a courtroom, even though it's open, it's an intimate scene. It's like being in a black box theater or chamber concert, right? But if you stream it and it's widely available, it could become like a stadium concert where you perform for everybody and you don't know who puts it online later on for recording or and so forth. And then witnesses could start to perform for the audiences outside the courtroom rather than focusing on the courtroom and what's happened there and their role in it. And also these kind of case management systems, the electronic ones, they haven't really been designed for openness. So we still have a system that's based on access to the courtrooms. And in Norway, we have discussed whether all judgments should be published online. But the answer was no, because unless you have research tools that are appropriate, you will just get a million hits or thousands, and you will not know which case matters. And of course, this is very different than for Supreme and higher court cases. But we still need to know how to use the new technology to produce justice. And to come to an end then, systemic changes, I think at this time, are very necessary, but they're slow. And countries that have switched to new technology have an advantage, have a head start in this, because I think in due time we will see changes. And the systemic changes, I think they will be disruptive, they will be arduous, they will be uncomfortable, but sometimes disruption is the prerequisite for real renewal. And we should not waste this opportunity, but we should embrace it and know that we have some rough waters ahead of us, moving to a digital world and a new structure, probably, of civil proceedings, and to a time when we have to rethink many of the concepts. But I think we will emerge, if we're diligent, in a better new normal. And I think these kinds of events are important because they help us bring a step forward in that process of understanding the richness and the diversity that there is in proceedings, and then also see new opportunities for how to develop our systems. So thank you very much for your attention.
Thank you very much for the interesting presentation and keeping the time limit. And now I would like to invite Professor Andrzej Jakubecki from the Faculty of Law and Administration of Maria Curie Skłodowska University from Lublin, from Poland. Dear Professor, the floor is yours.
Thank you very much. Am I being heard? Yeah? Okay. In the first place, let me congratulate Professor Katarzyna Gajda-Szczeniawska as well as Professor Christian Markiewicz for the heavy load they have taken to make this thing happen here and make us happy that we can attend it. In the second place, I'd like to express my gratitude that I'm here. Thank you for invitation. And I hope that some remarks on Polish legal regulations on COVID-19 as possible, very short, hope so, to introduce mainly foreigners, because all the colleagues from Poland, of course, know this regulation. From now on, I'm going to speak Polish.
Thank you very much for the invitation. Maybe I will explain why I am here, not there. In the past, one of my older colleagues said that a good speaker should be characterized by the following elements. First of all, he should be able to talk while standing. Secondly, he should be speaking without using any pieces of paper. And then he should be telling jokes. And today, because of the time limit, I will not tell any jokes. But not to prolong anymore, there are the notes that I will be using. And then you will be able to see them on your screen. I will start that the Polish government, when it comes to the legal matters, observed the issues connected with COVID-19 in March 2020. When the pandemic started earlier, so in the early months of 2020, there were some symptoms of this phenomena. And the legislator didn't decide, as many expected, to introduce the regulations, statutory regulations like the state of emergency, but approached this problem on the basis of legal acts of lower rank. These were the regulation of the Ministry of Health. At present, we can talk about the third regulation that regards these topics. The first regulation was the introduction of the state of epidemic risk. A few days later, it was later transformed into the state of an epidemic. And 2 weeks ago, it was then the state of epidemic was revoked, and then there was the restoration of the state of epidemic risk. Why am I talking about this? Because the Polish regulations, which refer to the civil procedure during the pandemic, they connect this time of binding with the time of when this pandemic takes place, or when there is the risk of the pandemic, and they prolong it 1 year from the revocation of one of these states. And when it comes to the regulations, which were prepared for the state of pandemic, As Judge Żółtak mentioned before, these regulations with such long titles that even the authors cannot repeat and cannot remember the titles of them. So they use some names like shield number 1, shield number 0, shield to the shield, and then amendments with the shields. And I will also not quote you the specific names of these regulations, which these shields include. But it's worth mentioning that the first issue that our legislator had to face with was the functioning of the courts during pandemic. This is the regulation which you can see on the screen. Maybe its content is not the most important. It provided what can happen if, first of all, the court, the common court or the military court ceased totally its operation. And the second situation, what happens if all common courts or military courts on the area of one appeal stop functioning. And these regulations, as you can see on the screen, they are no longer valid, but they were moved, transferred to other regulations. So their idea was kept. And as I think, this regulation was the first thought, which was the answer to the first thought of the legislator. What will happen if the courts stop functioning? The problem was real, and I remember really well that we considered if in a given state of affairs, which we had at the beginning of 2020, if there shouldn't be application of Article 173 of the Code of Civil Procedure, which provides suspension of civil proceedings because of the cessation of the actions of the court. So this is suspension of the courts on the basis of the law. As I know, despite of the doubts, despite of analyses, this situation didn't happen in Poland. It didn't happen in Poland that a court stopped functioning at all. But when it comes to the regulations, which more refer to the civil procedure, they appeared 1 year after the announcement about the introduction of the state of the pandemic risk. The next regulation here you have, and in the scope of this regulation, some regulations were introduced regarding some remote sittings. In Polish, we call it off-site sittings. I don't know how can you say it in English. Dislocated, relocated, or something similar. And secondly, there was adjudication in a closed session during a pandemic. Thirdly, trial, examining the cases by a single judge, both in the courts of the first and second instance. Then the issue of electronic delivery. Next, the party's professional representatives should indicate additional information, especially their email addresses and telephone numbers to contact. And finally, the witness participation in a remote court session. Some of these regulations they raise fundamental objections from the point of view of, first of all, principles of due legislation, secondly, compliance with standards arising from the European law and the Polish constitution, as well as, finally, the principles of civil procedure. It's worth to emphasize that these regulations were not introduced into the basic code which regulates the civil proceedings, which is the Code of Civil Procedure, but they were included in a separate regulation. So it hopes that maybe these are just episodic, temporary regulations. But in the literature, there are expressed doubts that some of the regulations introduced only for COVID is just testing what can be left permanently, but not drawing the conclusions which will result from the analysis, some of the ideas were kindly accepted and accepted by science. But the problem is about very poor, bad legislation, but this is another issue. Today we already heard about remote court hearings, dislocated hearings. The judge talked about it, so maybe I will skip the details, but I would like to draw your attention that the Polish regulation regarding the dislocated hearings in the civil law appeared much earlier before the start of the pandemic. In Article 151 of the Code of Civil Procedure, we have a paragraph number 2, which results that the chairman, the presiding judge, may order a public hearing to be conducted using technical devices that allow the hearing to be conducted remotely. And this enigmatic sentence was then added that in this case, the litigants may attend the court session while they are in the building of another court and perform procedural acts there, and the procedural acts shall be transmitted from the courtroom of the court conducting the proceedings to the location of the litigants, and from the location of the litigants to the courtroom of the court conducting the proceedings. So the idea was that everything is happening in the court buildings, but in different buildings. This regulation was not adequate to the challenges presented by COVID-19. But we should notice, I didn't examine this, but I based on the publication, that until the start of the pandemic, Article 15 was in practically never used. So never it was decided that there should be a remote hearing, which shows that the practice doesn't like such solutions. And this is not about this not liking it by the judge, but this is about these technical problems, which then later we can discuss about. The problem which appeared, and it still appears on the basis of Article 15, paragraph 2 of the Code of Civil Procedure, solves the anti-COVID regulation, because first of all there is the regulation which allows to have the remote hearing, dislocated hearing, where the parties or the representatives don't need to be in the building of another court, or they can even be in their own home. This is one important issue. Secondly, the judges of the panel don't need to be together in one building, but they can also participate in the hearings in different places. The last issue, the legislator solved it in any other way, then introduced the single judge compositions, which when it comes to examining the courts of the cases of first instance, then this was not a problem. And later, when it comes to the regulations, that there is the possibility of waiving the remote meeting in favor of trial or public hearing conducted in accordance with general rules, so in the building of the court. And the premises which result from it is that the recognition of the case at public hearing is necessary, and the conduct in the court building will not pose an undue risk to the health of those participating. And here I can just say that I'm really interested in the criteria which will allow to judge if there is the risk for the health of participants who take part in according to the classical rules. And here we have to face the possibility when the hearing, the remote hearing, can can be revoked in favor of, maybe this is not a proper word, in favor of a closed hearing. Because as the anti-COVID regulations show, the presiding judge may order a closed hearing when a remote session cannot be held. And so here I understand the technical problems don't allow it, and the hearing or public hearing is not necessary. And here again, the criteria. So it is not necessary to conduct the public hearing. This is so enigmatic that they give the right to voluntarily judge if the session should take place publicly or it should be a closed session. And here I would like to mention the question that there was excluded the possibility of planning this non-public institution in appeal matters, and this is just prolongation of the authorities to another instance. And here just a short summary. The openness of the proceedings, this is the rule which is enshrined in international law and in the Polish constitution and in the Polish Code of Civil Procedures. And here we have to emphasize that the right to open proceedings, this is not the right to the proceedings of closed sessions, that this is the constitutional law of human freedoms, and it has a reflection of some restrictions of and openness of a court proceedings. This is an important element of the right of the court. That this is one of the guarantee of judicial independence. This is the guarantee of impartiality and transparency, guarantee of building public confidence in the court and in the justice system, and it protects the judges from the suspicion and allegation against that they are independent, and it protects them from the corruption allegations. And the judge mentioned some problems connected with remote proceedings, remote meetings. So I will not come back to this. Maybe during the discussion, these issues will appear once again. So to sum up, the remote sessions were generally met with favorable reception in practice and doctrine. So this step forward, which we didn't do on the basis of Article 151 of the basis of the Code of Civil Procedure, that here it was implemented, and I hope that here the barriers were crossed. But what is the problem about? The problem is that this regulation is residual, and this is clearly insufficient. There are no implementing regulations. There is also no digital platform for securely conducting a remote meeting. So in practice, as I know, we use available platforms such as MS Teams, Zoom, Skype, or WhatsApp. And this is not sufficient. And the judge mentioned the problems associated with remote meetings, of the verifying the parties, and the access of the audience, and I will skip this. And the next point is that we can summarize just with a shrug of shoulders. This COVID regulation provides that in the situation when in case heard in accordance with the provision of the Code of Civil Procedure, so on the general rules, the evidentiary proceedings have been conducted in its entirety. The court may close the hearing and make a ruling in a closed session after taking the written position, the viewpoints from the parties or participants in writing in the proceedings. The written positions of the parties or participants are a substitute for the parties of the closing statements. But these regulations are not equivalent, because these positions in writing means that it's just a replicate, so the parties cannot present their own position. And in this situation, there is a non-excludable allegation of the privation of opportunity, that there can be the allegation that there was the party's right was infringed, its right to defense was infringed. So it leads to the nullity of the proceedings. And then we have some other doubts. Why does the trial close the court and not the presiding judge? Because according to the Polish law, the presiding judge closes the case, but this is just the legislator's secret. Should the party's position be received before or after the close of the hearing? Should the written positions also be received from the collateral interveners? Should the written positions met the requirements for proceedings? And there are some other issues, lots of issues. And the next issue, whose fulfillment is really doubtful, is this problem of electronic delivery. I know this is a separate panel, so I will not talk too much about it, but I would like to say that as far as the idea is good, and we can say that we can express our regret that still now we are not able to prepare a good system which would allow this electronic communication with court. So this was supposed to be called the Electronic Delivery Office, but at some moment the works on it were stopped. And what we have today and what we call this electronic delivery, this is just the use of using the IT portal of the functioning of the system, which has a totally different aim. This portal was not supposed to be used for delivery. This was supposed to post information about cases. And at present, this is used for handing over deliveries. And there is a special bookmark, My Deliveries. And if you click there and if you open it, then it has the effects of delivery. And the same as the electronic submission delivery, if you just open on the website, the pleadings are all downloaded to the computer. And if you don't click on the right time and if you don't accept it, so then this effect takes place within 14 days. The idea is good, but there is... So just to add, these IT portals are only unified in appeal cases, and there is no unified system within the whole country, which causes some disputes. And I asked Professor Gader-Szczenialska, so if this ruling is placed in this portal, if there is the result of delivery or not. And then additional obligations of professional attorneys, this is obvious. Then we have the composition of the courts during pandemic. Then it will be an issue during another panel. And here, just to irritate on this over this relegation, I would like to say that single composition judge in the first and second instance, this is a really shocking solution. Of course, we had and we still have, according to the Code of Civil Procedure, in the wide scope, we have the possibility to make judgments in the first instance in the single judge composition, and instead of the composition of 3 judges and with lay judges. But till now there was the rule that in the second instance, the control of these judgments is made by a 3-member panels. But here, when we have these appeal levels, when the composition of the judge of the second instance is only a single member composition, then this is not the balance between single composition collegial, but this is something which lowers the standards, judicial standards, and then it doesn't allow fair judgments. And what we expect from this collegial court compositions, that is this, that we can avoid the corruption allegations, that we don't have this. And I think that it will be then presented in more details. But here there is this introduction of the single member judge. This is just a testing what will be able to be enforced in the future. But here we should say no to this regulation. And finally, the evaluation of anti-COVID regulation is inconclusive. Remoting meetings and electronic delivery seem to be a good idea, but its introduction has, when it comes to legislation, has a number of problems. Limiting the publicity of the proceedings and the introduction of single judge panels, in my opinion, is a totally harmful solution, and it should be abandoned immediately, even from today. Thank you very much for your attention.
Thank you very much for your in-depth analysis of presented problem. And now we move to the second part of our panel. We will now listen to 4 presentations. I would like to invite Professor Wigita Webrajte and Professor Irina Izarova. Yes, please. Okay. Okay, let me invite Professor Fernando Gascon Inhausti to give the presentation, his presentation online. Professor Fernando Gascon Inhausti is a full professor of procedural law from Universidad Complutense de Madrid Law School from Spain. Dear Professor, the floor, I would like to say, the floor is yours. Okay.
I believe you can hear me properly. Is it correct?
Yes, we can.
So technicalities are fine. Okay, well, thank you very much. First of all, I wanted to thank the organization of the conference for the invitation. I'm terribly sorry I cannot be there with you as I would have liked, but well, previous and urgent commitments prevented me from traveling to Poland as I would have liked to. A special thanks to Professor Gajda-Rożnialska, if I have said it more or less understandably, for all the interest she put in having me here today with you. And well, I'm going to speak about remote hearings as one of the flagships of digitalization of civil proceedings. In times of restrictions on mobility and on the gathering of people. The pandemic, it's also said, may end up serving to promote a digital transformation of the administration of justice, which, without the health crisis, would perhaps still perceived as a mere wish difficult to achieve. Remote hearings, which have become commonplace in the last 2 years, are the most visible part of this transformation and the proof that a sort of new modernity is trying to make its way into civil justice. It should not be forgotten in this regard that when the pandemic broke out, civil justice systems in much of the world were immersed in a crisis of efficiency. They were faced with the need to ensure access to justice for large numbers of cases, with limited resources, but also with higher quality requirements. In this context of crisis, the incorporation of digital technologies into judicial activity is a recurring mantra because they may improve the efficiency, but it's also important to determine its limits, especially from the perspective of basic procedural safeguards. The transition from traditional orality to digital orality represented by remote hearings can be a good sample to see how far we are willing to go in the field of digitization for the sake of efficiency. When the pandemic broke out, the first reactions were drastic. In line with the general objective of curbing contagion through strict lockdown, lawmakers and governments suspended and interrupted procedural deadlines with the consequent paralyzation of judicial activity. Scheduled hearings and trials were postponed without it being easy to determine the new date on which they would be held or resumed. Judicial offices were closed to the public, and a large number of court staff had to remain at home without being able to implement work from home quickly or easily. This paralysis was not sustainable. Judicial activity could not be put on hold given its constitutional significance. From a more pragmatic point of view, it was crucial to avoid the congestion it was causing. In a rather artisanal way, the court tried to gradually recover their activity, on many occasions based on goodwill and procedural improvisation. In this context, certain urgent procedural actions requiring oral proceedings began to be carried out by video conference. This opened the way for the use of remote hearings as an emergency functional equivalent, which made it possible to reconcile the need for an operative administration of justice, the protection of health, and respect for orality and immediacy, which were legally required for the development of some procedural acts. Remote hearings were resorted to for reasons of necessity, as they were considered preferable to the paralysis or the holding in writing of oral proceedings. And this was a generalized trend in the comparative panorama. A very large number of civil procedural activity was carried out through these channels, especially preliminary hearings, management hearings, but also trials in simple and or repetitive cases. In fact, in a less dangerous health scenario, hybrid formats have become equally common, with subjects, with persons intervening remotely, some of them parties, witnesses, experts, and others present with the court in the courtroom. In this vein, as an example, it is reported that up to 7 different kinds of hybrid hearings are being held currently in England. As the health emergency situation starts to ease, what was initially exceptional is becoming normalized, and the possibility of remote hearings becoming a regular feature of judicial proceedings is emerging. This is a clear trend in most of the national civil procedural systems, although some of them also show a trend to shift back to traditional oral proceedings. It should be borne in mind in this regard that all oral acts, and certainly the most substantial ones, are in the abstract capable of being held remotely. In most cases, therefore, oral proceedings can be imagined, at least in the abstract, in a face-to-face format, in a virtual format, or in a hybrid format. In fact, according to many surveys, many judges and lawyers assess positively the virtual format of oral acts during these years of pandemic, especially preliminary and equivalent hearings, because it allows them to better manage their time. The greatest reluctance is, of course, with respect to procedural acts involving evidentiary activity. It is perceived, although it is difficult to verbalize the reasons, that oral proceedings in virtual format do not provide the same added value as face-to-face oral acts. The conclusion is thus reached, or perhaps it's just a mere intuition, that the remote holding of a hearing may affect essential procedural principles associated with the legal option for orality, particularly immediacy and public proceedings. When they came into use at the beginning of the pandemic, remote hearings were intended to circumvent the restrictions to the mobility of citizens and legal professionals during periods of lockdown, and in general to avoid the concentration of people in closed places for a long time. They were therefore legitimized, at least primarily, on public health grounds. Obviously, there were underlying reasons of effectiveness and efficiency. They were the way to avoid a collapse of the administrations of justice due to this paralysis. With the progressive overcoming of the pandemic and the easing of restrictive measures, there is a shift in the rationale for remote hearings. The need to preserve health takes second place, while efficiency is enshrined as an element with sufficient virtuality to legitimize them in a post-pandemic future. In addition to efficiency, indeed, there is sustainability and the contribution to the fight against climate change. In my country, in Spain, for instance, the government presented last November a draft bill on the digital efficiency of justice, aiming, among other purposes, at generalizing remote hearings. The report accompanying the draft stated that the holding of virtual hearings has avoided an enormous amount of travel, which in turn has prevented the emission of almost 6,000 tons of CO2. In any case, these are valid aims. Preserving public health is more than acceptable, but it's also legitimate in the abstract to sustain a procedural change on the objective of promoting the efficiency of the administration of justice. And the same can be said without the need for special justifications regarding the now added purpose of contributing to the fight for sustainability and against climate change. This last ground, indeed, opens up a new space for legal reflection, that is, to what extent environmental protection and the fight against climate change can become per se elements justifying restrictions of other fundamental rights, including procedural safeguards. But this is another issue. Bearing all this in mind and looking into the future, digitization by remote hearings must take into account at least 5 factors. Firstly, we must take account of technical constraints, which lead to the problem of the digital gap and access to justice. In this sense, the widespread use of virtual hearings is conditioned to the availability of the necessary technical means for the courts and the litigants. From the point of view of the courts, it is a question of public budget and of training. In this vein, countries like Norway, Finland, or England reported a very fluid transition into the digital format in the pandemic, thanks to the previous developments that had taken place in those countries. For litigants, to have the necessary technical means to act remotely is not only a constraint, but it may affect their access to justice. In many jurisdictions, the scope of self-representation is very wide, and the digital gap may compromise the access to justice of those who would be expected to intervene remotely without having the appropriate means. The problem was evident during the pandemic, and it will not disappear with it. In the second place, it is necessary also to take into account what is at stake in each procedure. Both during the hardest times of the pandemic and also in later times, it was assumed, at least in some jurisdictions, that some procedural acts legally foreseen to be oral were only possible in person, so that they could not be held virtually. The clearest example is provided by criminal justice, where some countries established red lines, like France or Spain, where the physical presence of the accused and the lawyer is always requested in trials for serious crimes. It is thus recognized that direct interpersonal contact has a value that is difficult to explain, but that can have an impact on the quality of the procedural activity, including the quality of the right of defense. In rules such as those, the lawmaker assumes the limitations of remote hearings and recognizes, maybe implicitly, that they are not the same as ordinary ones and that they may affect some procedural safeguards. In civil proceedings, freedom is not at stake, I know, but it seems to me unquestionable that the social, the economic, or the personal importance of what is at stake in a specific proceeding is an element of relevance which should work as a counterweight to mere efficiency. The third factor that needs to be assessed when analyzing a generalization of virtual hearings is their impact on the principle of immediacy and on the quality of justice. There's a legal notion of immediacy linked to the right to judicial relief, and which is identified with the direct contact of the judge with the parties and the evidence. Can it be said that this direct contact also takes place in a virtual context? In my opinion, not entirely. In a remote hearing, the spoken word is certainly used as a communication tool. It is common to point out, however, that in a virtual framework, participants are not subject to the environmental and the ritual influence typical of oral proceedings, and that the judge may thus be deprived of useful elements for assessing their credibility. Opting for orality and immediacy means assuming that direct communication between persons interacting in the same space increases the chances that the process will better fulfill its functions, including the consensual resolution of the dispute. Orality implemented through face-to-face hearings also influences the social legitimacy of the judicial system. It gives litigants their day in court and increases the perception that the state, through the court, takes the resolution of the specific case seriously. From this angle, both the screens and the limitations of video conferencing programs can be seen as instruments that distort the communication required by proceedings. Elements of assessment and context may be lost, which would result in a better quality of oral judicial activity and ultimately of the process itself. Thus, a commitment to greater use of remote hearings aimed at making the system more efficient and more sustainable requires taking on board this intrinsic deficit to avoid incurring in low-cost orality or low-cost immediacy. For the future, it is essential to ensure that all remote hearings meet adequate technical requirements in terms such as the location of the participants' cameras, the possibility of close virtual contact between participants, or the existence of a channel for the instantaneous sending of documents while the hearing itself is taking place. Many guides and protocols approved in many countries during the pandemic are concerned with these questions. But these requirements should attain true legal and binding status so that real procedural rights and powers should derive from them. The fourth factor is the impact of remote hearings on the principle of public proceedings. The court is no longer a physical space where any citizen can go to see how justice is administered, since hearings take place in platforms whose location is not always public. Therefore, generalizing remote hearings should be accompanied by a more detailed regulation of public access to those virtual courtrooms, which should be spontaneous and through mechanisms that would ensure the publication on the electronic sites of judicial bodies of the links or channels for live broadcasting of their proceedings, since streaming may be the only real formula for public access. It's in any case something that must be done with caution and with limits linked to privacy. After all, this is not just an issue for virtual hearings, but more generally for all online courts or equivalent features of the future. The requirement for public proceedings will be in those cases more necessary than ever because, as has been noted, digital courts must be open courts. The fifth and last factor is that of the powers of the court and of the parties regarding the choice of using or not remote hearings. Many of the rules regulating remote hearings as an emergency solution during the pandemic established a preference for the virtual format, so that it would be the in-person hearing that would have to be justified in each specific case. The initiative to opt for the virtual or the face-to-face holding of a hearing was also attributed to the court, which could impose it onto the parties. This was a logical regulation in times of emergency. Is it reasonable to maintain it for the future? In my opinion, the answer must be yes, at least in general terms. The court must have the power to define specific format of an oral hearing depending on the circumstances of the case and those of the judicial body itself, such as agenda or available space. Conversely, the court should also have the power to force the personal presence of subjects who would have preferred a remote presence. This is the experience in many common law jurisdictions. There are cases in the United States, in Australia, or in Canada where litigants have asked for face-to-face hearings and courts have denied the right to have them. In other jurisdictions, however, the will of the parties is still a very relevant element when the court decides on the format of a hearing, and it is regarded as a precondition for a virtual trial to take place. This appears to be or to have been at least the rule in France, in China, or in Denmark, for instance. But it would be excessive and in many cases dysfunctional for the will of the parties to be imposed on the court. In accordance with what I've mentioned before, it would be reasonable that a litigant could object to the virtual format of a hearing on the grounds of lack of technical means to face it with full guarantees. In such a case, for purely procedural fairness reasons, the court should offer adequate support measures and eventually a return to physical presence could be considered. Let me just make a few final remarks. Virtual hearings bring many of the advantages of digitization, namely flexibility, convenience, and procedural economy, but they deprive oral proceedings of ingredients that could redound to the quality of judicial activity. By opting for remote hearings, procedural systems are undoubtedly jumping on the bandwagon of efficiency, technological modernity, and sustainability. But it seems to me they run the risk of doing so insufficiently if they omit the mandatory nature of technical and procedural requirements suitable for reinforcing the quality in the development of the hearings in terms of immediacy and public proceedings. And it should not be forgotten that efficiency, properly understood, always requires preserving the quality of the results. Likewise, it must be remembered that efficiency must always go hand in hand with proportionality. Virtual development of the trial or the main hearing in a complex case with abundant evidence will undoubtedly have a greater negative impact on the final outcome of proceedings than the virtual holding of a hearing to decide on purely procedural or incidental uses. A good exercise of the case management powers of the court and of the parties should include the appropriate choice of those hearings that are to be carried out virtually or in person. That's all on my side. I thank you very much for your attention. And of course, when the appropriate time comes, I will also be available for questions. Thank you again.
Thank you very much for your presentation. And now the next presentation will be made by Professor Michał Balcerzak from Nicolaus Copernicus University in Toruń from Poland on the COVID-19 pandemic and proceedings before the European Court of Human Rights. Dear professor,
Panie profesorze. Panie profesor.
Dear
Słyszą?
professor.
Tak, dobrze, to możemy zaczynać. Dzień dobry.
We are really sorry for the technical problem from earlier and then change. Now we are ready to ensure connection with you. So please, you can give the presentation.
Thank you so much.
Bardzo dziękuję Państwu i dzień dobry. Będę mówił po polsku, ponieważ poproszono mnie o przedstawienie tej prezentacji w języku polskim.
That's no problem. It happens. Technology sometimes fails us, so no worries. Dzień dobry Państwu i przechodzę już do rzeczy.
Now I shall move to my lecture. The topic of my speech is the COVID-19 pandemic and the proceedings before the European Court of Human Rights in Strasbourg. So it so happens that I had the opportunity to have a close look at the proceedings before the European Court of Human Rights during the pandemic, while fulfilling the honorable duty of deciding as an ad hoc judge. And this privilege is in progress in one of the cases. Therefore, due to these cases, I will not be able to speak too much about the cases. Nevertheless, I will be very willing to share with you a few observations I've had, referring to how the tribunal in Strasbourg coped with this great challenge. Well, there's no doubt that the pandemic did not have any influence on the functioning of the Strasbourg tribunal, especially in the first months after its eruption in March, April, and May 2020. At any stage, there was no suspension of the operation of the European Court of Human Rights, fortunately, but the sanitary restriction introduced by France and the European Council also had its reflection, had its impact in the special measures associated with the work of the Chancellery and judges, also the decisions that modified procedural matters. And this is the panel. Civil procedures, also digitalization, so therefore I would also like to mention a few words about this in the further part of my speech, how the tribunal coped with this digitalization. Well, there were, of course, certain measures to be taken, which I would not like to discuss in detail too much, because the fact that some court procedures were cancelled, that some March or April cases were not conducted. The first hearing took place on the 10th of June after the first wave. For some time, the pronouncing the rulings was suspended until the end of April 2020. Today in the morning, Mr. Professor Spunar, that in this respect, the tribunal in Strasbourg, the court in Strasbourg, has it easy because it does not announce rulings immediately via, there is no need to read rulings during the meetings of the court, but publishing the rulings in the system, QDoc system, is already its announcement. So some of the rulings, yes, are announced. So this kind of announcement did not take place. And yes, it was also, communication was limited and slowed down. The tribunal with those who were accused and those for 2 months, the tribunal stopped communicating new cases. I mean, the accusing parties, the defendants, there was no list of questions and invitations to place your position. We have to note 2 decisions which may be more interesting for you, ladies and gentlemen, as process specialists. 2 decisions which the European Tribunal of Human Rights, Court of Human Rights, made in the first days, actually, of the pandemic, actually in the middle of March, which referred directly to procedural matters. One of these decisions was elongating by 1 month the internal term defined in hearings that were in progress, procedures. And the second decision of the court was suspending for a month and then for the next 2 months the term for filing individual claims. And this term is defined in the convention in Article 35 of the European Convention on Human Rights. And in the margin, it was 6 months before the 1st of February 2022, and from the 1st of February 22 this year, it's 4 months after the protocol number 15 entered into force. So it is allegedly to improve the effectiveness and objectiveness. And in the margin, I want to mention that I'm not really convinced whether so strongly this would improve the procedure if the deadline for filing an application, a complaint, is just shortened from 6 to 4 months. That's just my opinion. Nevertheless, these terms, which initially were elongated by 1 month, then were elongated by 2 months again, and until the middle of June, whereas this did not refer to the term associated with the possibility for applying for hearing the case once again by the Great Chamber, because the Chamber's decision, the Chamber's ruling, may be still actually appealed to. It's a special mean of appeal in the Strasbourg system by an application to hear it once again by the Great Chamber. Here the term is 3 months. This term is not elongated anymore in the context of pandemic. And a comment that I would like to propose to these decisions, the comments are as follows, where first of all, the tribunal the European Court communicated with external parties through press messages. We can understand that these decisions were not just made, I assume that these were decisions of the President of the European Court regarding the elongation of the internal terms and those non-convention terms, but also as for the decisions about the elongation of the term for filing individual applications claims. Well, there is no doubt that this was adequate response to the presentation of to the presence of a force majeure. This was a force majeure for sure, and only that this term of 6 months, early one, and that the term back then is clearly indicated in the treaty in Article 35 of the Convention on Human Rights, and the Convention does not foresee anywhere the possibility for suspending the terms which are clearly indicated. So you cannot modify the Convention easily as an internal law. I'm not saying that it's easy to novel internal law, but attempts to change a treaty, such as the European Convention on Human Rights, where you've got 46 countries, parties, 47 actually, because Russia, until September, is still a party to the treaty. Whatever they say themselves. Anyway, this is a task which has no chance to be successful in short term, so the modification of the convention was not the case. What was possible was modification of the regulations of the tribunal, but via regulations, rules and regulations, you cannot change the convention. So there is a question whether the tribunal was not acting supra vires, ultra vires, but I would defend this decision. I think this was as part of the convention of the tribunal. There's Article 32, which specifies the competence of the tribunal, competence of the court in Strasbourg to solve all matters of interpretation and application. I would like to also recall, just briefly, that for decades now in the tribunal, we've been promoting a ruling thesis that the convention is supposed to serve the implementation of rights which are practical and effective and not theoretical and illusoric. And this principle has been appearing many times in the judicial decisions. This refers to material legal matters, but I would also defend the view that it also has a process dimension. This material complaint is supposed to serve somebody. We should not treat this mechanism only as an addition to the convention, because the convention is based on, it's a pillar of the system for controlling the performing of the obligations. And anyway, the tribunal, also in the earlier judicial decisions, it had flexible decisions referring to some formal rigorisms. Sometimes, in just a few cases, but it happened that a party was deprived of the possibility to operate, it was not able to keep a date, deadline, then this also happened already. But as far as I know, in the Strasbourg system, never this term was suspended so directly and in such circumstances. Nevertheless, this rigorism, procedural rigorism, is not typical for the European Court, even though for 10 or 15 years the Court is being encouraged to also be more flexible, to cope better in this rigorism, so that the Strasbourg proceedings to be faster and more effective, to be more flexible. Nevertheless, this suspension of the term, for sure, for some of the accusing parties, or for some of the applicants, allowed them to file an application, a complaint. There is Mr. Saakashvili. There was a complaint, several complaints, Saakashvili contra Georgia. Contra Georgia. It was not possible if it wasn't for that extension. Just a few sentences I wanted to devote to tell you that the tribunal coped with this. It's interesting that some threats came perhaps not from the side only of the context of this first wave of the pandemic and the sanitary restrictions, but there was a certain attempt of obstruction and attack at the court in the context of the pandemic caused by a website. Websites are not created on themselves. It was established by one person, an applicant who filed a complaint. It was a website established in a French domain. It is still functioning, but I will not advertise the address. This website was prepared in such a way so as to enable the claimant, the person having the claim, generate a claim, because claims, applications are generated in PDF, editable PDF forms, and this website was established as part of objection movement to COVID passports, to COVID passes objection in France. Thanks to this website, it was possible to print out a ready complaint, ready application, just by inserting the personal data of the applicant, and the part referring to facts, the law was ready. After printing such a complaint and claim, it was enough to just put it in an envelope, stick a stamp and for €2 and send it. And this way about 18,000 complaints were filed to the tribunal, to the court. Please imagine. The content of the application of the claim referred to accusations about these COVID passports, but also the persons, the accusators, also wanted to paralyze the work of the court. And this strategy was the denial of the idea of a right to individual application claim. The court, not for the first time, when it was dealing with a type of a wave of complaints in certain cases. It already happened, but in this case, well, the pandemic caused this effect of a wave. And nevertheless, there is a clause of abusing law also in the context of individual complaints. The tribunal found that these complaints are an abuse of the right to file a complaint, an application. There is a decision in Zambrano versus France from the 21st of September, where the tribunal, I cannot hear the speaker. There were also, in this case, we meant abuse of procedural law in this case. Ladies and gentlemen, I shall not discuss matters associated with the judicial decisions of the tribunal, of the court on COVID matters, because this exceeds the frames of the panel and the conference. I just want to kindly mention that it is also interesting that the right to file an application, a complaint, was preserved, whereas in the conventional system we have a mechanism of derogation in Article 15. This derogare means derogate, and this means a mechanism of temporary suspension of performing certain obligations of the Convention in times of public danger. About 10 countries, parties, used this clause, notifying the derogation. Poland was not in this gremium, and 8 out of the 10 countries were countries of Middle and Eastern Europe, let's call them this way. And this is an interesting matter, perhaps not only a process matter, although yes, partially, but some countries reacted also this way, using this possibility, trying to avoid the consequences of certain claims of accusing parties. This is also an interesting question. How sufficient were such limitation clauses as for the right to privacy, the freedom for gathering, and how strong we had to reach for, let's say, an instrument, a radical instrument as temporary suspension of obligations, although countries are entitled to that. It's quite interesting, because in this, at the moment, in the court now, cases are heard which were accusations referring to some limitations of rights and freedoms were mentioned. Switzerland did not report a derogation as for example, the freedom to gatherings. In one of the cases, the court noted that since freedom of gathering was available and it was then turned off, let's say, in such a case, this was an infringement of Article 11 of the Convention. But to sum up this topic, derogation does not refer to procedural entitlements of the accusing party. In this scope, there is no entitlements of the accusing parties were limited or infringed. Ladies and gentlemen, just a few conclusions, because here I would like to just signal certain topics. If the matter of judicial decisions of the Strasbourg Tribunal Court would be interesting for somebody, I want to kindly recommend to you an elaboration, a paper, which was published a few days ago. It's available online at the website of the court. It is a document, summing up what's now happening. I will just read its English name. It's background document, human rights protection in the time of the pandemic, new challenges and perspectives. It's dated 17th May 2022, very interesting discussion on the current judicial decisions of the court on COVID matters. And just brief conclusions. The COVID pandemic has not led, fortunately, to a paralysis of the activities of the European Court of Human Rights. The court quickly introduced modifications of the way of functioning in the scope of online hearings, of which there are not too many, 8-10 per year. And anyway, there was no infringement or problem for the effectiveness of this court. Secondly, the most important modifications adopted due to the pandemic referred to the suspension of the running time limits in the pending procedures which were in progress, time limits which are established by the court to the parties, and also the convention timing referring to the claim, individual claim, then 6 months, currently 4 months. And finally, the last conclusion, computerization, digitalization of proceedings before the Strasbourg Court of Human Rights was something that was started much earlier, before the pandemic. And thanks to this, I believe that the consequences of the pandemic were slightly eliminated, it wasn't devastating for the effectiveness of the system, Strasbourg system. It was ameliorated, and some of the experiences will stay with us, telework, video conferences. I'm sure this will be useful in the post-pandemic period. However, I want to express, this will be the last thought of which I would like to share with you. I would like to share that if the future of judiciary and higher education is based only on the fact that we just connect online, and that all this would be in the remote form, I don't know if it's my future, actually. Of course, we can have procedures, hearings online, we can have online meetings, and meetings also happen in this mode. It all operated well. Nevertheless, I believe that not necessarily we would like to return to that online remote period. Thank you very much for your attention. I wish you a good conference.
Thank you for your presentation, and let me invite you, Professor. Let me invite Professor Wigita Webraite from Faculty of Law of Vilnius University to give her presentation. Dear Professor, the floor is yours.
So thank you very much. It's really nice to be for the first time in Katowice, and thank you very much to Katarzyna Gajda-Rożynalska and other colleagues for organizing such a nice conference. And as Anna has told me, it's also for me the first time after pandemic that I am in the conference, face-to-face conference abroad, not in Lithuania. So thank you very much. So I will talk quite generally about digitalization of justice in Lithuania, not only about COVID. So I will talk about the steps we're taking to digitalize Lithuanian courts. So actually, digitalization of public service has been one of the main objectives of Lithuanian governments already for a long time. And as you see in the table, and so we have many platforms and many public services are possible to do it digitally in Lithuania. So we have like this e-government gateway, where all citizens who have e-card or electronic banking or electronic signature can log in quite easily and can provide documents, can get documents, and can get public services quite easily online. So we have quite well-known platform, e-health platform. It works actually quite well. We have also Center for Registers e-platform, and all registers are online, and most documents can be provided online. Also, we have e-platform for taxis services, which works quite good actually, and we have quite a big e-portal for legal acts. And actually, word GovTech, like government technologies, is relatively well known in Lithuania, and we have GovTech lab. It's organized in Lithuanian government, and it's also quite well known. So actually, digitalization is quite high in Lithuania, I could say, and courts are, of course, no exception for that. So for quite a long time, not only during pandemic, steps have been taken to create and to develop ways to administrate courts and court proceedings digitally. So actually, the first steps were taken a bit earlier than in other public institutions, and first steps were taken actually in 2003 and 2004 to make some first steps to digitalize Lithuanian courts. So when we speak about digitalization of court proceedings in Lithuania, we usually discuss such aspects. So electronic e-service of procedural documents, also recording and storage of records of courts hearings, electronic allocation of cases to judges, also electronic management of court documents, and also like statistics, different statistics of courts activities in Lithuania, and some other aspects. So how it works actually with digitalization in Lithuania of courts. So there is such a big platform, it's called Liteco, and it's these all aspects, these all modules are provided in this system, Liteco. So the first steps to create this Liteco system were taken on 2004 and 2005, and now I think every year some modernization works are provided and are created to modernize this Liteco system and to create new models and so on. And in 2013, amendments to the law on courts and to the procedural courts were introduced, and they stated that the electronic data related to judicial and enforcement proceedings must be managed, registered, and stored using information technologies. So the rights of the parties to proceedings to get remote access to electronic case files, and the right to submit procedural documents to courts electronically if they wish so to do it. So the same system also is provided for civil proceedings and administrative proceedings, and some steps are done for criminal proceedings to provide also such services. So the court electronic services are accessible for customers via portal e-teismas.lt, and as I told, the electronic government gateway system can be used to log into this system, and for persons who are like foreigners and do not have e-card of Lithuania and so on, we get some special code to access this platform and to get documents online and to provide documents online if we wish to do it so. And also you can pay stamp duty and so on through this platform. Also, our law now states, especially along courts and Code of Civil Procedure, that attorneys at law, assistants attorneys of law, bailiffs, assistants bailiffs, notaries, state and municipal enterprises, institutions, organizations like insurance companies, court-appointed experts, insolvency administrators have the obligation to submit procedural documents by electronic means in Lithuania. Yes, so, and other persons like private companies or natural persons, they have a right to submit documents digitally if they want to do it so. And also now in this ecosystem, so you can find different forms for court proceedings. So there are, I think, now more than 100 forms are placed, and participants to proceedings can find these forms and fill them just into and send it to the court. Important element of this ecosystem is also storage of audio records of court proceedings. So the court hearings in civil cases and administrative cases must be carried out, must be recorded. So, and different technologies are provided to record such proceedings. So our Supreme Court of Lithuania stressed in several cases that the record has to be in good quality, and if a record has some significant disturbances, it can be a ground to repeal the judgment. Also, it's possible to have like some judicial mediation procedures and enforcement procedures also can be done electronically. Yes, so I can say you that like at the end of 2021 we were like more than 100,000 users of the system, and 86% of civil cases and 69% of administrative cases were managed electronically in Lithuania. Yes, so while speaking about remote court hearings, so actually not only during COVID, but actually in 2013, amendments to Code of Civil Procedure came into force, which stated that information and communication technologies such as video conference, teleconferences could be used during court hearings. And similar rules were introduced also in administrative proceedings. So the courts were equipped with stationary video conference equipment and mobile sets to organize such hearings, but actually till the COVID pandemic it did not work very well, and these video conferences were really applied really only in hearings when some of participants were abroad, or in some cases where participants were imprisoned and so on. So really it was used. Of course, COVID pandemic really was the major reason to promote remote court hearings and to apply the legal rules more flexible. So actually nowadays, so the courts decided during pandemic that to use Zoom platform for court hearings and not to organize some special platform for remote court hearings. And of course it is possible to use hybrid court hearings when the judge and some participants of proceedings appear in the courtroom and other participants participate in the court hearings remotely. So actually, while speaking about COVID-19 pandemic, so this transition of courts went really smoothly, I can say that, because judges and participants of proceedings, especially if they were lawyers, were not really in shock that the remote hearings can take place, and actually most of proceedings transition went really well. And we did not change actually Code of Civil Procedure, and we did not adopt new amendments to the code regarding the pandemic, but we used these general notions about remote court hearings and possibilities to have remote hearings also for COVID-19 pandemic. And we got our Judicial Council provided recommendations how these remote court hearings could take place and how it should look like. So we had, I think, 3 or 4 different recommendations depending on the time, for the first quarantine, for the second quarantine, and now we have also recommendations for remote court hearings, but we are really general recommendations, and we do not mention COVID pandemic, so that means that these recommendations can be applied in different court hearings, not necessary for COVID pandemic. And actually till now we have some remote court hearings. We right now we don't have any restrictions, Lithuanian restrictions for COVID-19 pandemic already, finally, but still we have some remote court hearings, especially hybrid ones, where participants to the proceedings agree, and the court agrees that it is possible to have a remote court hearing and all the principles, procedural principles can be safeguarded. So of course I can say that orality and publicity principles were mostly changed during pandemic, and it was quite difficult to safeguard principle of publicity firstly. Now we have like a system where not participants but public can join the system and can watch hybrid or online hearings, but firstly it was really a problematic angle to safeguard publicity of court hearings. So our court practice also reaffirms actual Court of Appeal. We still do not have some judgment of Supreme Court about remote court hearings, but our Court of Appeal states that if participants to the proceedings have agreed to remote court hearing and there were all possibilities to connect to remote court hearing, the parties had opportunities to speak out their argument and had the opportunity to speak with their lawyers confidentially. So it means that there are no formal procedural grounds to challenge the judgment, and the court hearing was organized properly. It can be agreed that a final implication for the judges system arising from the COVID-19 experience accelerated investment in digital technologies in Lithuania, and the remote court hearings will be, I think, like a form for the future also. Now remote court hearings are also perceived as a way to level the workload of judges in cities and in smaller towns. So it is hoped that if participants to civil proceedings agree to remote proceedings, it will be possible to apply different jurisdiction rules and refer civil disputes to other courts, to other smaller courts. While speaking about digitalization, so of course you can also speak about use of artificial intelligence in court activities, but till now we have no huge discussions to apply it or to provide some possibilities to apply artificial intelligence for court proceedings. Like, for example, Estonia states that we have such a platform, but actually I don't think it really works. It's only like an advertisement. So we are not really discussing it. I think the problem is because we are really too small and it's too expensive to provide such a platform, and we don't have such discussions, but perhaps later we will see. Perhaps in the next conference in 5 years we will discuss it, but we will see it. So yes, so this is my small short presentation about digitalization in Lithuania, and I hope you will have questions and I can provide you answers. Thank you very much.
Thank you for your presentation. And the next presentation will be made by Professor Irina Izarova from Law School of the Taras Shevchenko National University of Kiev from Ukraine. Dear Professor, the floor is yours.
Thank you very much. Dear colleagues, this is a great honor for me to be here and to speak. And first of all, I would like to thank Dr. Gaida Rusinyalska for her tremendous efforts in this project implementation. I'm happy to be part of it, and I hope our results contribute to judiciary development. Yeah, I'm from Ukraine. I'm from Taras Shevchenko National University of Kiev, and I'm going to talk about our path of digitalization of justice. Some of my remarks in conclusion go to the main goal of this activity, reflections about who is in the focus of this series, courts or citizens, who should benefit in the end. So, as far as I remember, when I started to write about the digitalization in general, it was like something like 10 years ago. and the focus was on the European achievements and the move towards e-justice and on the first Ukrainian steps towards the digitalization. The last few years of challenges have shown us, all of us, how the digitalization of justice is important for the proper administration of justice. The war in Ukraine confirmed how important it is to ensure the security of digital assets. In my presentation, the issues of the Ukrainian e-justice system as a part of e-government are considered, as well as new models of the e-justice system introduced in fall 2021. The idea of facilitation easier access to justice for all through digital tools, accompanied by the reduction of costs and the sustainability of paperless activities, is undoubtedly a good one. Even though it should be articulated and introduced through the appropriate options and tools for such a system, still the focus of e-justice should be on the customer, and this means that a lot of e-tools like attorneys, mediator services should be introduced to the system in Ukraine. So, I was listening attentively to my colleagues from Lithuania. We have almost the same achievements, but 10 years delay. But this is a great success, and I'm gonna start with it right now. DIA, the abbreviation of abbreviated name comes from the words the state and I, Держава и я, a mobile application that has mediated the relationship between government agencies and citizens in Ukraine since 2020. Identification documents, here is mine, are stored here: domestic, foreign passports, driver's license, and a lot of other documents. You can access a range of public services here. At the end of 2021, it was being used by 20 million people. From August 2021, by law, so last year in August, by law, the documents in DIA used similar as paper documents. Most likely, Ukraine became the first country in the world where e-passports have the same legal meaning as paper passport. At the same time, not all areas of our life have been successfully covered by digitalization. Certain problem on the way to the introduction of e-justice in Ukraine was a general imbalance in the digitalization of various branches of state bodies. That was an obstacle to successful creation of e-justice in Ukraine. So it's worth noting that Ukraine is among the top 3 countries with regard to the rapid pace of computerization of the judiciary, according to the CPR report. DIA brings us new solutions such as enforcement procedures, summons, etc. And it was announced just a few days ago that it helps us to attend hearings, court hearings, through this app in close future. And I believe it could be, in particular, according to the State Judicial Administration report at the end of last year, the average level of computer equipment of Ukrainian courts was about 82%. But this also raises very important but painful issues. Digitalization will bring simplicity and ease only to those who use or learn to use new systems. For the rest of employees as well as users, this can be a serious obstacle. You can see numbers of staff in Ukrainian courts and judges and other staff for our courts. So it will be painful and problematic to some extent. In my opinion, the way of justice. In Ukraine, the concept of justice has been around 10 years. So at the same time, the first concept of e-court was developed by state enterprise, information court system, in a very simple way, just 10 years ago, 2012. Accordingly to this old vision of e-justice, this system should have provided the possibility to send the court documents signed with an electronic digital signature, to distribute cases, very simple options, so-called automated core document management system. At the same time, Ukraine, since 2011, has a unique open unified state register of judgments. So recently, this register has more than 1 million justices available for analysis, but anonymized the participants in the proceedings. This register contains almost all the procedural decisions of the courts of Ukraine, which has become quite a serious financial burden. From one side, there were some opinions about the cancelment of court decisions from publication in the register, where in some cases, which indicates it's important to society. The video conferences, a special mode of court proceeding, were introduced also in 2012. In 2020, due to the quarantine, this was supplemented by a provision on the right of a person to participate in court hearings outside the court within video conference. And I would like to tell you a little more about EasyCon system, which helped to provide such video conferences. Perhaps the most important step in the digitalization was the creation of the unified judicial information and telecommunication system. I will tell briefly system during the great reform of procedural legislation in 2017. So I can't use the only one slide to show the whole picture of the system. So I started from the main models, so general subsystem and models of this system. It's it seems very complicated, but actually it consists of e-cabinet for general services. So you have to be registered in this system, and so it helps to get access to the information about place, date, time of hearings and decision. Official web portal of the Judiciary of Ukraine. So we have some not so similar like e-justice portal, but to some extent, with information on the activities of the judiciary, background information, other public information, some information from open registers of the judiciary, a lot of data, the Unified State Register of Court Decision, the Unified State Register I told you about, the Unified State Register of Enforcement Documents, and the Open Data Set modules provides access to Open Data Set on the Unified State Open Data Web Portal. So we have a specific web portal for distributed some information about state activities, and the last model is, in my opinion, one of the most important. It's automated interaction with other automated systems. So courts may interact with other systems, with other state bodies and institutions, state registers, information system, with other courts actually. So the unified subsystem of electronic record keeping of courts, bodies and institutions of the justice system consists of 5 models. E-court allows to send copies of electronic documents, to pay court fees and so on. E-record keeping, automated distribution of cases between judges, e-archive, and judicial statistic. This is like more technical subsystems, provides automation of personal, financial, accounting processes, the formation of reporting on these issues, economic activity management of courts, subsystems, the unified contact center of the judiciary of Ukraine. So all of this subsystem ensures the confidentiality, integrity, and accessibility of the system information. But starting from October 5 last year, only 3 subsystems or modules were officially operational: the video conferencing, e-cabinet, and e-court. So others are only on the state of designing and producing. This is actually totally Ukrainian product. EasyCon communication platform is a modern alternative to video communication that does not require any specific installation of additional programs, especially useful for those who, for various reasons, can't be present in person to attend a court hearing. This is entirely Ukrainian product used in government agency, and it's available from outside of Ukraine, and not only for courts, for businesses and for ordinary people, it's also available. So e-cabinet. E-cabinet is a model that allows to register an official email address with an electronic signature, which will then be used to exchange documents in electronic form between courts, between the court and participants, and between both participants. So lawyers, notaries, and like everywhere, private executors, they have to register official emails in the system. Others only on a voluntary basis. E-court. E-court system allows certain procedural actions to be carried out to ensure the trial of the cases in an electronic mode. The system registers application, complaints, and other procedural documents submitted to the court. As of November last year, the e-court allows more than 600 types of lawsuits to be filed electronically with templates proposed by this system. The system also allows to pay court fees online calculators, allow to determine the amount and details of payment, provide information on the stage of the trial, and send in procedural documents by email. Judgments, summons, other procedural documents are also set out and sent through the system. So, enforcement. This is the weakest part of Ukrainian justice, I would say. At the same time, certain achievement, not so great like in Lithuania. I'm certain this, but to some extent should be shared. First, this is an automated enforcement system, computer program that provides collection, storage, accounting, retrieval, generalization, provision of information enforcement proceeding, the formation of unified register of debtors, protection against unauthorized access. Parties, debtor and creditor have the right to access enforcement proceeding by searching, reviewing, copying, printing documents in enforcement proceedings in which they participate. Ukraine also maintains a register of debtors and online database of debtors, which is maintaining to publish real-time information on debtors, unfulfilled property obligations in order to prevent the alienation of property by debtors. But the main achievement is the last one, so in current time I can check if I have some enforcement procedure, and you can imagine my surprise when I once I found one mistakenly, but it was very interesting and experience very visible. So in this app, any person might be notified about the enforcement, has an access to all of the documents, and also a payment option too. So very important thing, in my opinion, free legal aid online. Free legal aid system has an extensive network throughout Ukraine. Free legal aid is a provision of legal services guaranteed by the state and fully funded by the state budget of Ukraine. This legal assistance aims at ensuring the realization of human and civil rights and freedoms, the protection, their restoration in case of violation by providing legal information. Help with preparation of applications, advices, assistant with the representation in courts, other state bodies, and etc. Providing such services online has significant advantages: speed, simplicity, and ease to access. At the same time, it should be noted that these services do not interact with the portal of judiciary, which raises doubts about the main purpose of digitalization of justice. Is it meant to provide courts with technological innovation or to ensure access to justice through digitalization? Anyway, wartime challenges for e-justice in Ukraine brings us some new specifics. During the period of this war, the weakness of our Ukrainian justice was especially noticeable, visible. The access to the unified state register, as you can see, as well to the services of status of proceedings, list of cases under consideration were temporarily suspended. Even though the state judicial administration of Ukraine reports that for the period of first months of war, the courts adopted and sent half of the decisions to the state register comparing with the same period in peacetime. It's worth noting that Ukraine has a large territory, more than 600 courts, 20% of which were occupied or terminated their function due to the invasion. Therefore, the question was how fast could we cancel access and contacts between a particular court and the whole system to avoid any illegal access and acts. So some of my concluding remarks at the end. It should be noted that unlike its European counterpart, Ukraine does not yet have concept of providing comprehensive access to justice online as a single entry point is provided, for instance, by the European Justice Portal. The idea of all in smartphone brings a new vision of e-justice in Ukraine, which become more human-centric than before. This is primarily a path from finding information about violated rights and possible ways to protect them, to obtaining compensation and restoring them. So it's quite a long and extensive road on which many more opportunities can be and should be found by ordinary citizens. In Ukraine, the digitalization of justice was considered as an additional option for functioning the judiciary. Still, we have this vision of e-justice as a technical tool rather than digital help for users or customers of this system. Also, we still may share certain achievements, like, for instance, the interactive functionality of e-justice portal allows ordinary citizens to have convenient access to justice and almost all possible services that facilitate its implementation. Finding a lawyer, other specialist, alternative dispute resolution. We have loan mediation from since fall of last year, legal, interactive forms of appeal and others. So still in Ukraine, the services are scattered between different portals. Thank you very much for your attention.
Thank you very much for your presentation. This was the last presentation in our panel. And now I'm opening the discussion with the speakers from both panels, the first one and the second one. I encourage you to ask the questions. Is there anyone who would like to start this part of our conference? Who would like to ask the first question? Have we the question from the chat? Oh, excuse. So, please give the answer.
Thank you very much. I'm Roland Kempfler from Germany. I'm a judge going to speak tomorrow about criminal law. And I was very interested to hear, especially from our colleagues from Ukraine and Lithuania, how extremely digitalized your court work is already in civil law especially. I must say that in Germany we're far behind what developments that you explained to us today. What I would be interested in, because it wasn't entirely clear to me, because you spoke, as I understand, about criminal law, civil law mainly. Is there a difference between civil law and criminal law in your countries in the way you work digitally, in the way court proceedings are digitally? Did that change during the pandemic, or are there changes on the way because of the pandemic? That is something I'd be interested in. You first?
Yeah, so I can start. So I do not work actually a lot with criminal proceedings. I'm not really into that, but I can say that, yeah, criminal proceedings are really less digitalized than civil and administrative proceedings, and COVID-19 pandemic was really a big step to digitalize them in somehow, because still up till pandemic actually only small parts of criminal proceedings were digitalized, and actually now, so still the main principle is that criminal proceedings should place in a courtroom without the help of digital technologies. Only some procedural steps can be taken like digitally, like some, not the main hearing of criminal proceedings, but some steps and investigatory steps and so on. And also like audio records. So audio records are like a part of protocol, but still the protocol is being also written in the courtroom, also in criminal proceedings. Like in civil and administrative, only a record is done, but in criminal proceedings also the record is written, like a protocol is written during a court hearing. So yes, so I can say that criminal proceedings are less digitalized, and only amendments of Code of Criminal Proceedings amendments were introduced during COVID pandemic about digitalization. Up till pandemic, we do not have any rules on digitalization of criminal proceedings.
Professor Izirova, would you comment, would you answer this question?
Yeah, I think we may compare in some of more traditional justice system in Europe with our e-justice in Ukraine. This is a result of last few years. I would say pandemic makes us to rethink how we should use this e-justice digitalization tools. I wanted just to reiterate my idea to show you how it was before pandemic. It's like only mostly options for courts, for managing in court, but right now it's mostly for citizens, and I like this focus because I use this app and it's really great and it's really helpful and helped me to reduce time. So according to criminal proceedings, I would say it's not my area, so I will try to ask Professor Kaplina for tomorrow to draw more attention to digitalization of justice. I can only say we have to compare with Lithuanian colleagues. Criminal proceedings was the first, the pioneer, I would say, in video conferences, because even we had a pilot project with Spain, because I don't know, Spain seemed more attractive for our criminals. Because Ukraine is a huge, great country by territory, and it helps to reduce time and cost for reaching hearings in the highest courts. In Kyiv, for instance, from where the first instance was far away. Yeah, thanks.
Okay, thank you. I saw, yes, please give the answer to that question.
Dzień dobry.
Tomasz Zawiślak, ja jestem
Good
sędzią.
afternoon, Tomasz Zawiślak. I'm a judge. I have a question to Ms. Izarova. I was really interested, Ms. Izarova, in the information about the register, about register of debtors, those people having debts. If you could please kindly say more about this topic. Is it a register run in execution proceedings, or based on this register, can you obtain information about the run executions, or whether it's all wholly public register, where such information may be obtained, not proving your legal interest? Bardzo dziękuję. Thank you, madam.
It's interesting, but you are the second our Polish colleagues who are interested in particular enforcement and debtors register. So I found it, and it's accessible from here, from Poland, because not all our services accessible from outside, from Ukraine. And I will show it to you. The main idea of creation of this register of debtors was to give more detailed information about parties in agreement, and about those who is trying to somehow, I would say, avoid of enforcement when private or state executors trying to find their property and other assets. So you can find easily person with some information about proceedings open in and when and where and who is the executor. It's only not so detailed, but it gives you some information about the person. I think it's helpful. I hope I answered your question.
Okay, thank you. Are there any other questions? Okay.
Thank you very much for very interesting presentations and different overviews from different countries. That is really interesting to hear. I wanted to ask all of you if you can share with us the experience from your countries in respect of two problems which we identify in previous discussions, and that is that during the pandemic we have this challenge of access to justice for people who do not really know the ICT systems, the platforms, how to use them, and some of the many people do not actually have means to have these platforms. So do you have any interesting experience or maybe recommendations how to solve this issue from the countries you are coming from? So that's one aspect. And the other challenge was the different platforms, Zoom, Skype, or I don't know which ones were used in courts. Is there any progress to to ensure uniformity of these platforms so that it becomes something more standard in your countries? Do you have anything to share on that?
Okay. Okay, who would like to answer the first one? You. Okay.
Yeah, so thank you very much. So yes, the persons could not log in to these platforms and so on, so we could get help. For example, all our libraries in Lithuania have computers, and web and internet is for free, so the employees of these libraries could help them. Also legal clinics were available, and you can log them, we can come there and we would try you to log in and to show you how to speak. But actually it was not a big problem, I think, for people, older people who do not have representatives. So during the first quarantine, so of course the court hearings were adjourned and postponed for the later period, but that was not a big percentage, so that was not a big problem. And for platforms, so yes, now the courts use Zoom. At first we used Microsoft Teams and Zoom, and then our National Court Administration bought licenses for all courts, Zoom platform, and Zoom platform is used. There were discussions to create, like in Ukraine, I understood, some special platform, but it was decided that it is too difficult, too expensive, and to storage all the information from the court hearings in a special only Lithuanian platform, it would be really too difficult to safeguard all the security issues, privacy issues, and so on. So it's better to have Zoom platform for remote court hearings and then to provide all the records also in the ecosystem. So that was the idea. And for example, for universities, so we use mostly Microsoft Teams, but for courts we use Zoom platform.
I would like to refer to this question. You?
I think this is a very good question, but it's also one that sort of displays the illuminates the realities of Europe. Norway has more than 95% of the population has access to a high-speed internet. So everywhere you expect people to actually have the equipment, know how to use it, and then it's only a small percentage of the population that has a problem. And also when you have courts that are like the Ritz, it's open to all, but most people have no chance of accessing them. You also get rid of the problem of self-represented litigants, or you push away the problem to other organs of the justice system. But then public libraries are a key function, and this is also very much the reality in the rest of Nordic countries. So also from schools, you just ask, you try to find the few pupils who don't have high-speed internet, who don't have access to a computer at home, because they're the minority in most schools. And when it comes to the platforms, we have, it took just 2 months to develop a platform for courts. They had been working on it for 20 years, and suddenly we got this fast forward. It's not perfect, and it has problems. We still have some courtrooms, almost all courtrooms have access to this platform, but still only less than half have access to the one that actually makes a recording of what's happening there. So we have this dual system, but I think this really illustrates also the problem in many countries. From the study we saw that you develop these systems for years and years and years and nothing happens, it's too complicated, then comes the pandemic and then whoops, there you have it. Might not be the perfect one, but perhaps we've previously been aiming too high, and something more makeshift does the job. Thank you.
Thank you. Professor Jakubecki.
Sorry, according to Polish regulation, on the motion of a party to the proceedings or participant, court is obliged to organize for him to attend in an online hearing in the court, building court, equipped. I am not aware of the fact if any works on new platforms are concerned. Maybe Dr. Żółtek will tell us if there are any works on it. So no progress so far.
Okay, thank you. Are there any other questions? Professor Andrzej Olasz.
Thank you very much, Andrzej Olasz from the Jagiellonian University in Krakow. I would like to ask Professor Webreiter about the digitalization of court files, because this is a process which in Poland is still before us. So I wonder how it was actually achieved in Lithuania in terms of technical aspects. For instance, in situation in which the parties are submitting their pleadings like a lawsuit and reply to the claim in the paper form. Precisely speaking, because in Poland there was an idea that to make it simpler for the administration of justice, the parties could be obliged to attach to their pleadings the electronic copies of their pleadings. So it was an attempt, an idea to take off some of the hard work from the staff of the court just on the parties. So this is my question, how this was achieved and whether it was difficult from the perspective of the staff of the court to take care of this whole work of digitization of court files. Thank you.
Thank you. So the idea is that actually the employees of court have to do it. If we send it by paper, so we have to digitalize by themselves. Of course, in most cases, so mostly now all documents are sent digitally, so there is not a problem. But if the party sends it written, so the court can ask to provide you also an online e-copy, but it's not an obligation. We just also can ask for the help if we need it, but at first perhaps there were some problematic issues, but I don't think it's now the most problematic issue, so everybody is quite good, and of course in quite many cases, so there are representatives of parties, so lawyers or assistants of lawyers, so they are quite used. We have good access to computers and to databases, and we send it everything electronically. But of course, there can be cases, quite problematic cases, but it's more an exception.
Thank you. I would like to ask the next question. Yes, please.
Okay. Bogdan Jędrys, judge from Krakow. The thing that interests me is how you save, how you protect these digitalized acts from the invasion from the unauthorized people. For example, let's imagine a situation in which the court proceedings are ended, all is stored, these data which are included into these files are stored. Where are they stored? How you try to prevent this from invasion from the unauthorized people, from, for example, Ministry of Justice, data collectors, all this stuff. What are the safeguards? What are the core safeguards just to prevent such a activity? Thanks a lot.
Thank you. So I'm not like a computer science scholar. I do not know all the details, but so Liteko in Lithuania has like two platforms, I could say, two models. One is like in a circle, only courts and participants to proceedings can enter it. You have passwords, and you can enter all the information. And the other part, like Liteko 2 or something like that, it's for all the public. So, but of course for all the public, so you can get only statistics and only like judgments after the judgments who are already in force. Yes, so I think there are some cyber security experts, and we work on that, and we safeguard the systems. And of course, Minister of Justice does not participate in this creation of the systems. It's the work of our National Court Administration and Council of Judges to organize the system. And we get the funding, and they provide like services, and they pay for these services, they got funding and so on. So Ministry of Justice does not participate in this creation of a system.
But furthermore, what about the procedures which allows you to destroy this data? Are there any? Like we have destroyed the paper files. Are there any? Because in the internet, it exists till the end of the world. what are the procedures to destroy this data, which are very sensible and can be really dangerous, just storing this kind of data? Are there any procedures?
I really cannot say. I'm sorry. I don't know. Yeah, of course it's.
Professor Nylund?
I have to admit that I have no idea. And you can say, okay, she's just an naive Scandinavian, and that might be the case. I think there are good reasons for why we don't know this, because they don't want us to know how this is done. But then again, I think so far we've managed pretty far. But I think there was a recent study on attitudes and trust in digitization in European countries, and you see there are huge differences. And the Nordics and the Baltics are, we trust in this, we believe in this, and I don't know if it's worth our trust, but.
And I can add a bit that after the war started in Ukraine, so the systems are, how to say, safeguarded double or triple. We have double passwords for most of systems and so on. So I think cybersecurity experts work on that and try to work on that constantly.
Professor Andrzej Jakubecki.
Let me put it this way. We've just been given a warning. Don't do it. Don't digitalize the files. Thank you.
But I think we should digitalize. I'm originally from Finland, and the country that once it joins NATO, then NATO will double its border to Russia, and a country that's got its electricity and gas shut down from the Russian side just recently, and is prepared and regularly experiences attacks. But still, I think there too the system works, so I think there is a way of making it workable, and I think these attitudes towards digitalization are really interesting and explain some of the differences, I think, because if you compare the Nordic countries to Germany, which were in many ways quite similar, you see that the attitudes are very different in Germany, and then you also see that the infrastructure is also very different than what it is in the Nordic countries, and the Nordic countries have now seen themselves bypassed when it comes to digitization of the Baltic countries.
Okay, yes, please.
Thank you. You just mentioned the attitude that is quite different, and that's good for a question that I have. What is important is always how is the acceptance by the people who come to court. And in civil law, I think you see very much if people accept the way courts work or not. So I would be interested in those countries of you who have this high level of digitization in civil law. Could you see over the years an increase or a decrease in number of cases brought to court? Could you see the number of cases, the kind of cases that are brought, that the acceptance is there by the public, or that the acceptance is even higher than paper file court work? Do you have any statistics on that? Or other reactions from the public?
Okay. Professor Nylund?
I can only quote a Danish judge who was very much involved in the project of creating a digital case management system in Denmark. And this comment is from pre-pandemic times, and she said that the Danish public, if they wouldn't be able to file everything digitally, they would think, what kind of organization is this that doesn't have digital services? Is it worth our trust? And why do they want to make things so difficult? And I think that reflects it. But we have no studies of how people perceive this, but generally people expect fully digital services and if not, then the courts will not meet their expectations. And this has been a problem in Norway, that the courts have not been sufficiently digitized.
Okay, we have connection with Professor Inhausti, and I have a question to him. No connection. Okay, is there any question? Any other questions? Yes, please.
Thank you. I was not planning to speak, but I didn't resist. Well, let me tell you two different things, quite different. The first is that I don't, as I told Tuduru, I don't remember to see a paper file for more than 4 years. I'm a Court of Appeal judge. We have everything digitalized in Portugal. I don't have even the memory of seeing a paper file, a judicial file. So you can see how the level of digitalization in my country. And on the other side, I am very concerned with some of the issues that Professor Anna put it forward. For instance, the performance of witnesses when they are in trial, what is a real problem. If you have everything streamed, you will have like a theater and not a court, a trial court. The other thing is the excessive information, because if you publish everything, nothing will be useful. And we are facing this problem also. We want to have transparency, and at the end, we don't have transparency. We have excessive information that is no information. And it's easier to have fake information. If you put doctor in a screen and say that the vaccines have a chip from Soros or Bill Gates, you will have 3,000 people checking the YouTube video. If you are a doctor and explain the advantage of vaccination, you will have 300 people listen to the video. And this problem of expertise or the excessive information and how to filter information in a valuable way, it's a problem also for courts and for our rulings. And so this is the mixed feelings that I want to share, and to thank you all for all the contribution that you did.
We have the question from the chat. I'm reading in Polish. Czy to jest powszechne, około 100%, oczekiwanie w Norwegii na scyfryzowanie sądów, gdyż wydaje mi się...
Because I think that in Poland, generally the citizens are not aware, or even the professional attorneys are not to such high extent supported. Profesor Anna Nylund, czy odpowie Pani na to pytanie?
I cannot guarantee that it's 100% support for digitization, but I would say it's very high support, and nobody wants to go back to the paper files. And attorneys and judges are so happy that you don't have to have this wheelbarrow with files in a huge civil or criminal case. And I also think even before the pandemic, we heard expert witnesses usually remotely, and nobody wants to go back to that. Nobody wants to cancel hearings because there's a closed road somewhere and the witness cannot meet up in the courtroom. But when a witness can testify remotely, so I think there is basically very uniform support for digitization.
Thank you. Okay, yes, please.
Same as Jose, I can't resist a little bit to curb the enthusiasm. I think also digitalization depends on the culture. For example, in my country, if you buy Teslas to everybody, they will not obey the traffic rules. So the same goes with the court proceedings, and in many countries it is not seen as a problem to lie before the court. In my country, they have a hearing, 2 witnesses, and the cow is ours. So it also goes with that, and the hearing and the collecting evidence is controlled event, and with huge digitalization and remote hearing, you're losing that aspect. And perhaps it should be a little bit taking cautious about how to proceed in these issues, especially having in mind how the things are working in different countries. That is not for this meeting, but perhaps for those who are making rules for whole European Union in Brussels to think about that. And another issue which nobody answered yet on different meetings, and how much the judge of the appellate level needs to study a case when it is online or when it is in a paper. Is there any research on that basis? In my belief, I think we have some small cases now. In digital, it is much more time consuming to check everything when it is online, when it is in paper. So perhaps we are chasing a wolf and the bear will come out of the woods.
Okay, thank you. We have the next question from the chat. I'm reading in Polish. It is the question to Professor Anna Nylund.
Question to Anna Nylund. If the witnesses in Norway, if they testify, do they testify from their place of residence, place of work? And the second question, how it's verified that they are not subject to any influence?
This is a tricky one because usually if it's an expert witness, like a doctor, they would of course testify from their office. And then during the pandemic, things got really wild. Of course, you had to allow people to testify from their homes. But now we want to see more restrictions, and there's this discussion, should we have local offices where you could meet up to testify? It could be a government, so mixed service office, for instance, in smaller villages. Or you could ask them to meet in their local court if they cannot go to another court. Or you could ask them to meet up in lawyer's office or somewhere, so you could control the environment. But it depends a little bit also on the witness. So if this is somebody who testifies in a professional capacity, then more lenient rules could apply. Like a law professor, you could allow them to testify from their office. But it's a tricky question but this existed already before the pandemic. When you call them up, you had even less control of where they were. They could be like in Spain on holiday or something.
Thank you. Are there any other questions? Okay.
Ja mam pytanie do pana
I've got a
profesora.
question to Professor Jakubecki. I've got a question to Professor Jakubecki. Here we do not talk too much about the influence of the pandemic on the enforcement procedures, but I wanted to ask one question referring to quite surprising change, which was adopted in connection with the Act of the 8th April 2020. This is the Act amending the Act on the support to the citizens of Ukraine. And there was two significant provisions were repealed. It's withdrawn. Article 1952 with Index 1, Paragraph 5, which banned licitations of selling immobilities, real estates, and this provision was withdrawn with reverse date. So this means it was repealed, withdrawn on the 15th of April with the date 24th of February. Second provision which was repealed, withdrawn, is the Anti-COVID Act, COVID-19, Article 15 ZZU, which banned the selling licitation of real estate. And all these protection periods foreseen in that act were cancelled, 90-day of or yearly protective period. What do you think about this, Professor? As for the idea or as for the implementation? I mean the idea and the implementation, but more I mean the style in which this was introduced. Yeah. I mentioned in the beginning about the fatal legislation as for changes, COVID changes. This is one of the many examples where legal provisions are written like fast, without taking into consideration systemic reflection. And then we have such examples, curiosities, and also the justification. I don't know the justification for this novel, for this amendment. I have not been dealing with it, but the justifications are frequently so simple that it's even difficult to, they're so strange, it's difficult to understand the sense. I don't understand the meaning of these changes, amendments. But in the technical sense, retro actions, reverse actions, and destroying earlier consequences is absurd. I cannot be more detailed in these problematics. No microphone, no microphone. They don't want to see any sense that there is no temporary provision. I've been trying for a long time, and this provision which bans the auction selling was repealed, withdrawn with one day vacatio legis. But this one which banned throwing people out of their flats was with a reverse date. Some of them trying to think, what did the legislature want to obtain? Of course, you cannot perform an eviction, auction a reverse date, but is it an example of extreme lack of diligence from the side of the legislator? You cannot find sense where it's not present at all. So this is a task which was deemed to be unsuccessful from the very beginning. This short vacatio legis, and just moving away from the COVID acts, let's look at what's happening with the intertemporal provisions in any novel, in any amendment. The amendment of the KPC, after all, 2019, this required a manual to sit and think what would enter when, what would be suspended, what will be late, what would enter a month later. We cannot do intertemporal provisions like that. It's shortening the absurd vacatio legis period to an absurd. Vacatio legis has a certain function to play after all. Surprising. I would like to say the recipients as all, as people subject to this to law, with regulations that are kept until the last very moment secret so that nobody would criticize them in advance. All this is this fatal, horrible legislation. And an example which you, sir, have mentioned is extreme. It's extreme. It's gross. I have to say, perhaps the author knew what they have in mind, but this thought absolutely was not expressed in that. Thank you.
Thank you. Any other questions?
Thank you.
Yes, please.
Wojciech Wójcik, sędzia Sądu Powszechnego.
Judge of the Common Court. I've got a very quick question to our participants from abroad, our kind guests from abroad. Here in Poland, we've got various strange institutions in KPC. Nevertheless, we've been discussing here statements of witnesses. Is there something like a statement of a witness in writing? Is it used in your countries? If there is something like a witness statement in writing, how it is received in your countries? Because it's, I would say, an institution which, in our case, allows for submitting the statement in writing to the witness. How does it function in your case? Do you have anything like that? How do you cope with it? Or possibly can the parties state in writing their declarations which have the nature of proof? Thank you. Kto chciałby odpowiedzieć?
So in 2017 it was a great procedural reform in Ukraine. And almost all our procedural codes was changed. And in civil procedural code, new institution of written statement appeared. And some of provisions of this institute are seems to me very funny. For instance, we have some like rule to write 10 questions to the witness. So you can imagine, as a scholar, how we can, combine these questions into these 10 within this obligation. But anyway, it's not very popular still in Ukraine, and I don't have any. I have no any idea about criminal proceedings, unfortunately.
Okay, thank you. I have a signal from organizers that we should go to the end of this panel. So I'm closing this part of our conference. Let me say thank you very, very much to all of speakers and to all debaters, of course. On behalf of organizers, I'm inviting you to the lunch. The next panel will start at 3 p.m. Thank you.
Ladies and gentlemen, I warmly welcome you on the second part of our conference today. The moderator in our panel will be Professor Karol Wajc, the judge of the Polish Supreme Court from University of Warsaw. He will join us remotely. Serdecznie witam, panie profesorze, i oddaję głos.
We welcome you, Professor, and we have to give it the floor.
Dzień dobry Państwu. Witam Państwa wszystkich serdecznie.
Welcome all of you very warmly. The organizers have made a risky decision and have entrusted me moderating this panel, which the influence of COVID on the course of the civil proceedings. I'm sorry for not being present with you physically, only remotely now. You know, this is not conditioned by the pandemic, which is mentioned, which, as we all know, has ended, but my health condition, I'm so sorry for that. Nevertheless, I hope that we shall cope with this virtual way, online way. In this panel, we have got two presentations of two respectable professors, Professor Remko Wadrę from the University of Maastricht and Professor Zdrański from the University of Warsaw. I shall not prolong my introduction. Please allow me to kindly ask the first professor, Mr. Wadrę, Professor Wadrę, for his presentation and his speech. Professor, the floor is yours. 25 minutes for you.
Ladies and gentlemen, dear Karol, it's a pity I can only see you in a digital way, but maybe that is something that fits the theme of this conference well. Thank you for your introductory words. Ladies and gentlemen, I first would like to thank the organizers of this conference, including the friends from Ukraine and Lithuania, who all invited me to address you at this meeting. It's a pleasure to be here. The circumstances are, of course, very sad, looking at what is going on in the home country of one of the organizers. And we would hope that things were different, but reading the news, I'm not very optimistic at this moment, and I think we probably agree about that. But let's have a look at the topic of today. My paper is called The Impact of COVID-19 on the Principles of Writing and Orality and on the Organization of the Procedure in Comparative Perspective. That was actually what the organizers asked me to do. But before taking you to COVID-19 and civil procedure, I want to trigger some memories from law school, because I think that many of us will realize that our modern procedural systems have a long history of trial and error. Our systems, they originate in the high and later Middle Ages, and what is especially important is, of course, the so-called Romano-canonical procedure, the Romano-canonical procedure, which is the mother of all civil procedures on the European continent. It was a procedure that was present throughout Christianity in the Middle Ages, and it was implemented at the court of the official, a new court at the time. And this Romano-canonical procedure really meant a break with the past. The procedure aimed at the rationalization of litigation by implementing a written procedure, a well-organized procedure, a procedure that was organized piecemeal. You remember the small steps that procedure prescribed, something that we are not very much favorably disposed to nowadays. A series of short hearings over a long period of time, and the idea was that would guarantee quality, because people could think about the lawsuit and think about the arguments that were being raised. But the main shortcoming of this model is, of course, that it is not fit for handling large volumes of cases. And that is very problematic, and that is still clear in our modern days, when we look at the biggest problem of the civil procedural systems in many European countries. It is the problem with the reasonable time requirement of Article 6 of the European Convention of Human Rights. That problem, reasonable time, I think is one of the most litigated cases in the European Court of Human Rights. So we have problems with the reasonable time requirement and we have overburdened courts. And in addition, I think that in some jurisdictions it's felt that the costs of the administration of justice have spiraled upwards too much. Now, both the reasonable time requirement and the spiraling costs of litigation has made that jurisdictions all over Europe, but not only in Europe, even outside Europe, of course, have looked for a way to modernize the administration of justice with the help of modern technologies. And that's what we've seen this morning as well. And this approach, by the way, is also not very new. The phonograph, I'm not sure if everyone still knows what that is, but the phonograph, the telephone, the telegraph, shorthand, and later on the telex and the fax machine, which is in the Netherlands still being used, are all examples of approaches to a more modern civil process. And at the moment, of course, it's very fashionable to talk about digital document exchange platforms, digital document sharing platforms, video conferencing through the internet, and so on, and so on, and so on. And now we have seen that COVID-19 has resulted in an enhanced interest in modern technologies. But we also know that this interest was not brought about by the wish for more efficiency in the administration of justice and lower costs, but of course mainly by the wish to overcome the limitations of social distancing. The need for social distancing endangered the continuity of the administration of justice, as well as access to justice on a global scale. Indeed, the question became what to do about it. How can we guarantee continuity and access to justice? Methods that had previously in some jurisdictions been used to make litigation more efficient and more cost effective were used for other reasons during the pandemic. The question how fundamental principles of procedure could be safeguarded while using these technologies was not so high on the agenda, because we were confronted with an emergency situation. Now, since the need for social distancing apparently is at the moment less pressing, it may be time to reconsider the technologies that have been introduced in the past few years for reasons, as I said, for social distancing, to determine whether they can be used in a civil lawsuit while at the same time observing fundamental procedural guarantees. And we could even maybe look at whether these new technologies should be maintained, because maybe they can indeed result in savings in money and time, and thereby making justice more accessible. I think, when I'm listening to what you've been telling us this morning, that the new technologies most likely will have to function in a procedural landscape that is not very much different from the times before COVID. It's of course very exciting to think about new procedural models accompanying the introduction of various modern technologies, but I doubt whether these models will be introduced in the short run. And that is maybe due to the fact that most of these new technologies we have introduced are serving the usual purposes. They are serving purposes, I think, to a large extent that can be compared to paper and writing. We want to make a record of the case, and we want to allow oral hearings. So whether the new technologies are being used in a very creative new way can be doubted. Of course, new technologies sometimes allow different uses. For example, where it concerns instant communication in writing. Now, of course, we can exchange emails right away. But I'm not sure if such instant communication will be possible if a lengthy and complicated legal message, such as a statement of case, a claim or a defense, will have to be answered by way of a counter statement. Furthermore, claimants and defendants working online on the same document, something that I think Anna Nylund mentioned this morning. Well, I feel that may also be problematic in an adversarial environment, where the various points of view of the parties have to be kept separate, or at least separable, in order to be able to get a clear idea of their respective legal and factual points of view. I think that another approach would endanger the observance of rights such as equality of arms, since a joint document would not allow the judge to disentangle the respective contributions easily, if this would appear to be necessary later in the lawsuit. So it seems, therefore, that to a large extent our existing model of civil litigation will remain. Now, what is this model? That's very difficult to explain here, because, of course, every jurisdiction in the European Union has a different model. But maybe I could talk about some best practices that have been identified in the model European rules of civil procedure, drafted by the European Law Institute and UNIDROIT. I've myself been involved in that project. I think that the best practices we identified provide for a procedural model that consists of several distinct stages. The first being pre-litigation, or maybe pre-action, as the English call it. And that is a stage before going to court, where the parties have to adopt what Lord Woolf in England and Wales called a cards on the table approach. Before going to court, parties have to get together and exchange information. They have to exchange their point of views. They have to discuss the evidence that is available. And that may then either result in a settlement, that's the preferred approach, so then the court is not needed at all. Something I think that is very important, because of course one way to deal with overburdened courts is keeping cases away from the courts. If the dispute doesn't need a judge, if the judge is only there for administrative purposes, I think the case should not even go to court. Now, Lord Woolf was also of that opinion in England and Wales, and what he introduced is this stage in which the parties, before they go to court, discuss matters with each other. They have to follow a certain pre-action protocol. And we feel in the model rules that this is, of course, a good approach, reducing the number of cases, and not fighting overburdened courts by way of technology to start with, but maybe first by introducing obvious, how would you call them, administrative measures. Now, the pre-litigation stage is followed by what may be called a stage for initiating the action and pleading. The French would call it exchanging the conclusion, exchanging the statement of claim, which is usually part of the summons, the defense, a stage in which also the evidence is being brought forward and discussed. And that is crucial, that stage, we feel, because in our model there is a main hearing. Haupttermin, the Germans would call that, but that needs to be prepared very well. That stage is mainly a written stage. When you go to France, you'll see that that stage is being executed by way of digital technology. In the past, of course, there would be a session of the court called the rôle, if I pronounce it rightly. I'm always having difficulties pronouncing French when I'm speaking another English. But the rôle, let's say the court case hearing, in which the parties would take steps in the procedure that were mainly, and that are mainly, from an administrative nature, submitting your defense in writing, maybe discussing the court or the case calendar, I should call it. That stage, of course, is easily to be organized in a digital format. And I think there are very few problems here from the perspective of fundamental procedural guarantees. You're basically using the internet as you were using writing and paper beforehand. And why not? What is against such an approach? That stage now is followed by, of course, a main hearing. And I think I should take you to the main hearing in order to see what problems may arise. But before I take you to the main hearing, I should maybe say something else. When considering to what extent modern technology can be used in the various stages of a lawsuit, we have to ask ourselves which principles are at stake. Obviously, there are the ones that have been formulated under Article 6, especially fair trial or fair hearing has been a very productive starting point for the European Court of Human Rights to develop fundamental principles. But I think there are other principles we also need to address. And the first principle I would like to mention is the principle of proportionality, and the other one is the principle of cooperation. Let us have a look at the last one, cooperation. That means that the adversarial nature of a civil lawsuit is reduced because the parties are required to cooperate with the court, and they're also required to cooperate with each other in order to obtain a speedy and just decision of their dispute. And when you read the European Law Institute model rules, you will see that actually the judge has various sanctions available in order to make this happen, because of course naturally parties might not be tempted to cooperate that much. The other principle is of course proportionality. That's also an important principle, and I think I will touch upon that principle in a minute, because that principle allows us to decide sometimes that the best possible procedural solution for a certain stage in a lawsuit doesn't always have to be chosen. We may opt for second best or third best. Lord Wolf said, well, not each civil case needs a Rolls-Royce. If you're litigating about a small claim, a very heavy evidentiary procedure is of course maybe sometimes too much. And proportionality now says, well, you don't have to choose the best possible solution. You need to find a solution that is proportionate to what is at stake in the lawsuit. And Lord Wolf even said, you also need to look at the case load of the court in general. What can we do in this individual case, taking into consideration the other cases that are being pending and that need to be handled? Okay, we go to the main hearing. In my opinion, this main hearing poses challenges where it concerns modern technologies, since the main hearing is of course traditionally envisaged as a concentrated event where ideally the parties and their lawyers make a court appearance. They come to the court, they get their day in court, and where the case is then orally argued before judges who in our model exercise considerable case management powers. In addition, the main hearing is a place where witnesses are being questioned. Even witnesses that appear in the court file by way of a witness deposition can be questioned if the parties so ask and if the judge allows that. So a witness deposition, a written witness deposition, will stand unless challenged by one of the parties. From the perspective of fundamental rights, difficulties arise when the main hearing does not take place physically in a courtroom, but wholly or in part by way of distant communication, and that can be writing, audio, video, or a combination of these. And some questions that may arise were formulated by Anna Nylund and Bart Krans, who published this very interesting volume on civil procedure and COVID-19 in, well, actually last year, 2021. Anna and Bart asked themselves, for example, does remote attendance influence our perception of a witness or party, and if so, how? is something essential lost if non-verbal language is reduced in remote hearings? Do the background, the angle of the camera, lighting and other factors influence whether we consider the witness trustworthy? Now, they have more of these very relevant questions, and I think that these questions should be evaluated from the perspective of fundamental procedural guarantees, such as access to justice, fair hearing, public hearing, reasonable time, etc., etc., etc. And it seems that the fair hearing requirement is one of the main fundamental rights that is at stake, where it concerns the questions that are raised by Anna and Bart Krans. Actually, I think that especially hybrid court hearings are problematic. And hybrid court hearing is, of course, a hearing where, for example, one party joins online and the other is present in the court. I think that is not advisable from the perspective of equality of arms, because the impression that a party who joins online makes is, well, most likely very different from a party that is in court. So if you have such a hybrid hearing, serious questions, I think, arise as regards equality of arms. But that doesn't mean that distant hearings cannot be organized. In light of the principle of proportionality, for example, it might not be a problem if a court hearing of lesser quality than a physical hearing would be scheduled in order to save costs and time. But one should then make sure that none of the parties is in a better position to argue its case than the other party. And so hybridity, I think, is problematic here. If you decide, well, both parties are being heard from a distance, then most likely there is not an issue with the fundamental guarantee of equality of arms. You could also think about publicity. That's also something we have discussed this morning. I think it should first of all be remembered that this fundamental right of publicity serves the purpose of allowing the public to be present at a court hearing in order to scrutinize what's going on in court. It's a kind of control function, checking what is going on in court. And the possible presence of the members of the public is deemed to remind judges of the necessity to observe the applicable rules and regulations. People can enter your courtroom. And that right, I think, does not require that court sessions are accessible to the public at large by way of public broadcasting or by way of streaming, I think, is the modern approach to matters. I think it would suffice that a limited number of those who are interested are provided with a video link to observe what's going on in court. A limited number. And a limited number is enough, since physical access to the courtroom itself is obviously also limited to the number of seats that are available in the public area of the court. And that restriction has not posed any problem whatsoever, I think, as regards the principle of publicity. So why not do something similar in electronic hearings? Well, I have much more I want to tell you, but I'm looking at my watch and I should maybe come to a conclusion. The written text, which is apparently going to be published, will contain, of course, much more, because I cannot address all the important issues right now. But what I wanted to say as a kind of conclusion is that, well, throughout the centuries, the efficiency of our continental procedure has been enhanced by various structural reforms and also by the use of modern technology. We've seen this already in the 19th century. Shorthand, that's probably early in the 20th century, was introduced. And so this is not something very special. I would say what is going on right now, well, that can be put in an historical perspective, and then you're not surprised anymore. And all that was needed because of the shortcomings of the original Romano-canonical model, this historical model, that was not fit for handling large volumes of cases. Modern technologies are also central during the COVID-19 pandemic, but that is not for reasons of efficiency, but because of the need of social distancing. And due to the emergency situation, modern technologies were implemented in order to make sure that the administration of justice would not come to a halt. At the moment, when social distancing seems less urgent, I think that we should ask ourselves which of these technologies can be maintained in the civil process without endangering fundamental principles of procedure. It seems that the discussion should not focus on the relative quality of an exchange of information on paper or through the internet or, or during a physical court hearing or online, since the principle of proportionality in civil litigation does not prescribe that the best solution should always be used. One should concentrate, I think, on a discussion of principles like equality of arms and the publicity of the hearing. Equality of arms, for example, may become problematic. I've seen that if court hearings are hybrid. And publicity, well, does it become a problem when we have a virtual court hearing? I would say if you distribute links to those who enroll for listening to what's going on in court, then you don't probably have a problem, just as we are not having problems by having a limited access to the courtroom when there is a physical hearing. Now, once again, only two examples. Much more can be said. I thought I take these examples because they have been discussed to a certain extent this morning. I very much hope that this is helpful, and I'm very much willing to answer questions during the discussion. But for now, thank you for your attention. Thank you.
Pana profesora Piotra Ryskiego.
Now I would like to ask.
Thank you very much, Professor Weitz, for giving me floor. Thank you also for our hosts, especially for Katarzyna Gajda-Roszczynialska, for inviting me for this splendid conference. I would like to tell you something about the organization of the civil proceedings in Poland. You see here the presentation plan. The most important elements of this schedule is this introduction and conclusions. This is the traditional schedule of presentation, but I would like to focus on some very detailed issues related with organization of Polish civil procedure. As you know, recently Polish legislator undertook a major change of the Polish CPC provisions by implementing the Act of the 4th of July 2019. This act has been generally in effect since 7th November of 2019. It is a fundamental change for the course of the fact-finding proceedings, both before first instance court and second instance court. There have also been major changes in terms of the organization of the civil proceedings, particularly in relation to the preparation of the case for the review and the new role of the court as a manager of the proceedings. Even though the amendments implemented in 2019 were not related to the COVID-19 pandemic, the pandemic was a real test for procedural solutions were implemented. It proved their benefits and revealed their shortcomings. On the other hand, the pandemic also led to a change in our perception of the principal procedural rules and the existence of procedural solutions. In particular, there arose a need to consider the possibility of using the existing solutions under procedural law in order to mitigate the negative effects of the pandemic. The changes made in 2019 have also provided a good opportunity to do so, and there are multiple new solutions require a separate in-depth analysis from that perspective. The purpose of this presentation is to point out to new mechanisms relating to the organization of the proceedings, which could be of use when alleviating the consequences of the pandemic for the civil proceedings. It is also to determine whether or not those regulations may be of help after the pandemic as universal solutions.
I would like to start with the written preparation of the case. The issue of speech and writing, of course, in the civil proceedings has long been a classic issue of the civil proceedings theory, also from the comparative perspective. Over the last few years, there has been certainly a general trend to limit the orality of the proceedings and to put more emphasis on writing. This applies in particular to the preliminary preparation of a case called the pretrial proceedings. As for the Polish civil proceedings, we can now say that there is a separate written stage of the case preparation. It results from the duty implemented as of 2019, whereby the presiding judge is required to call on the defendant to submit a statement of defense. Up until 2019, it had been practically up to the defendant whether or not she or he wished to submit a statement of defense. In general, there had been no negative consequences to the defendant for failing to submit such a statement. Article 205 with the Index 1, paragraph 1 of the CPC was implemented in 2019, whereby the presiding judge shall order the service of the statement of claim to the defendant and calls on the defendant to submit a statement of defense within a prescribed deadline, which shall not be shortened than 2 weeks. However, the legislator also implemented a clear sanction for the defendant's breach of the duty to submit a statement of defense in the court may give a default judgment, and that is the most important aspect of the amendments. While giving a default judgment in the event of the failure to submit a statement of defense is optional rather than mandatory, the courts frequently take advantage of that option in practice. A default judgment is enforced immediately, therefore the claimant may commence the enforcement of the claim before the judgment in the case becomes final and binding. It needs to be also kept in mind that the statement of claim and the statement of defense are not the sole instruments used for the preparation of the case for trial. Where necessary, the presiding judge may order further exchange of pleadings between the parties and prescribe the sequence of the pleadings, the deadlines, and their submissions, and the facts of the case that need to be clarified. The above changes allow us to conclude that a model of the written stage of the pretrial proceedings has been introduced to the civil procedure in Poland. It is mandatory in the case of the statement of claim and the statement of defense. As for other pleadings, it is at the discretion of the judge preparing the case, called the presiding judge. Overall, the isolation of that stage is a positive change. The same can be said of the issue of a default judgment, which is to discipline the defendant and make the defendant present their stance in the case. Written preparation of the case may accelerate the case review, particularly in the wake of the COVID-19 pandemic. It allows for faster accumulation of the procedural material and proper preparation of a court session. However, it is also argued that it involves certain risks relating to the limitation of the openness of the proceedings and that it restricts the contact with the court. It is obviously necessary to create an effective mechanism for the service of court pleadings in order to ensure the effectiveness and efficiency of the written stage of the procedure. As you heard morning, unfortunately, such a system has not been created in Poland yet. As a consequence, any correspondence between the court and the parties and their attorneys is exchanged by traditional mail. This prolongs the stage of the proceedings considerably and adds to the costs. Now I move to the topic of the preparatory meeting. The Act of 2019 also implemented a new solution, notably a preparatory meeting, which is supposed to precede an open hearing, regardless of the written preparation of the case. However, that meeting may also mark the end of the proceedings, in the way of settlement, for example. Under the Act, that meeting is a mandatory stage of the proceedings. The presiding judge may resign from the preparatory meeting only if such a meeting does not help to make the case review more effective. During the preparatory meeting, the presiding judge determines the subject of the dispute together with the parties and clarifies the standpoints of the parties, including their standpoints in regard to the legal aspects of the dispute. There have been multiple reservations formulated in the legal doctrine in regard to the concept of the preparatory meeting and the role of the presiding judge. However, there are no doubts that the solution is yet another manifestation of efforts to strengthen the role of the presiding judge, who, in addition to the written preparatory stage, has been given the ability to co-manage the case together with the parties to the proceedings. The need to carry out such a meeting is of particular importance in complicated matters where the question of facts and questions of law are complex and where it is necessary to take multiple pieces of evidence. The usefulness of the preparatory meeting in the wake of the COVID-19 pandemic has not yet been noticed in practice. It was probably caused by the fact that the period between the enactment of that regulation and the peak of the pandemic was rather short. It seems, however, that applying an informal approach to the relationship between the court and the parties is reasonable in the wake of crises such as the pandemic. It facilitates the preparation of the procedure and the contact with the parties. However, it is questionable whether or not such a meeting needs to be carried out in each and every case. It should be at the discretion of the court whether or not to take advantage of that solution in a given case. Next topic, this is the trial plan. Because according to the current regulation, the main goal of the preparatory meeting is for the presiding judge and the parties to prepare a trial plan and to take actions to reach a settlement deal, if any. The trial plan is a special procedural agreement that in general must be signed by the both parties of proceedings. However, that document is made under the supervision of the presiding judge, who has the duty to approve it once it has been signed by the parties. In the trial plan, the parties should agree on the evidence to be taken in the case. In that regard, it replaces the court's duty to issue evidentiary decisions. In addition, it may contain other elements like exact description of the subject matters of the parties' claim or even the dates of hearings. It is not frequently the case that the parties enter into a trial plan in practice. However, it is a step towards reinforcing the role of the parties in the management of civil procedure. Therefore, it fits into a global trend of admitting procedural agreements between the parties. Therefore, since the agreements rely on the parties' will, it is more likely that the parties will deliberately act on them, unlike on the writs of orders of the court. This trend derives from the experience gathered in the course of arbitration proceedings. However, it goes without saying that in practice, such agreements may be concluded only if there are professional representatives, where we've got attorneys involved. It also applies to cases of a greater rank. It may be added as a side note that the so-called evidentiary agreement, which may be concluded by the parties in a separate procedure in commercial cases, is another type of procedural agreement implemented by the legislator in 2019. Unlike in other countries, the scope of such an agreement has been defined in a relatively narrow manner under Polish law. Due to the narrow scope of the said procedural agreement, it is not too popular in the courtroom practice. Now a couple words about the possibility of giving judgment without a hearing in Poland. Because the possibility of giving judgment in closed court has been expanded in the Polish civil proceedings for quite some time, which is also the case in other legal systems. While this option is subject to criticism in the legal doctrine, it has been a steady trend of changes in the civil proceedings. It has been criticized because giving judgment in closed court, along with the written pretrial proceedings or preparatory meeting, may lead to a complete elimination of a hearing as the forum for reviewing civil cases. The court may review now a case in closed court when a defendant admitted the claim or when following the submission of the pleadings and documents by the parties, the court decides that holding a trial is unnecessary. Thanks to the solution discussed in this point and upon completing the written pretrial proceedings, the court may be able to give judgment without hearing the parties to proceedings in person. The need to take evidence in the form of witness testimony or the need to question the parties during the hearing is frequently a major obstacle preventing the court from giving judgment in closed court. However, as you heard this morning, since 2019, it has been possible to take evidence in the form of written witness statement, which may help courts give judgments without a hearing more frequently. The ability to take advantage of such an option is of particular importance during the epidemic threat caused by COVID-19, as it allows for limiting personal contact between the court and the parties and witnesses. However, it is viewed negatively in terms of the openness of the proceedings. There are also concerns about the fairness of the evidentiary proceedings. A couple words about informational activity of the court. While discussing the organization, informational activity. While discussing of the organization of the proceedings, it is also worth noting provisions implemented in 2019 to increase this informational activity of the court. This refers to instruments used by the court to update the parties on and to explain the current status of the case or to indicate the possible legal grounds of the verdict. You see two solutions. First one, this is Article 156 with the Index 1 of the CCP. If needed, the presiding judge may advise the parties during the hearing of the possible outcome of the case in the light of the assertions made and the evidence submitted up to a given point. The provision is to enable the parties, usually not represented by an attorney, to evaluate their chance of winning the case at a given time. It may happen as a result that a party will present new facts and evidence or decide to withdraw the lawsuit or limit their demands. This competence is reserved for the presiding judge and not for the court, which means that it may also be applied during the preparatory meeting. The other regulation is in the Article 156 with the Index 2 of the CCP. According to this article, should it transpire during the hearing that a verdict regarding a party's demand or request may be made on a legal ground other than the legal ground indicated by the party, the parties attending the hearing are advised of such a possibility. This regulation is to protect the party in accordance with the case law of the Supreme Court from adverse consequences that might arise for the party if the court makes a different evaluation of the legal ground of the party's demand. As such, it is to avoid a situation where a party is surprised by a legal classification, legal interpretation maybe, that the party had not previously considered in the course of the proceedings. It can be concluded that both the above regulations are right solutions. The case management by the court is not only about managing the course of the proceedings, but also about advising the parties of possible consequences. By giving the parties notice of the expected outcome of the proceedings and of possible other legal classification, the court gives the parties an actual ability to start a polemic with the court. It allows them to undertake adequate procedural activities, for example, in the area of the evidentiary hearing. As such, it contributes to the implementation of the rule of the fair trial. It is an embodiment of certain vision of the court as an active participant of the proceedings. A participant who is not only supposed to hear the parties in silence and give verdict, but also to be involved in the open dialogue with the parties in order to give a fair judgment. Now I move to the conclusions. Firstly, the changes in terms of the organization and preparation of civil proceedings are meant to give greater competences to the presiding judge at the expense of the competences of the full bench of justices. As a one-person body, the presiding judge is responsible for the proper preparation of the proceedings and for the conduct of the preparatory meeting. Consequently, the presiding judge cooperates with the parties on an ongoing basis in terms of the case management. The full bench of justices is responsible for giving the judgment. This division resembles the distinction between the judge preparing the case and the adjudicating judges, which is common under French law. Le juge mis en cause, this is the French name of such a judge. However, the Polish legislator reduced the importance of the adjudicating panels comprising multiple judges because it implemented a rule under the Special Act of 2021 on combating the effects of COVID-19 pandemic, whereby civil cases before first instance court and second instance court are frequently decided by one person. Therefore, in practice, the presiding judge now in Poland and the court are frequently the same person. This is a significant violation of the rule of collegiality and gives rise to major concerns in case of appeals. Secondly, based on the experience gathered in terms of the functioning of the written proceedings and of the preparatory meeting, the development of a legal regulation to that effect does not suffice. It is also necessary to ensure technical effectiveness of those solutions. This refers to an effective system for the service of electronic court pleadings and an effective system of remote court hearings. Those solutions are still missing in Poland. In 2021, the legislator added a duty to the Special Anti-COVID Act whereby pleadings must be served to the professional attorneys via an online portal. However, the solution has not been well prepared and it has relied on the existing information portals of the courts that are used by the attorneys only to monitor the case progress. The portals are not an appropriate way to serve court pleadings on a large scale. Thirdly, the attempt at giving the parties the ability to influence the organization of the proceedings by giving them the right to enter into procedural agreements needs to be appreciated as heading in the right direction. Certainly, the trial plan and the evidentiary agreement are an example of such solutions. However, those attempts are too modest and apply only to selected proceedings. Giving the parties greater ability to influence the organization of the proceedings by entering into agreements could contribute to further improvements of the proceedings. Those improvements should address areas that are of key importance for the effectiveness of the proceedings, such as service of court papers or deadlines for taking procedural activities. Fourthly, the dialogue between the court and the parties is also of special importance for the organization of the proceedings. The dialogue should involve giving reliable information to the parties where possible. It should involve giving information on the possible outcome of the proceedings or on another legal ground of the verdict. Such dialogue requires constant activity of the part of the court and being up to the date of the case status. Court proceedings in which the court relies on the mistakes or lapses of the party are certainly organized in the wrong way. The procedure should be transparent to both parties. It does not mean, however, that the court can replace attorneys. And the last conclusion, fifth, there are still visible differences between the organization of proceedings involving professional representatives and those without the presence of professional representatives. Where the parties are represented by an attorney, the court's role is more limited because of the party's attorney assumes certain functions. Where the parties are not represented by an attorney, the court must be more active. Also, procedural agreements are more frequently concluded when parties are represented by professional representatives. This points to the need to consider the implementation of a legal obligation to use a lawyer, at least partly, in the Polish civil procedure. Parties should be allowed to represent themselves without a lawyer only in minor and simpler cases. With the presence of professional attorneys, the court could assign them more tasks relating to the preparation and the organization of the proceedings. Thank you very much for your attendance.
Rygoryzm czasowy.
We're going to keep the time rigor, time restriction, and now we're going to have a short presentation. And I've been informed that we can ask a few questions to the speakers. We're going to have questions to the people from the room, to the people in the room. Would anybody have any questions to the presentation by Professor Rimsky? Ladies and gentlemen, we kindly encourage you to ask questions.
Do you have any questions? Or statements? Okay.
Thank you. Just this concept of judge revealing the possible outcome of the case exists in many in procedural theory for ages, but in practical sense, how are the judges faced by the request for recusal because from one of the parties, because what he or she says about the possible outcome doesn't fit the expectations? In Croatia, that is the case, so the judges are reluctant to reveal their opinions because not to face this request and then to answer to that and all this.
Professor Van Rel?
Yeah, it's for me, I think. Yes, Polish legislator foreseed such problems and regulated in the Polish code that it's impossible to recuse the judge from this point. It means if the judge used this regulation, you cannot put a motion for recusal of the judge. But in practice, I think that this regulation is not very popular. Because it's dangerous regulation, okay? Because you need to present your opinion before the decision. So I think this is the only regulation for specific cases where we've got maybe a party without the legal representation, or or such a cases where the judge foresee that maybe the party does not know in which direction this case is going. And sometimes it's necessary to act, but in practice it's not used very frequently, I think.
You want to ask? Okay, and Professor Renko van Rij.
It's interesting. This is a very this is based on legal culture. What happens? You say, well, in Croatia they will recuse the judge if he or she doesn't. They will ask for that. Whereas in the Netherlands, judges also do this. They indicate to the parties their ideas, and then a judge may say, well, gentlemen or ladies, could you maybe you need some time outside my hearing room. And that happens very often, and it very often results in settlements. And the whole issue of recusal doesn't pop up at all. It's not part of the discussion. Recusal is very, very rare. And the question, of course, is why is this? Well, the first answer is, of course, maybe a different legal culture. Maybe a relationship between the lawyer and the judge. Lawyers don't want to appear before the court as a vexatious litigant, how do you say that? Representatives. I don't know, but it is interesting. I know, for example, in Croatia or in Ukraine. Well, at the moment I don't know because of all the problems, of course. But before the Russian aggression, recusal happened all the time. And there were also ethical issues being raised all the time. Why is that? I think in Ukraine the reason was that it was actually admitted rather easily, and it was a good way to make judges insecure, because the procedure would take a long time. Especially if there would be an ethical issue being raised. You had to go to Kiev, and then for a year you would be under a cloud. And none of these, or not many of them, were successful, but the actual fact that this possibility existed already made judges a bit worrisome. Well, that's at least what they told us. Again, a different procedural culture maybe.
And Judge José Igreja Matos.
So no statements, quick questions to Professor Remko. Limited numbers for streaming, using the analogy with physical spaces that are also limited. Very, very, very nice, very, very good idea. Criteria. Second question, equality of harms for hybrid trials. Again, very important principle, equality of harms. How do you manage to have hybrid trials respecting equality of harms? Or it's impossible? Thank you.
The latter question is I think, easier to answer. I think I stated that hybrid trials would be problematic. As has been indicated by Krans and Nielund in that book, there may be issues. A party joining online makes a different impression, may also not be as convincing as a party that is in the courtroom with his or her lawyer. So I would say you have to be very careful with that. If one party joins online, I would like the rule that the other party also has to join online. If one of them is in the courtroom, the other also needs to be there, because in that way I think a certain equality of arms can be guaranteed. Hybridity is, I would submit, very problematic. And it is exactly within that context, I think, the questions that are being asked by Nielund and Krans need to be understood. If you're talking about is a litigant with background lightning or an unstable connection, is he or she less convincing? Well, probably that's not a problem if the other one also joins online. At the same time, of course, now I already have mentioned another issue. If one of the connections is unstable and the other one not, again, the problem arises. So slowly, I start to think that online hearings are problematic in themselves. That's also maybe demonstrated by what has been happening during this conference. The technique is a bit problematic every now and then, and we can't help that. We want that very much, but it cannot be stopped. The other issue, the criteria. Yeah, there are no criteria now for joining physically. If you knock on the door, the court has to allow you in. Sorry?
First to arrive.
Yeah. Yeah, maybe that then should be the approach. Maybe indeed it's very difficult to formulate criteria. First come, first serve. But you don't have to have the whole country join by way of streaming. Also for the reasons that were mentioned this morning. It's very different. A courtroom setting with a limited number of participants is very different from being on television, like in the US, court television. I wouldn't like to promote that. So probably not. Well, you raised indeed very important points, and I think we agree.
Proszę uprzejmie.
Chciałbym zabrać głos w tych dwóch kwestiach, które tu przed chwilą były
I would
poruszone.
like to mention the two matters that were discussed here, but I would like to speak as a practitioner, because generally this second matter, hybrid procedures, is really, I think it's really awfully dangerous. I agree with Professor Remko that in practice, whereas in practice, in my court, Court of Appeal in Wrocław, where I work, there are various beliefs, approaches. Some judges allow for hybrid procedures. I oppose to that, because due to the fact that there may be a situation that somebody may accuse them of being in a better situation, even though they themselves might ask for hybrid connection. I don't agree for that. Either we have a traditional procedure or we have a remote one. And here, I think it's also a matter of our regulations, which straightforward do not regulate this matter. These COVID regulations, referring to the first matter, which also I believe we should not jump so easily over this problem. And it seems to me that we should, this preliminary judgment, devote more time to it, because it seems it's an element of reliable procedure. And as part of the trainings, I advise lawyers when I'm in trainings with them, working with them. I encourage them to force the judge to preliminarily assess the case. Judges are not really willing to do that. Forcing the judge, I mean, it's the right of the judge. If the judge refuses to do preliminary judgment, it's also information for the parties that the judge doesn't want to do it. But frequently this judge will perform this preliminary judgment, and this judgment may be frequently a part of a reliable process in order not to surprise the parties with anything. This we learn. I keep learning on my own in the second instance how to do it. And I'm really surprised with first instance judges that they don't do it nearly at all. Of course. In the backstage today, we were talking with Professor Christian Markiewicz. He mentioned that he believes that, for example, this institution should be constructed in such a way so that not the judge which decides, which gives the ruling. I don't know if it's that the way it should be, but I think we should aim at that as an element of a reliable process. And we should also, lawyers, this should go, there are two sides of this coin. Each of the proxies wants to get this, sometimes one of the proxies wants to get this preliminary judgment. We have now the franc currency cases frequent. There should be also, there's a very often situation that the judge should perform the preliminary assessment of the case. I don't know whether it should be done in the second instance. So judges, I mean, the courts don't, the procedure doesn't regulate that. And I believe that in some cases it may be done also in the second instance. And first instance should be practically a standard, of course, if the judge can do that. And we should aim at that. It's a new institution, of course, which is only 3 years old in our case now. So that's all. And I think I would like to underline that above all, this refers to the reliability, the reliability of the process. That's the point. And that I would like to draw attention to. Thank you very much.
Jeśli mogę, ja może...
If I may, as the moderator, I would like to give the voice to Professor Rylski. So I would like to refer to this issue of this preliminary judgment of the case. The issue is about the regulation, which at present means that the presiding judge does it, not even the court. So not the one who later adjudicates. So this is the first issue. And now I am moving apart from this COVID regulations, that now the presiding judge is the same person as the court. But when it comes to the construction, there is something wrong. That this is the preliminary qualification of the case, or the qualification which will be used in this substantive adjudication. So this is the presiding judge does it, and this is the first problem. And the second one is that the parts of the attorneys applies for this preliminary judgment to facilitate their work. And I understand the judges who refuse this, because this should be the judge's decision if he believes that in such circumstances this is necessary and proper. And if there is something in this case which justifies giving this preliminary judgment. And this is the second issue. And the judge gave examples of cases regarding this mortgage in foreign currencies or denominated in foreign currencies. And here the problem is that this preliminary judgment is difficult, because here we even don't have a uniform judgment viewpoint of the Supreme Court. So we would like to get this judgment from the court of the first instance. So this is of course dangerous, but that's why we have the second provision. So if the court is convinced that the party bases its claim on the legal grounds, and the judge sees that this grounds is wrong, and that the judge will have to apply another grounds, so there is no optionality, but then the court has the obligation to draw attention to this. So I understand that these instruments are connected. So the preliminary judgment is just an optional institution, only I would say in exceptional cases. cases. And this, of course, imposes a lot of obligations on the judge, and he has to know everything from the very beginning of the case, and he has to know what he will do with the case, and this is very difficult, what you can, based on the viewpoints of the claims of the parties. So now I would like to talk about it. When it comes to Article 156, here, this all should start much earlier. So during the stage of demand, of formulation of the claim, if we have the main claim, if we have alternative claims, how the claims are formulated, the demands in the claim. And then we have the second institution, which is not used at all, but is useful for this. Then we have the preliminary hearing in cases which are doubtful, because here we are not talking about determining invalidity as one of the demands, for example, but Piotr here, he mentioned the frank settlements, because these settlements, these demands can be formulated in any different ways. Now people waive the settlements, but the first claim which appears is the claim for annulment, and more often without alternative demands, because the alternative demands and cascade demands, alternative demands, these were the claims that were popular 2 years ago. I call them cascade demands because then it was just not one demand, but there were at least 5 of them formulated in different way. And when we determine our claims at the demands at the beginning, and when we hold this preliminary hearing, then this 156, Article 156, this is the absolute discretion of the judge. And that the court is willing to show this designed solution, that he will say which evidence he will admit and which not. It can be in some sense schematic. But if the obligation of the court, and it is like this, is the obligation to decide about the legal basis on the basis of the factual states, and this factual states is not changed, and the court decides to indicate another legal grounds, then even before this provision 156, Index 2 was the judgment of the Supreme Court, the Judge Kozłowska, I think, and it was together with Professor Łętowska, as I remember well, which adjudicated in this issue that this is not the right of the court, but this is the obligation of the court just to adjudicate on the other legal grounds, and that the court will decide on another legal grounds rather than the one indicated by the party. It only firstly referred to the court of the second instance, but later it was extended to also the first and the second instance. So my conclusion when it comes to this response is that we cannot look at specific provisions, unfortunately, as our legislator looks like. So not, moving totally away from this procedure, but we have to look at the regulations in the course of the proceedings, in the whole of its construction, and we cannot at random treat some institutions. And as I remember, now Judge Żółtak and then Professor Oles would like to ask a question. Maybe I would like to shortly refer to what was said here. Mainly, I would like to say that I use this institution very rarely. Only in such situation when during examining all the evidence, I reach a final point if there is the need of taking evidence from the expert witness and generating additional costs of the procedure. Then I sometimes tell the parties about the possibility of probable solution, but these are just exceptional cases. I avoid this solution when it comes to the cases involving frank cases, as it was said by professors, that all these cases, that each case is different, simply, and that you should take into account that these claims are differently formulated. And I would like to say that this provision is relatively new, and you should carefully use it, not to endanger oneself to being found as impartial. So That's why I believe that such solution, this is new, but it should be used cautiously and only in very special cases, in my opinion. Thank you very much.
Bardzo proszę pana profesora Olasia.
Thank you. Now, Professor Olaś, please your question.
Thank you very much.
Dziękuję bardzo. W zasadzie mam dwa komentarze.
Based on what I've heard, having heard these two brilliant presentations by Professor Remco van Ree and Professor Rylski, my first impression is that actually when we look at the provisions and this short description of general procedural models, we could say that actually Polish CPC is almost there. I mean that what was described by Professor Rylski in general, in terms of a general procedural model, is not that far away from what is described and set forth in the model European law of civil procedure. We have a careful mixture between written and oral principle. We have the principle of the loyal cooperation between the court and the parties. At least we can interpret this principle from the provisions described by the professor. Moreover, we also have a very strong focus on the case management by the judge. So it looks like that actually the Polish Code of Civil Procedure as modified in 2019, has preceded many things that are described in model European rules of civil procedure as of 2020. But here comes the reality, and the reality that is the law in action, not the law in book, is quite different. What are my observations in this respect? First of all, what is still a dominant thing is a cold bench. Cold bench that is passive judge, who's not actively case managing a case before it. And the second element are extremely adversarial parties who are unwilling to cooperate with court and in any event unwilling to cooperate with themselves. So I think that it's to a large extent a matter of the legal culture, legal tradition, approach, a lot of problems with the way the also legal counsels, the lawyers behave, but also I think that this traditional approach to the role of passive judge who, to retain his independence, must be neutral, that means passive, is still prevailing. I don't mean to say that there are no judges who behave in a proactive way, who actively manage cases, but as an attorney at law, my impression is that still this traditional approach of a passive judge who's unwilling to engage, who's unwilling to engage in a dialogue with parties is a prevailing mechanism. And as I said, of course, this is connected also with a traditional approach of lawyers to their role. They try to win the battle, and to win that battle, they are extremely adversarial. So one thing are rules in book, and what I observe as an active lawyer, the reality in court is completely different thing. Thank you very much.
Szanowni Państwo, zamykam pytania.
I'm closing the question session, and I am handing over the voice to Professor Wojc. Dear ladies and gentlemen, I would like to thank both speakers. I would like to thank all the participants for their participation. I would like to thank organizers for moderating this, and I would like to express my sorrow that I cannot participate in the conference, that I cannot be there with you personally. Thank you very much. Goodbye. Thank you very much. And now I would like to welcome you to a short coffee break.
a short coffee break. We meet here 4:30. Okay, so 10 minutes.
Szanowni Państwo, ladies and gentlemen, dear guests, I invite to last part. I am pleased to announce two excellent international teams. First, Judge Katica Artukovic from Bosnia and Herzegovina, representative of Office for Democratic Institution of Human Rights, the open justice principle at the pandemic COVID-19, and two-person, Professor Anna Machnikowska, Faculty of Law and Administration, University of Gdańsk, Poland, of course. Ms. Judge, now it's time for your lecture.
Thank you. Dear colleagues, ladies and gentlemen, it is my honor that I have this opportunity to be here with you today and speak about this important topic, open justice principle. As you heard, my name is Katica Artukovic and I am a judge in Bosnia. And I'm a judge in Bosnia and Herzegovina, appeal court judge, second instance judge, and I will tell you more about this open justice principle in 3 stages. I will speak at the beginning about this principle in general. Then I will speak a little bit in detail about the situation in my country, in Bosnia and Herzegovina. And at the end, last but not least, I will tell you something about my personal experience about this very important principle, because of which I knew there's a catch when I was elected in the age of 36 as a second instance court or appeal court in my country. But let's start from the beginning. Before I start with the official presentation, I have to mention that this is my second time in your beautiful country. I had a great pleasure and opportunity to be in 2017, I think, in visiting study to the Supreme Court in Warsaw. And I'm very pleased to be here with you again, and I hope that there will be an opportunity to have you all in my country and be more warm welcomed as I'm felt here in your country. Let's start with the famous sentence of the Roman poet Juvenal, who will guard themselves. Open justice as a main principle is the heart of every democratic system of justice, and it is an indispensable part of the rule of law, deeply rooted in the need for accountability and transparency in the administration of justice. I'm sure many of you heard about the famous judge from England, Lord Heward, and I'm even more sure that many of you heard about his famous sentence about core of this principle. He said, "Justice should not only be done, but should manifestly and undoubtedly be seen to be done." In its essence, it guarantees that the general public and the media can monitor the hearing of cases by the courts in purpose to be able to understand and scrutinize the justice system of which the courts are the administrators. In other words, the administration of justice is accessible to the general public, so everyone who wishes it, with a few exceptions, have the opportunity to attend case hearings, and case adjudication information is made available to the public and the media. Because of the COVID-19 pandemic, legal system has been seriously affected, and in many countries, trials in open courts have been replaced with limited access hearings. The transparency of the legal process, as a consequence, came in great danger, because the operation of the legal system became significantly less visible and crucial aspects of fair trial are affected. The coronavirus severely impeded the operation of an open and accessible court proceedings, and they are conducted in open courts, and the courts around the globe are still significantly affected by the pandemic. Backlogs have ensued due to the limited scope of organized hearings. As you are all familiar, many restrictions continue to apply, and such measures may endanger the rule of law and the principle of open justice, because the open justice principle is strongly connected and dependent on what happens in each and every courtroom. The fight against the COVID-19 pandemic has led many countries to resort to emergency powers, with enormous challenges to the functioning of the court system, and the right to a fair trial, which requires great democratic resilience in order to avoid that emergency powers curtail fundamental rights and conflict with the rule of law. Open justice facilitates public trust and confidence in the administration of justice and is indispensable to the maintenance of the rule of law. Its rationale can be explained in many different ways, but the core of it lies in the benefits to the proper administration of justice arising from public scrutiny of judicial proceedings. The general public and journalists often cannot attend trials and are offered only limited access. We heard our dear colleagues speak recently about this topic also. Monitors in courtrooms may offer only a restricted view to the audience sitting in the public gallery, but they may not have a clear view of the monitors, which are primarily focused on the professional participants. Measures taken in the various countries are very similar. So we have adjournment of trials, introduction of video conferencing, court closures or limits on the number of members of the public and journalists able to access hearings and trials, working from home, and hearings organized outside the court buildings, etc. Courts are unique institutions that exercise judicial power in accordance with the rule of law. So even in a pandemic, courts need to function in a manner consistent with their institutional role and their essential characteristics. If the way that courts behave cannot be hidden from the public, this provides a safeguard against judicial arbitrariness and maintain the public confidence in the administration of justice. I'm sure that all of you are familiar with the main documents in this regard, and this open justice principle is promoted in, for example, Universal Declaration of Human Rights, in International Covenant on Civil and Political Rights, and of course, European Convention on Human Rights and Basic Freedoms. The core is about determination of the right that every has the right of the determination of his civil rights and obligation or of any criminal charge against him, and to be entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. That is the essence. Independent court and public hearing. However, health and safety measures put in place to respond to the COVID-19 pandemic, such as physical distancing and restriction on maximum occupancy in court facilities, have created a unique challenge for courts in providing safe and open access. Access to observe and report on a public court hearing should not be limited otherwise than for legally justifiable reasons, for example, to protect national security, vulnerable parties, etc. Therefore, the courts system must function regardless of any crisis. The COVID-19 pandemic and the measures taken worldwide in response to the outbreak have had significant implications for human rights. We can freely say that the emergence of COVID-19 has led to an unprecedented global crisis, and this pandemic poses unprecedented challenges for courts across the globe. As we continue to face the challenges of COVID-19, it is more important than ever to ensure open access to the legal system. So we must support every effort in finding innovative, pragmatic, and effective strategies to make our legal system more transparent, accessible, and fair to all. It is undeniable that when it comes to the procedural rights, the right of access to a court and a public hearing could be violated in the current situation where most judicial bodies in the world seem to face difficulties and may have to restrict public access in the foreseeable future. Closure of courts increases the risk of restriction of rights such as the right to a fair and public hearing, but the danger could be greatly mitigated by the creative application of simple and accessible technology. The effectiveness of all remedies for human rights violations face serious challenges in the current legal environment. So, in the face of the COVID-19 pandemic, judiciaries across the world are forced to rapidly adjust their daily operations. Many courts were forced to move quickly as possible into the digital sphere. In that regard, remote hearings, we talked about it earlier, seems to be a vital tool, so it should be checked, both legal requirements and technical options for opening a hearing to the public. Make hearing accessible to all or only to pre-registered participants or those authorized to attend through, for example, passwords, protected logins, pre-registration for the hearing, etc. Hearings could be streamed online. We also heard speaking many of you about that option too, to a wider public audience or to a smaller number of attendees who have previously registered and subscribed. It should be advised to instruct observers, including the general public and media, at the outset of the hearing that unauthorized recordings or transmission of the hearing is illegal, which is justifiable concern for all of us. Further advice on the consequence of such action. In some situations, a recorded broadcast could be made available following the live hearing on the court's website or video channels, for example, YouTube. Media representatives could help facilitate online access to a hearing. A secure link from the room in the courthouse for journalists to follow the hearing could also be considered as a solution. Now I will tell you more in detail about the situation in my country, in Bosnia and Herzegovina. In Bosnia and Herzegovina, courts and prosecutions organize their work in accordance with the recommendation of the High Judicial and Prosecutorial Council of Bosnia and Herzegovina, given in decision on the organization of work issued on 22nd March 2020 during the emerging epidemiological situation in the country caused by COVID-19, in order to protect personal health and public health and to prevent the spread of the COVID-19. Scheduled hearings were postponed, except for hearings that are required by law to be urgent and cases that are close to the end of the statute of limitation. Proceedings in cases related to crimes against human health were a priority in the prosecutions. Citizens had limited access to the court buildings. The notice of the submission of documents to the court was issued and published on the website and at the entrance to the court in order to inform the general public about the new work regime. Direct communication between court staff had been kept to a minimum. Communication was mainly by phone and email. The working hours of the court have been shortened and the possibility of working from home has been provided. The numbers of employees who are physically present in court has been reduced. Based on the delivery instructions issued, the ICT service exported the documentation and the cases were delivered to the judges electronically, taking into account the security of delivery of the document. The introduction of electronic communication with the judiciary is commendable, even in situations that are not caused by the epidemic or any other crisis, because in this way citizens have easier access to court. Courts took preventive measures, of course, like in every country. As we can see, like many other countries, Bosnia and Herzegovina decided to postpone court proceedings except in urgent cases. Unfortunately, such a solution significantly jeopardized the right of citizens to access court, given that during the pandemic there was a need to protect rights, other rights, that were not recognized as urgent. This primarily refers to the labor rights of citizens, which, due to the impact of the pandemic on the economy, directly endangered a large number of employees, but also many other rights that can be violated directly as a result of the epidemic or indirectly through the inability to protect them in the court because they were not classified as urgent. Also, in the decision of the organization of work that I mentioned earlier, hearings in minor offense cases were postponed, except in cases initiated on the basis of reported non-compliance with the decisions and orders issued by the competent authorities during the declared emergency over the COVID-19 outbreak. We also had, as of course in other countries, the duty judge assigned to minor offense cases could also decide to take action in other cases for reasons of urgency. Hearings in civil matters were postponed except in cases in which a prejudgment attachment is to be decided. Courts had to organize a duty roster of judges for criminal, civil, and minor offenses cases. Prosecutor's office had to organize a duty roster also of the required number of prosecutors to handle the urgent cases. Only those judges and prosecutors who were on duty on a particular day in accordance with the duty roster were able to come to the court or prosecutor's office on that day. Duty judges assigned to civil cases could individually decide on the urgent need to handle individual cases based on the assessment of the case and its urgency. It was necessary to organize and facilitate work from home for second and third instance judges, and meetings of judge panels could be organized on an ad hoc basis at the discretion of the court president. Courts and prosecutors' offices needed to arrange a duty roster for the performance of administrative tasks. Failure to comply with this decision could give rise to disciplinary liability. Court president and chief prosecutors were required to assess the risk of human health and make ad hoc decisions that are more restrictive with regard to work process than the measures provided for in this decision that I just explained. The measures in this decision were considered to be a minimum restrictive measures, and this decision remained effective as long as the extraordinary circumstances caused by the COVID-19 in BiH persisted. Today, in Bosnia and Herzegovina, the situation is much more relaxed. Many measures are no longer in force, which is conducive to the principle of open justice, and we hope that the situation will stay that way until full normalization of process in courts and prosecutor's office, so this key principle for the fair trial could come to life in its true fullness. That would be all from my part, and as the third part that I mentioned at the beginning, I will now tell you, okay, thank you for reminding me. I will now tell you about my personal experience when I mentioned that I knew that there's a catch by being elected as a second court instance judge, appeal court judge, at the age of 36. In September of 2020, in the midst of coronavirus, 4 of the 5 of total number of judges in my court, so it is quite small court, but in one part of my country, it is the highest court, and it is one of the 3 pillars in this part of country, like in any other country, of course. So 4 of a total of 5 judges in our court, including the president of the court, were infected with coronavirus. Of course, they went on a sick leave, and gradually other employees followed them. And at the end, 3 of us in whole court were left. an office worker, my secretary, and me. It would not be so unusual if I had not been in the 6th month of pregnancy with my 4th child, and I was faced with a great dilemma of whether to go to sick leave or to stay in the court. I'm sure that no one would take as a harm that to me if I went to a sick leave, because as many of you know, that pregnant women were considered as a risk group, and they were invited actually to go to a sick leave during this pandemic. By some miracle, I was not infected, but my colleagues from all over the country heard about this case. That court was almost closed, and I will be polite and I will not mention the words that they were saying to me, but it was like, go home, take care of yourself, of your child and yourself, don't do this, etc., etc. Of course I was scared, I cannot lie. Whole world was scared and afraid because we knew nothing about this coronavirus. But after deep thinking, I thought, and it was my duty to stay in court, because otherwise the court would be left without single judge, and probably after me, and they told me so, the other 2 employees would also go to a sick leave. They said, if I will stay, they will stay. So we made an agreement, and I stayed for a whole month as an only judge in the court in this state of pregnancy, and I was acting as a deputy of the president, because she gave me by an email authority to be her deputy of her in her absence. It was extraordinary experience for me, but it showed me that the best leadership is the one when you are leading by your own example. It is very nice to speak about this principle, and we heard a lot of good sentences, good thoughts from the very beginning of the day, and I'm sure we will hear them even tomorrow. But in my opinion, the action we take, that is what it counts. And you have to act in the situation which life brings to you. Not before, speak about it, not after, act like a general after the battle. I'm sure you know about that expression. But in that same exact moment that life brings to you, it is never easy, but it is very worthy. At the end, I of course remain available for every question that you may have, and I'm deeply thankful and grateful, I must say this, for this opportunity. So I thank the organizers for the invitation and the OSCE Office for Democratic Institution and Human Rights for having me. Thank you.
Ms. Judge, thank you for your inspirational speech. You are a very brave judge and woman. And now it's time for another speaker, Ms. Professor Anna Machnikowska.
Szanowni Państwo,
Gentlemen, above all, thank you very much to the organizers for the possibility to participate in this discussion, for the possibility to listen to so many remarkable speakers, their experiences, their theories. And relating to what has already been said, I would like to present to you a few conclusions and postulates referring to the principle of the open system of justice, and I would like to use three examples. They draft the nature of the events we participate in, and I believe also maybe forecast what is ahead of us, at least in one of the variants. So actually the opportunity we presented to politicians, economists and IT specialists has accelerated the process of transformations. As for some elements of the system of justice, not beneficially has changed the division of roles, including the role of lawyers in the system of legal of the justice system, and has extended, at least in some countries, a specific possibility for uncontrolled connecting of elements of modernization and also using the parable which opened our today's conference. I could actually briefly speak about what I want to say in the following words. It is a history about a risky legal precedents, about political and economical temptation, and resulting from that responsibilities, including the responsibility of lawyers for ensuring that justice is neutral in times when more and more frequently we shall mention justice, digitalized justice, digital justice. It should just remain justice. The first statement of my speech is that the system of justice in Poland has not received during the COVID pandemic, has not maintained in the COVID pandemic a constitutional statutory standard of functionality, despite the fact that there were resources and mechanisms to achieve that target. It was, of course, not indifferent for the principle of open justice. In the supplementation, we have to state that the same events also occurred in some other countries, both countries with stable parliament democracy and those where governments believe in non-liberal democracy. It's one of the examples of a global problem of poor positioning of the justice system in the structures of public institutions. At the same time, it's a paradox, because more and more more and more frequently we are dealing with legal, economic relationships, social relationships which are juridized, and therefore the role of judges should increase. The third extended conclusion is as follows. In Poland, the principle of open justice has in parallel been deprived of several elements, and new content has been introduced there. The element which receives special interest is the public presentation of these changes. It exposes new technologies. They are commonly associated with open access to information, with egalitarianism. Their symbol has become a remote trial. However, the performed modification is not only based on positive progression. Proof that it's otherwise is the content of the new forms, new regulations, and their official justifications. The subject of this proof of non-obvious treatment of the open legal system principle are two examples. The first one is the location where we've got the guarantees for the openness of the principle. And the second example refers to the guarantee of parties which are present without a professional proxy, and which the system allows for receiving. Referring to the first example of running a remote trial, it serves for improving the unity, because it helps a person who lives in a small town or who is sick to also participate in a court proceeding. In Poland, however, we were dealing with an interesting case. Namely, while establishing the standards which introduced remote trials, at the same time there was a possibility for limiting clarity, limiting its availability, limiting its, I would say, transparency, openness, even stronger than before the pandemic. And these standards ignored, at the same time, the standards ignored two facts. First of all, lack of access for 1/4 of people. These are in Poland, these are the current research results. Access to a kind of system which would at all allow for remote communication, and also a lack of at all public common certified by the state, having appropriate functionalities for handling trials, a system. And what did that result from? This resulted from 3 types of decisions which were made by the legislator. From legislative negligence, from faulty legislation defined by some as nihilism, and also legislative activity with a doctrinal component. As for the let's say omission, we had many examples. I mean, negligence, we had many examples. These are situations where, despite strong conditions, the functioning of the justice system was stopped. At the same time, for a longer time, there was no preparation of appropriate legal standards, which resulted in the fact that many matters for the first months were solved individually, in dispersion, without stability, which introduced differentiation of standards of protection of laws, rights. We were dealing with administrative bans, frequently undertaken in good faith, referring to the access to court, access to the proceedings, access to act. We can mention a lot of other matters. And if we're speaking about defective legislation, I don't want to develop this topic too strongly. Ms. Judge mentioned this. We were dealing with certain instruments which officially reacted to changes, but did it in a way that judges or proxies of parties, or even the parties themselves, were frequently not able to implement what was present in these standards. The most interesting, I believe, example is this 3rd form of activity of the legislator, the form which is based on the fact that we use this situation of emergency situation opportunity to develop certain standards which are supposed to ensure to us not only solving the current problem, but also introduce to the system solutions and adapt the community to solutions which implement certain long-term policy. And such an example is, for example, giving a guarantee for the transparency principle. What happened in Poland? In the beginning, of course, in a delayed way, there was a solution introduced which was like this. Here we have a remote trial. Earlier in Poland, it was not an established institution. We've got a remote trial which we conduct when there is excessive danger for life and health. Therefore, we open the justice system. At the same time, however, it was said that we open new possibilities for conducting non-transparent, non-open proceedings when 4 conditions are met. First of all, we are dealing with certain objective obstacles. We cannot organize an on-site meeting due to health reasons. We cannot organize a remote meeting. It was not specified why. Thirdly, the protection of citizen laws exists because the parties can object to such an organization of the non-open meeting. And also the 4th condition, the judge finds that there is urgent necessity for conducting a trial. Please remember that this urgent necessity has to be also confirmed by the party which does not object to that. Some time had passes, and it seems that in this moment we have gained new abilities, we have strengthened the system, we are no longer surprised now. And, ladies and gentlemen, after over a year of functioning of the pandemic, the legislation is changed. in a very specific way. First of all, they are changed in such a way that by editing they are dispersed, become complicated, prone to numerous interpretations. And secondly, the meeting which is non-open changes its status. How? There is no longer 4 conditions to conduct a non-open proceeding. It's mentioned that it's not possible to conduct a remote meeting. Still, we don't have the standard for impossibility defined. The party is deprived of the right to express consent or objection against such a solution. And third thing, which is most interesting, one of the necessities exchanges with the other. So instead of the necessity to urgently recognize a case, there is the premises of the assessment on the side of the judge, whether at all an open proceeding is necessary. There are 2 separate necessities. And if we look at it from the side of theory, we could say that, well, this new authority has been entrusted to a judge who is happy with independence guarantees. Let's trust this judge. But if we combine this with new technologies, such as lottery selection of the judge, in the situation we don't know the algorithm based on what this mechanism is working, and we know that manual controlling is possible there, and we don't know what are the principles, I can obtain access to this system, which will help me to conduct a remote proceedings, and my colleague in a similar case suddenly finds technical difficulties. Yes, then there is a problem ahead of us, of a threat with this situation. The next problem which occurs, is the fact that a lack of common access to the system, lack of different kinds of support, which was proposed earlier, before the pandemic, has revealed itself most difficultly to the weakest group, to the group which has no professional proxy, the group which is frequently this sovereign entity, which so frequently some of the government is referring to, the people. What happened there during COVID? During the COVID pandemic, there was a withdrawal from the legislative obligation to standardize instructions for people who do not have a professional proxy. And they were supposed to not only get a standardized instruction, because they do not receive it today, we know the problems arising from that today, but also they resigned from providing these instructions through teleinformatics systems with an educational value. And parallelly, more and more frequently, the process law is difficult, which caused an increased level of risk for this group. By instruction, I mean caution, reproval, and the reaction of the legislator to the state of epidemic took the form of limiting rights, which have no axiological nor systematic justification. This infringement of principles does not result only from this negligence, from the defectiveness of certain solutions, but also from the introducing of controversial concept of promoting speed, whereas speed is understood as the only designate of efficiency. And this concept is not good because it comes on the positive response of the recipients. Why? Because more and more of us function in the culture of speed at the expense of other values, other goods. So therefore, having the above in mind, I would like to formulate 3 postulates. First of all, I hope I'm also relating to the words which have been mentioned here today. It is urgent and necessary to develop a normative standard of procedural guarantees for solutions that, using new technologies, including ICT systems, are directly or indirectly related to ensuring full participation of parties in court proceedings. This normative standard may be based on, I would say, a Polish constitutional standard, Article 31, paragraph 3, which says briefly that all the limitations cannot be cannot be infringed the nature of laws. This may be very safe before as a security against infringement from the side of the authorities. Infringement from the side of authorities, not only from the side of the owners of ICT systems, but also infringements of abuse of political power, because politicians have a very specific position today. On one hand, politicians don't have the appropriate knowledge so that they could impose certain obligations to providers of algorithms or providers of ICT solutions. Sorry. Knowing they don't have knowledge, they know that the majority of citizens also don't know how new technologies function. Therefore, authorities may try to connect various kinds of new technologies with this system of expecting that some of the citizens of this non-authorized connection won't notice. If we're speaking about the second postulate, if we want this normative system to work, we have to strongly introduce lawyers here, so that they have a leading role here, and so that they would decide about the priorities. Today, other entities are creating the systems, therefore they implement their interests. A lack of taking into consideration of this matter earlier has created a dangerous precedent, because specific situations will repeat. The justice system has to be more active here. And the last postulate, with which I will end, if we want to create a safety standard, if we want in the future, nearest future, so that the legal lawyers would be the ones who perhaps not only regain their place in the legal system, which at least the laws would not be that strong, we have to appropriately prepare ourselves to that. We have to, on our own, gain certain knowledge, which is possible to be obtained. How the system works, what are its possibilities, what are the risks. And I don't only mean technical matters. Ladies and gentlemen, here this was also mentioned, but each of you has specific experience. These new technologies, remote hearings, etc., change our way of functioning. So here we've got really a big potential from our experiences. We know that the parties which provide their statements in friendly solutions, they believe that the distance between them and the court gets shorter. It's possible to collaborate. We should use this potential. But we should prepare ourselves to this in a different way, also by changing the programs of university studies. Thank you very much.
Thank you very much for this excellent presentation, which was really moving and really conclusive. Now I would like to welcome our last two participants.
Last speakers, Mr. Professor Judge Christian Markiewicz and Dr. Dragos Celin. The subject of the last panel is the right to a competent court, composition of courts in civil case, principle of stability of panel during COVID-19 pandemic. Mr. Please, you are.
Thank you. First of all, I would like to thank you for the invitation. In the context of the extremely rapid spread of coronavirus infection, national public authorities have been forced to take precautionary measures, some of which also concern the works of the courts. And this was also the case in Romanian courtrooms, where more than 100 people can enter at the same time and are able to remain indoors for hours. Chiefs and registries or court halls, mostly inadequate, but filled daily with hundreds of litigants, lawyers, clerks, and other staff. Article 42 of the decree number 195 on 2020 regulated in 8 paragraphs the entire judicial activity from March 16 to May 15, 2020. The activity of the Romanian courts continued in the cases of special urgency. In these cases, if possible, the courts have taken the necessary measures for conducting the court hearings by video conferences and proceed to the communication of the procedural documents by fax, email, or other means. The list of the cases defined as special urgency was established by the relevant bodies, the High Court of Cassation and Justice and the Courts of Appeals, and the Superior Council of Magistracy by decision 415 on March 2020 has indicated the causes for which the judgment is not suspended, among which are measures regarding the protection of minors, the indictment or forced execution, precautionary measures, request to suspend the enforcement of the judgment, and any other request that concern exceptional situation that can be considered of especially urgency. For the rest of the cases, the judgment, the cases were suspended. The enforcement activity continued only in cases where it was possible to comply with the health rules set out in this decree. The Romanian Judges Forum Association asked the Romanian Superior Council of Magistracy and the Ministry of Justice and all the courts to implement extensive and fast digitalization of the Romanian courts. And the Timișoara Court of Appeal and the High Court of Cassation and Justice, the Bucharest Tribunal, used this WhatsApp and Zoom communication, and the High Court of Cassation used a new system implemented by IT specialists from the Supreme Court, using the structure of the secret service, the special telecommunication service in Romania, and the Ministry of Justice by the implementation of the electronic files application, the online access to file document, reducing time and cost for the parties. Also, the service of electronic communication of procedural documents, secure document transmission, has been launched, which allow parties to opt to make communication in digital format, and the video conferencing system was used both for holding court hearings in civil and criminal cases. But there was a lack of regulation regarding the video conferences, and there are still pending cases in which the parties attacked the judgment pronounced in the cases using the video conferences, and the High Court of Cassation and Justice will pronounce a judgment in this kind of cases. This limitation imposed have led to negative consequences for the work of the courts in terms of efficiency criteria, increasing the length of non-urgent cases by suspending them during the state of emergency, and increasing the number of the cases at the court level, including those longer than 1 year, increasing the volume of activity while it was necessary to reinstate the cases suspended during the state of emergency, combined with granting of the time limits in the cases where the preliminary procedure was completely, increasing the time of court's hearings by scheduling cases by time and by type of object, decoupling activities by setting up an exchange work program to enable social distancing in the workplaces, increasing the workload of clerks by increasing the share of electronic communication of documents and procedures, hampering partially suspending the performance of the activity due to the quarantine isolation of staffs. The direct consequence of these measures imposed was to affect the efficiency indicators of the courts as a whole, but also by section and individual judges. In civil cases, courts panels have remained unchanged as a rule regarding the composition. However, due to the individual cases of COVID-19, approximately 35% of Romanian judges, and only one judge died, Permanently, the planning was often resort to. Judges in medical isolation have been replaced for short periods. There have been delays in resolving some cases and some postponement justified by the need to maintain the full composition of the court in complex civil cases. And in criminal cases, after the cases Beraro and Cutean against Romania by the Human Rights Court of Strasbourg. However, the rule was to judge the files even by the panels constituted with judges from the permanent planning. But after the returning from medical confinement, the judges returned to the composition of the panels. They were part of the management boards of the High Court of Cassation and Justice and the Court of Appeals handled this situation. But unfortunately, due to the lack of the legislative framework in Romania, it was not possible to compile the court panel online with the judges in confinement at home and other judges in the courtroom, like in Italy. For example, it was not possible in this way to pronounce the court verdicts online. But between January 1st, 2020 and December 31, 2020, a total activity volume of 2,700,000 files was recorded at the national level, and 1,800,000 cases were resolved in 2020, and this representing 68%. Given the huge effort of Romanian judges, the level of stocks in 2020 increased insignificantly compared to 2019, with only 459 files. Both the independence of the judiciary and free access to justice are dependent on the human, material, technical, and financial resources allocated to the activities carried out to achieve these goals. Data and realities confirm numerous shortcomings, but also action that were taken to address them during the pandemic period. Generally speaking, the trend towards digitalization of justice has been driven during this period by the need to prevent and combat the epidemiological effects of the pandemic. This secure document transmission and the video conference system has been used for hearings in the civil and criminal cases, but there are in Romania judges which refuse to use the video conferencing system. There are in Romania lawyers and parties which refuse to use this video conferencing system. There are in Romania lawyers which refuse to replace the oral hearings with written hearings, like in European Court of Justice in 2020, for example. Judicial culture, mentality, conservatism, I don't know the right answer. Thank you.
Thank you, Mr. Doctor, for your report from Romania, and now Mr. Professor Judge, famous person, Christian Markiewicz from Silesia University.
Dziękuję, panie profesorze.
Thank you very much, Professor. The last 45 minutes belongs to me. The organizers are making suicide now, committing suicide now. This joking, of course. How much time have I got? 10 minutes? For you, Professor, always there is too little time for your fantastic work. Please maintain judicial disciplines of 45 minutes. Ladies and gentlemen, the principle of stability of the composition of the court and the collegiality. By my reflections, general reflections, will be drafted, will be briefly presented in 2-3 sentences. I'm really happy that Professor Jakubecki said what I wanted to say as for the changes introduced in the last years by COVID acts. And let's start from the fact that the appropriate composition is a value which is protected by the Constitution. And it's a value which is protected by Article 6 of the European Convention on Human Rights, where there is mention of considering a case by the court. It's established by an act and by European law also, which is regulated inter alia by Article 2 and Article 19 of the Treaty of the EU. What is interesting, it has been very strongly underlined in a Polish case, which referred to judges delegated by the Minister of Justice. In Poland is at the same time the General Prosecutor. And no, I cannot hear the speaker. The translator cannot hear the speaker. No. Please report to the speaker that he has not heard. Please kindly, thank you. And now they found that such regulations cannot hear the speaker. Sorry, could you please kindly stop the speaker for a moment, and I'll tell him that he's not heard. Sir, could you please kindly tell the speaker that he is not heard, because I cannot hear the speaker. Sir, Mr. Dragos, could you please kindly indicate? No. Thank you. We're just waiting for the microphone. Oh, now it's okay. Now we can hear you, sir. Now is it better now? Oh, perfect now. Thank you. It's perfect. So as for the comparative context, there is a principle of invariability of the composition. However, it's not absolute, but it's a major standard in the EU. It's desired as for repeal instances and the highest courts. As was mentioned by Professor Jakubecki, in the Polish process law, in the first instance we had one-person composition with some concession for collegial compositions or jury compositions or professional compositions, but there was a principle that the judges repeal courts ruled in the professional collegial composition. I won't enter the details, there's no time for that, what derogations from that were foreseen. As for the decisions, less important. Anyway, non-substantive. Polish process law and systemic law, constitutional law, in scope of civil cases, for a long time did not foresee the principle of invariability of the composition, but in a certain moment it was introduced. 2015, we've got a fundamental change, political changes in our country, and 2 years later, in 2017, there was an increase, and in these matters of transparency were very hot topics, whether it was introduced, we'll see. There was random assigning of cases and invariability of composition of the ruling court, and the principle regarding the random assignment of cases. It was mentioned by Ms. Professor, but always handled by the Minister of Justice and General Prosecutor. Nobody actually knows what is the principle this works on, this random assignment of cases. The best proof is that an hour ago, the head administrative court found that the Minister of Justice infringes the law by not publishing the source code referring to the assignment of cases. At the same time, what has been introduced in Poland, nobody knows how these cases are assigned to judges. And at the same time, there was this principle introduced of invariability of the ruling composition of the court in civil and penal law. There were restrictive exceptions which allow for derogation from this principle. I will say immediately that, of course, this principle of invariability of composition and random assignment of cases was not introduced, especially random assignment, as for the Supreme Court and Constitution Tribunal, because there were also already there presidents which were subject to the Minister of Justice, and there was full control over that. So what happens, there's the year 2021, May, I mean the last act, COVID Act. In May, the act is passed, it enters into force in July, and in July 2021, everybody, we were all on holidays, beaches were full of people. Why? Because that was the time when all the restrictions were taken off. It was assumed that COVID has withdrawn, that there is no more COVID, no more COVID risks. We opened companies, companies were opened, streets were opened, factories were opened, and at that time, very far-reaching restrictions were introduced as for the functioning of courts. Two things were introduced. First of all, there was a liquidation of the collegiality of court compositions. Instead of three-person compositions, there was one single-person composition introduced. What is more, a regulation was introduced that where there was already a three-person composition, in the moment of entry into force of the act, and the act entered into force immediately, 14 days from the moment of being passed, there is a change from 3 people to 1 person. What is more, there was an introduction of a regulation that this principle is binding not only in the time of the pandemic, but it is binding also, it is binding, you bet. It is binding also a year after the finishing of the time of the pandemic risk. And actually, the justification for this act was clear. It showed that the COVID and the risk, epidemiological risk, actually is not the reason but the pretext for introducing the changes. Actually, the aim was something completely different. If somebody had any doubts about this, I'll put it this way, that in the same time, the same act remained the three-person composition in administrative proceedings. It did not eliminate three-person administrative compositions in penal compositions. I even started wondering, perhaps this is some affection of the Minister of Justice and the MPs to civilists, to civil judges. Speaking brutally, penal judges, administrative judges can die, civil judges have to live. This is what it looked like, unfortunately. So, what is interesting? This act allowed the president of a court, which in Poland is selected by the Minister of Justice, the General Prosecutor, so that he or she would decide about that in special cases the composition will be three-person. We can say that if COVID is the reason for such a situation, then I'm sure some consequences referring to the fact to maintain certain principles of safety so that they are observed. No, absolutely not. This decision of the president of the court about a three-person composition has nothing to do with COVID. So what is the aim? It turned out that there is an infringement of 2 elements. There is an infringement of the collegiality principle of the composition of the court. In this group, we don't have to convince ourselves what is the value of that. Anyway, if we forgot, Professor Jakubecki reminded us of that. Secondly, there is a matter which is very important, that not only that there was an infringement of the collegiality principle of the appeal court's collegiality, but also the principle of stability of composition, which was introduced 2 years earlier as very important. And possible movement referring to the composition of the court was associated with a decision either of the Ministry of Justice or people subject to the Minister of Justice. So there's a question whether such movements could have been made, whether this is in the competence of the EU states to introduce such regulations. Here, with the help, there is the help of the whole judicial decisions of the case law of the Court of Justice of the EU. This referred to Malta courts and judges. Can the level of legal protection be lowered? The tribunal, the Court of Justice, replies that it's impossible to, in reference to the access moment. It cannot be taken into consideration to abbreviate the holistic assessment of such a situation to lower the level of legal protection. And undoubtedly, in case of Poland, there was in 2 planes, in 2 areas, there was a lowering of the level of legal protection. and there was a collision, certain regulations, systemic, constitutional, which have been existing all the time, about the fact that only in exceptional situations there may be a change of the composition of the court. At the same time, there was also a COVID provision regulation, which episodically performed such changes. And therefore, it was, the question came by itself to the Supreme Court, since in Poland we don't have a functioning Court of Justice, constitutional court, and I did it, and as I found, the Supreme Court capitulated, refused to provide an answer based on law. I don't know why. I know that all the courts in Poland, nearly all of them, were not worried by that, and despite that, they anyway ruled upon the principles specified by, I believe, non-compliant with the Constitution and EU law episodic acts. I'm finishing. This meant that there was an infringement of the principle of court composition, and if this principle was infringed, we had the greatest process mistakes that there may be. We had invalidity of procedure. So the last sentence, or one but last perhaps, of course, I do not exclude the situation that perhaps the Court of Justice would have to face this problem after the returning of this case from the Polish Supreme Court. But I think, to sum up, of course, which was also mentioned by Ania, that now that we have COVID, but such situations, episodic or various situations, may be more, maybe many, and we have to draw conclusions from that, because unfortunately, but this case shows us, the last act, COVID Act 3.0, shows us that the pandemic, it was officially eliminated in Poland 10 days ago, more or less, right? The pandemic has ended, but the consequences of the ruining rule of law by COVID acts will remain. So thank you very much for your attention.
Dear Professor, thank you very much for this outstanding presentation. I don't know why the Supreme Court he didn't accept answering the question of Professor. You can assume, you can in some way understand the judges. Dear ladies and gentlemen, I'm sorry, but we don't have any time for discussion. I'm really sorry, and I would like to ask Professor Katarzyna Gajda-Roszczynialska and Professor Judge Krystian Markiewicz to summarize our today's meeting. Thank you very much. I hope that my microphone is working. Dear ladies and gentlemen, first of all, I would like to thank you, give my thanks. Then Professor Krystian Markiewicz will summarize the conference. So I would like to forward my thanks. First of all, I would like to thank to all our speakers, these who are present, and to the rest I will be thanking tomorrow, because tomorrow we have the second part, and it's concerned with criminal proceedings. So influence of COVID pandemic with reference to criminal procedure. So for us, this discussion will continue tomorrow. And I would like to, thank you to Vice Director for all the help, for being the patron of this conference, and all the help when it comes to this on behalf of Center that was given to us. And I would like to thank to all the honor patrons that helped us. I would like to thank to Advocate Rosati and to the city of Katowice, which is a patron of today, and which is the honorable patron, and to the city of Krakow, who will be a patron for tomorrow. And I thanked to my partners, but once again, thank you very much for behalf of Office for Democratic Institutions and Human Rights. And this is a huge honor to host you here and to be able to discuss with you. And I really hope that each of you will draw some conclusions and will benefit from this conference. And this I wish to you and to me, to all of us. Please, Professor Krystian Markiewicz, please could you summarize this conference into words, please? Dear ladies and gentlemen, I think that this COVID problem showed that we have to unify our forces, not only in Poland, but in the whole world. And I've been always wondering that we have the European Parliament and we have the European Commission, but we are still divided when it comes to lawyers. And this is high time, which shows that it's time to change it. Because if we are the ones who will take care of the rule of law and we have to take care of the rights of everybody who is alive, so we have to do it together. And we have to do as quickly as possible. So that's why I would like to say thank you to you. I would like to thank to Kasia, to Basia. I would like to say thank you to Kuba. It was a huge pleasure. Thank you very much. Dear ladies and gentlemen, we still have one point of the program, very important and I think a very pleasant one. Please, Professor Jakubecki. Professor Jakubecki, apart from the fact that he's the professor generally, but he works at the university, Maria Curie-Skłodowska University. He's the professor of our National Association of Civil Specialists, and every year this scientific society of trial civilians, we have a special procedure that every year we award the best master theses, and we do it together with the special gazette that is issued by Walter Skluwer, by a special publisher who is our media patron. And also this year there was such a competition, and we chose the winners. And here I will hand out the diplomas, and the professor will have the honor to hand over the diplomas and to congratulate the winners. And I would like to refer to Professor Markiewicz. That 45 minutes is for me, but we are working under time pressure. So please, just a moment of patience. Some young people visited us, some winners of the competition. And I would like to invite all the winners here. We will save some time. And I have the honor to inform that the jury of the competition for the best master thesis regarding the civil procedure decided to give 2 first honors and the second and the third prize. And is this order alphabetical or is it at random? This is the first one. So the first prize, the same prize, ex aequo, in the 7th competition of the Scientific Association of Civil Procedure for the best master's thesis for the proceedings in a child kidnapped from abroad is given to Klaudia Katarzyna Luta. Congratulations. And I would like to add that this work was defended in Poznań, in Adam Mickiewicz University, and this is under the supervision of Marcin Walasik. And the first prize, ex aequo, in the 7th competition for the thesis of deciding on gender, sexual gender, is to Iza Kozioł. and it was defended at Adam Mickiewicz University in Poznań, supervised by Paweł Grzegorczyk. But Inga Kozioł is absent, but the second winner promised to take and give the prize to the winner. And from Krakow, and I am the Krakow inhabitant, and I can say that this is just Poznań. And the second prize in the 7th competition for claims about obtaining information in copyright and in commercial property is to Iga Anna Makulska. And this thesis was defended in Maria Curie-Skłodowska University in Lublin. The supervisor was Jan Kielecki. And the third prize in the 7th competition for the master thesis proceedings for obtaining the ownership of property by prescription is to Joanna Wójcik. This thesis was defended in the Silesian University in Katowice under the supervision of the present here, Professor Krystian Markiewicz. Dear ladies and gentlemen, I'm really happy that the civil proceedings is chosen when it comes to master seminars, and I'm happy that the graduates in this field is huge, and I can say that it's increasing. And I always refer to an anecdote, an old anecdote. When I was a PhD of legal sciences, and Professor Zedler told me, hurry up with PhDs, because there will be nobody to write your review. And there is no longer this problem. I'm not in danger of it. I would like to say thank you to all the ladies. I would like to congratulate warmly, and I'm happy that you are here, that you found time to visit us. And we keep our fingers crossed for you. Dear ladies and gentlemen, the conference it's closed today. I would like to congratulate the winners. You are our future. Organizational matters. It's 6 o'clock. We are meeting, and we are going to the restaurant. Thank you very much.